We will May I be permitted? Oh, my lord, he's senior. He's senior, my lord.
But bring your lordship leave to move the application on urgent basis is connected with the item number 4, which is fixed by your lordships at 3 p.m. my lord. Yesterday I mentioned, well, I affirmed the application, my lord.
The transfer matter, my lord, it's appearing as item 24, that maize to fruits. My salary has been stopped, my lord. Kindly, my salary has been that is transfer from project on maize to project on fruits. My lords had heard the matter at length. My lord, now salary, although she is taking classes, doing invigilation duty as per the vice chancellor's. I've done that. My lord. It's 24 of the mentioned matters list. Kindly, my lord, before vacation, my lord, kindly, my lord. Yes, I have indicated that.
No, my lord, may I have your lordship's leave to file a memorandum appeal without the certified copy, my lord?
My lord, similar prayer, my lord.
Wait, my lord. Leave.
My lord, leave may be granted to file without certified copy.
My lord, leave, my lord, I am paying leave, your lordship's leave, my lord, without certified copy, my lord, ex parte order, my lord, we want to move, my lord, before vacation, my lord, ex parte order directing the board to, my lord, give the appointment, my lord, though he is, my lord, much below the, my lord, the marks, the cut-off.
Take the leave and then file a mentioning slip.
My lord, obliged, my
And
lord.
then explain the urgency, and when you file the mentioning slip, attach the order of the single.
My lord,
You want
obliged.
Ready to go. Yes.
I'm praying for leave for this appeal without the certified copy.
Yes,
Similar
leave-
matter, my lord, made
Leave
be
leave grant.
heard at 3 p.m. along with the
So you
similar matter.
give the number and then
My lord.
mention the matter.
My lord.
You want?
application will দেবেন application will leave দেবেন
না একটা
তাহলে ওটাই করবি
মেমো ফাইল হলে তো পুরো এফিডেভিট হয়ে ফাইল
সেটা মেমো ছেড়ে দাও
Your lordship, without certified copy.
Madam, that connected with item number 4 without the certified copy, let it tag with the
Lordship.
item number 4.
For granting you leave.
Yes.
So you take the leave and file it. But you have the responsibility to give us the numbers. And if the numbers are not available, we cannot pass a formal order on that. So if you give the numbers to us by 3 p.m. when the matters are called on, in that event, all those matters which they want to join in item number 4, they may be permitted to join.
Right.
But provided the numbers are given to us clearly, unhesitatingly, the MAT numbers, the CAN numbers, and with a slip.
Yes.
That this is akin to item number 4, which involves the same issue.
Extremely
These are the, otherwise, please do not come to, please ask your learned juniors not to tell us that these are not listed.
No.
Lordship, similar matter, lordship has item.
Similar matter, my lord.
Similar matter.
You have heard us. You have heard what we want you to do. If you can do it, you will be part of the.
Yes, sir.
My lord, may I take back the slip for more elaborately writing the urgency, that maize fruits thing.
We honestly.
We take it care of. So that my lords recollect the thing.
রাখুন।
এই এগুলো দিয়ে দেন এই কপিগুলো সার্ভিস কপি কোথায় এনেছিস ফুটবল
ওই
নোটিফিকেশন
যে ইয়ে এনেছে, সোমেশ এনেছে।
দেখ না আমাকে দুটো কপি দিতে
আরো গোটাটা।
আরে এটা নয় রিক্রুটমেন্ট
Mr. Shanal, why to be mentioned?
my lord, because of the urgency.
What is the urgency?
Urgency, I tell you, losses in the midst of the selection process. My lord, by the impugned order, the learned single judge has directed the board to change the entire application form by reopening the portal when they did not, my lord, mention that qualification in their, my lord, application form.
Mr. Shamim, you appear.
I am for the writ petitioner respondent, my lord.
We'll just see the order and come back.
Yes, sir.
You appear for?
I appear or not the applicants not in the in item number 2 with an application for leave to appeal.
Same order.
Same order.
না না আমাদের তো নেই আমাদের
দুটাতে এনেছে
জজকে দেখাবো তো
ওদের কিন্তু নম্বর
কোথাও নেই
আচ্ছা আচ্ছা ওদের ভিতরে আছে। এই
আমাদের তো নেই কেন দেখেছিস আমাদের নেই এটা তো দুটো লুজ কপি নেই
What is the NCT qualification?
my lord, right now my lord, NCT qualification B.Ed or DLED.
When you advertise, what was the qualification?
My lord, advertise B.Ed or DLED. Including the advertisement was that whosoever pursuing DLED, they can also apply. My lord, in the another appeal, that condition was questioned before your lordships in appeal, and your lordships was pleased to, my lord, cancel that condition that the persons who are not yet qualified, they cannot apply. My lord, probably that's the, my lord, outcome of this.
Shows the advertisement, shows the qualifications. And then
Exactly.
we-
My lord, বাকি করে দেখাবো।
Advertisement page number 117. Notification 19 September 2020. 29 September. All the writ petitioner have B.Ed.
এটা অদ্ভুত প্রসেস বাবা।
Yes, shows.
Now your losses kindly page, my lord, 117, right hand side at the top. Now your losses will find qualifications. My lord, A, my lord, that's then age and other formalities. My lord, B, the candidate shall possess the minimum educational and training qualification as prescribed by the National Council for Teacher Education prevailing on the date of publication of the recruitment notification. And state qualified candidates who are undergoing DLED, D.Ed special education, B.Ed training, and who have qualified in DLED, D.Ed special education, B.Ed training part examination will be given opportunity to participate. Malad, this part has been quashed by your lordships judgment. Then TET. Now, so far, Malad, B, the National Council for Teacher Education qualification, B.Ed and DLED, both are now qualified for the time being eligible to apply. Now, they applied, Malad, they had the B.Ed. The present respondent and petitioner, they are already B.Ed qualified. Malad, they had applied under this particular optional provision, DLED, which is more akin to the system, Malad, imparting education to the primary education. Because I tell you, lordships, a matter is pending before the Supreme Court, whether B.Ed can be declared eligible to teach primary schools teachers. Now they applied, since they are pursuing DLED, they apply. Now after the judgment, their application goes. Now they cannot, because they have, because of this your lordships, kindly come to page 200 of your lordships brief, running page 200.
Mr. Biswas, take your seat, please.
তোরা না এইগুলো কেটেও দিস না, দুটো করে প্যাজিনেশন থেকে এই দেখ kindly always take note of the pagination right hand side at the top. But may I place it, your lordships? 13th April 2023. Concerning cancellation of participation of DLED or B.Ed special education, B.Ed training session candidates in 2022 recruitment process. I am directed to hereby notify that by dint of the common judgment dated 11th April 2023, passed by the Honorable High Court at Calcutta in such and such matter, which quashed clause 3B of the recruitment notification dated 29th September 2022, followed by further notification dated 21st October 2022, to the extent of permitting candidates who did not have the minimum training qualification on the date of notification dated 29th September 2022 to apply, and the application candidate stands cancelled.
Mr. Sannal, please let us shorten the conversation. You came to court with the fact that they had not completed the DLED, therefore they should not be allowed to appear. So we agreed with you. Now the single bench says, no, if they only have B.Ed and B.Ed is a permissible qualification, they can appear. Show us where they said so.
The judgment says so. Order.
No, the parent notification of the school education department, the rules, what are the minimum qualifications for being eligible to participate? NCT qualification, minimum qualification by the board, by the, what is the notification?
That's your lordship, because that's your lordship's clause 3B at page 117.
That we know, that has been quashed. But what?
No, that's not quashed, your lordships. There are two parts, kindly, your lordships. Kindly come to page 117 once again.
How does the whole screening start? What is the parent qualification circular?
That's the candidate shall possess the minimum educational and training qualification as prescribed by the National Teacher Education.
Where is that as prescribed? Which part is as prescribed?
That NCT notification probably your lordships wanting for.
Whatever he has shown us, what is the parent? What is the basis for it?
That's not the part of any of the documents. Admittedly, B.Ed and DLED both are qualified. Admittedly.
Show us that.
Admittedly, that's the qualification.
Where is that NCT? What is that page 123?
123. Just a minute, my lord. That's your lordships. That's the recruitment rules. It also says, my lord, if your lordships kindly come to page 125. 6.2. 125, my lord, rule 6, sub-rule 2.
Yes.
The candidate shall possess the minimum educational qualifications specified by the National Council for Teacher Education and the notification to eligibility of candidates issued by the MHRD from time to time, read with the relaxed qualification issued by that ministry from time to time. And pass the tape.
So where is that NCT minimum qualification? Why is not annexed to this? That is the starting point.
That's the mistake. To some extent.
Internal page 5.
All right, your losses, Malad. I am thankful, Malad. Kindly come to page, Malad, 205. কোথায় নেই তো এখানে Oh, then same thing as specified by the National Council of Teacher Education. My lord is wanting the notification of the NCT.
2010 and 2011 notification. 12. At least 12.
Now your losses kindly come to Malad, page 211. This is the Malad notification of NCT, Malad, that has been quoted.
Yes.
And I tell you, lordships, your losses will not find here. There is no B.Ed mentioning. B.Ed was included by the notification of 2018. B.Ed was included. একটু আনা না কাউকে দিয়ে তো এখানে নেই B.Ed টা included নেই.
Therefore, either B.Ed or DLED.
Exactly. Now your losses they applied on DLED pursuing, which clause was set aside by your losses.
Because they are not qualified. They are not qualified.
Yeah.
That was the ground.
Yeah. Now, so
Yes.
so far I am appearing for the board. My points before your lordship is that when they applied under the notification of 29 September 2022, page 117, they had their knowledge that they are, so far B.Ed qualification is concerned, they are qualified. They had at the same time knowledge that under rule 6(2), on the day of the notification, if I do not have the qualification, I cannot apply. Knowing this, they applied for DLED, as because the board mentioned it in the notification. Now, as soon as having chosen a particular qualification in the midst of the selection process, when in a number of districts, selection process is over, though merit list has not been finalized and this is on the verge of completion, they cannot come up before the court and say, look, this has been cancelled, therefore I should be allowed go. These puts very difficult the entire selection process in a second condition. Every time someone will come, they knew about the conditions under the rules. It's not that this is unknown to them. They knew that only those qualifications on the day of advertisement they are having, those candidates are only eligible. So knowing full well that I am
Mr. Sharnal, when they came and applied for DLED, they were inspired by clause 3B of your notification.
To an extent,
They
your
gave
losses
DLED because you only said that they could, because they were intending DLED qualified candidate. You completed the results by November 22, and by December they had their certificates, you came. We went by, in our judgment, by the ordinance, by the notification rules, that you had to have the minimum eligibility qualification as on the cutoff date of the advertisement, the NCT. We gave our judgment on that basis. Therefore, we set aside 3B. Now, if they qualify on the basis of B.Ed alone as a standalone qualification, what is wrong with that?
I tell you,
And there is no conflict with our decision also.
no, that's not, I'm not saying, pointing out any confliction. But I pointed out that they have chosen these. Having chosen, in the midst of the proceedings, they cannot change.
Chosen on what basis? Because they were made to choose like that.
That's I am joining a little issue,
Yes.
They knew they are all educated candidates. Now, all that I'm trying to point out, very succinctly, as per my ability, they knew about it, that this is the law. Board committed a mistake that they do not create a right in their favor, because they knew they are B.Ed qualified. They could have applied for B.Ed qualified instead of DLED, which was not complete. And the rule says, unless a qualification is complete, you cannot apply for. This is the first thing. Second thing, immediately after the application, notification, twice, edit option was given to them, to all candidates. If you change make any change, you can change it. Twice edit option was given, but they did not apply for changing their qualification. Third, so for board is concerned, it is almost impossible to open a new portal, because portal is closed. I cannot give a portal. Now thousands of candidates will come up with B.Ed qualification now. And if I portal open, it has to be portal, everybody can change it. But then entire system of proceeding with the recruitment process becomes shaky. I can't at any point of time conclude it. So, my lord, kindly consider this, that first of all, they knew about their qualification. It's not that somebody has forced him. My lord, they were not induced by the notification simply stated. That was an option given to them. So, whichever, my lord, is a complete qualification, they could have done it. Now, the thing is that, your losses, they were not sure about their B.Ed qualification, because B.Ed qualification is at stake before the Supreme Court. Whether B.Ed candidates are still eligible or not, well, judgment is reserved by the Honorable Supreme Court. That's another aspect. So, taking that advantage, they applied for DLED. So, this is the exercise of option. Now, second, my lord, after 29 September 2022, edit option was given to them. They did not correct it, that I can shift to from DLED pursuing to B.Ed. Third, my lord, in the almost in a completed selection process, it is impossible for the board to open the portal. I have taken a specific ground to this, your lordships. Kindly consider that. Just I give your lordships. Ground number 8. May I just read out? The learned single judge has failed to consider and appreciate the direction to open portal with option to change the training qualification would make the entire ongoing selection process not only to be stalled, but also amounting to a new process in respect of the respondent writ petitioner and similarly situated candidates dehodes the recruitment notification. Now, my lord, first of all, I cannot open because portal was closed. It cannot be changed in the application. Well, they have to change their application also. But if I have to open a new portal, but apart from costing whatever your losses can ignore for the time being, now it will be open to all. Everybody can change it. Everyone can change it. Then it will never be, my lord, completed.
Yes.
These are, my lord, the grounds so far the board is concerned against the Indian.
Yes, Mr. Chaturvedi.
Lord, we are not the DLED.
Which one is your appeal?
Lord, item number 2, MAT 830 of 2023. Now, Lord, we are, Lord, the trained candidates who participated, Lord, in this selection process. Now, Lord, a participant, Lord, in a selection process, Lord, can neither choose, Lord, the other participants or the number thereof. But once, Lord, the game has started, the draw of lots is complete. The last date is over. Now, Lord, the number of, Lord, competitors cannot be increased. That would be altering the rule of the game after the game has commenced. Now, the question, Lord, is whether any equity, Lord, inures in favor of the writ petitioners or not. Lord, it's true that the recruitment notification, it provided for 2 options to them. We need to look into the background as to why they chose to compete in this selection process as DLED pursuing candidates, though they had a fairer chance of participation and selection as a B.Ed candidate, of which they have completed the course. But that is because they took a calculative chance in view of the fact that whether B.Ed would be treated as a training certificate or not for the purpose of this selection process, but the issue is pending before the Honorable Supreme Court, where the hearing is complete. I am told the judgment is reserved. Now, these writ petitioners will not, if they chose to participate in a particular category, whether today, after having suffered an order from this Honorable Court, that category of candidates do not fulfill the eligibility criteria and hence not entitled to participate, whether they can now change their option or not. But all selection process wherein applications are invited online, the data which are uploaded by a candidate are relevant to his candidature, and his eligibility is adjudged on the anvil of whatever information he uploads. The portal provided to him an opportunity to rectify it in the event he thought that whatever he has uploaded, it requires a correction. Once that date is over, possibly any and all persons who are participants in the selection process would be treated to have missed the bus if their applications so uploaded still retain some errors. This last date, this carries some sanctity, or else it would be an endless process. The selection process would never be completed. Kindly take an hypothesis that a person who belongs to a reserved category, he participates in a general category, and because my lord knows that in some cases the cutoff in reserved category is becoming more than in the general category. So he takes a calculative chance, he participates in a general category, does not get through, but finds that the cutoff in the reserved category is less, and then seeks to correct the category of participation. Will it be permitted? The answer to that possibly would be no, because he has now lost his right. He has acquiesced it. He would not be permitted to alter his category, because the data that have been uploaded are true to his knowledge. He wanted the data to be so, and he wanted his candidature to be adjusted on the anvil of such uploaded data. Now, my lord's order passed, whereby the DLAT pursuing candidates, their rights were taken away. That declared them to be ineligible. Now, these candidates, if in their perception, feel or have felt that their rights of participation in this selection process has been taken away by dint of an order passed by lordship, the remedy lay before this honorable court, in division bench, to seek a modification of the order, citing maybe the self-same grounds or such other grounds which may be available. But these candidates who have been declared to be ineligible by a division bench, cannot be given another window by a single bench, and thereby declaring ineligible candidates declared by this division bench to be eligible. That, in my view, is not permissible, for the single bench, to do so. I would be relying, on a decision. This is 2020 SCC online, Allahabad, page 848, where identical issue cropped up. As principles of remedial resort in legal matters. More particularly, can this idea inspire a selecting body or the employer inviting applications for appointment to public posts to allow candidates to correct mistakes in their application forms about data, figures, and categories whereon the relative merit of competing candidates depends. Then, my lord, paragraph 3, the petitioner Rukhsar Khan and others. The petitioner Rukhsar Khan and others in connected writ petitions are all candidates who have applied for the post of assistant teachers in primary schools maintained by Uttar Pradesh Basic Education Board. They have applied in response to an advertisement dated 5th of December 2018 inviting applications from eligible candidates who wish to participate in the assistant teachers recruitment examination convened by the Examination Regulatory Authority Prayagraj. The applications were required by the advertisement to be submitted online for registration of candidates intending to participate in the selection examination. In these applications, the candidates were required to fill up important personal details, educational qualifications, etc., mentioning particulars such as roll numbers relative to which a particular educational qualification was earned, the marks secured and the relative total marks, special reservation category, if any, and the like. The advertisement bore a bold caution figuring as a centerpiece that makes candidates aware about a declaration that they would have to make while filling up the online registration form. It reads so and so. Now, there's a declaration in this form as well, my lord, may not be in the same words. My lord, may kindly, my lord, come to paragraph 7 now. The petitioners who are 17 in number.
Mr. Chaturvedi, we are little short of time. There are 3 benches.
Lord, I understand. I will be very short and refer only to the
12:30, there is one bench. At 2 o'clock, there is another bench. At 3 o'clock, there is another bench. So let us just come to the substantive paragraph. Which is the substantive paragraph?
Very well. Kindly permit me to only to place this paragraph, and I'll come directly to paragraph 63 and 65. The petitioners who are 17 in number have qualified the written examination except one. They say that they have committed mistakes while filling up various particulars, personal, educational, and others in their online reservation form, registration form. They want to correct and rectify those mistakes which the respondents have refused to allow. They ask this court to command respondents to permit the petitioners to rectify mistakes committed by filling up their online registration form. All the petitioners say that these mistakes have occurred on account of human error. It's a mistake which each of the 17 petitioners committed while uploading their online registration. Lord, kindly come to page 63. This was essential, my lord, to only to Lord narrate what was the Lord scope and ambit of consideration before the learned court. Lord, page 6, paragraph 63. Lord, this court, paragraph 63. Page number. What a stapled hoega, sir.
No, page 29.
29. But paragraph 63, this court has elaborated the bold and resounding caution administered to candidates at the pre-submission stage of application forms about ensuring accuracy of entries relating to the particulars filled up there. To recapitulate briefly, the caution is carried in the government order dated 1st December 2018, on the basis of which the present recruitment process commenced. There is again a clear instruction mentioned in the advertisement dated so and so. Most of all, the online application form carries a dynamic mechanism where a candidate, after filling up all entries, is required to take out a print and compare the entries made in the online application form with his original documents. He has been obliged to make a declaration that he has cross-checked the entries in the printout, compared it with his original documents, and certifies them to be accurate. There is then a specific undertaking given at the time of finally uploading the forms online that the candidates will not have any opportunity to seek rectification or correction of the application. Then paragraph 65, in matters of public affairs, like the process of recruitment to the post under state, there has to be an element of certainty. The process of recruitment must proceed on the foundation of firm and reliable data. A public recruitment cannot be permitted to be shaky affair with shifting positions of aspirants about their candidature. Milord, I heavily rely, Milord, on this observation. A public recruitment cannot be permitted to be shaky affair with shifting position of aspirants about their candidature. If this were to be permitted, it would introduce uncertainties in the recruitment process, leading to its embarrassments. It has also to be borne in mind that where a number of posts have to be filled up, expeditious conclusion of recruitment process requires an unhassled and unhindered course to be run. It is bearing thus objectives all legitimate in mind that candidates have been held bound down by the entries they make in the application form. This cannot be set at naught. Now, my lord, where the shoe is pinching in so far as we are concerned, my lord, the scope of competition, my lord, is being increased, enlarged, my lord, at the instance of some, my lord, belligerent candidates who chose to apply with eligibility criteria alternatively available to them. So it was by choice, my lord, they did so. It was voluntary in nature.
Yes, that's
Good.
way.
Today, my lord, they cannot turn around. And my lord, after my lord, the selection process has proceeded about 80%, my lord, we cannot be, my lord, permitted to compete with ineligible candidates.
Yes. Anybody else? You're for the Mrs. Shaukat Banerjee?
But I am assisting Mr. Shubhi Shanna.
Mr. Shamim?
I am for the respondent writ petition, I am alert. Before Mr. Sami proceeds with, may I draw your losses one notification? Yes.
Yes.
Why I told you losses that they have taken a chance. I'm just telling you losses. My lord, B.Ed qualification, my lord, was first time introduced in 2018 for primary teachers training recruitment. Now you will also just place it, I will just narrate it within a minute. With reference to your notification, it is hereby notified that please be informed that having regard to the development reported to the board verbally by you, the board being the recommending authority for recruitment has no difficulty to allow B.Ed candidates to participate in the 2022 recruitment process for the post of assistant teacher in primary school in West Bengal, subject to the solemn verdict of SLP and other connected matters pending before the Honorable Supreme Court of India in respect of their participation in this said recruitment process. But I tell you, losses, why they took the calculative chance. Before 29 September 2022, as I told you, losses, B.Ed was introduced for the first time 2018. So for the Rajasthan High Court is concerned, they quashed that notification. No, B.Ed is not permissible. Because this state permitting that following NCT notification. The entire matter went before the Supreme Court, judgment is resolved. Now, their participation has been, therefore, subject to the SLP, those DLD. So they thought it, instead of B.Ed, since board is permitting pursuing candidate DLED, I go for DLED. This is the exercise or choice of option. It's not that this is done. And other point, your losses, suppose your losses, I allow them your losses to by offline method. Portal is very difficult even by offline method. Now your losses consider tomorrow verdict comes of the Supreme Court, B.Ed is not. Then what would happen to this selection process? Kindly consider this. One has to come to a end of it somewhere. Might be some apparent, not even apparent, but some irregularity, illegalities. But one has to conclude to a logical conclusion. Well, that should be the only date of the last advertisement date. That should be the date according.
Yes.
I am for the respondent petition, I am alert. But the doctor created problem called iatrogenic problem. But I don't know what abbreviation will be used for board creating problem. Kindly take my lord, a order passed by the honorable single bench. Page number 120, my lord.
What do you call a doctor created problem?
Iatrogenic problem. Iatrogenic problem.
Doctor created
problem. Yes, my lord. But I don't know what's called the board created problem. My lord, kindly take page number 120 first.
This is, I have to add to my vocabulary.
Created problem, then what will happen?
It will be a boardogenic.
Created problem, sir. I will place. Don't worry, don't worry.
Board created problem would be a boardogenic.
Might be such type of abbreviation might be used. May I read the order? Just two pages order, my lord. In this matter, I am told by the learned advocate for the West Bengal Board of Primary Education that today, that is on 29 September 2022, on the date of notification, the result of DLED Part 1 will be declared and the digital mark sheet will be sent to the different institute. All the person who are undergoing the course will get digital mark sheet tomorrow, that is 39/2022, the very next date of the notification. It has further been stated on instruction by such and such learned advocate for the West Bengal Board of Primary Education that TET qualified candidate who are undergoing DLED training session 2022
and qualified in DLED Part 1 in session 2022, examination will be given opportunity to apply in the recruitment process to be initiated by the board. He has also submitted that opportunity will be given to all the person who are undergoing DLED course of the session 2022. Therefore, I find that grievance of the petitioner is redressed by this stand taken by the board, which is beneficial to all. Therefore, the writ application is disposed of and as allowed. So, the board taken the stand, they will allow 2022 session DLED course. It is board stand, no one stand. Either the court stand, page number 120, my lord, of stay application. So this is the board stand. And after that, my lord, by taking that stand, my lord, they, in their notification, they introduce this qualification. Para 3, Subrata B. The first qualification, the candidate shall possess the minimum educational and training qualification as prescribed by the NCTA prevailing as on date of the publication of recruitment notification. What was the NCT notification? May I hand it over the NCT notification of 2018, my lord. In this I have one copy, my lord. Kindly pardon me, my lord. In this 2018 notification, NCT
Yes.
in this 2018 notification, after 2010 and 2011, the B.Ed is introduced as a minimum eligibility criteria for the participation in the selection process. In the 29th September 2020 notification, this B.Ed also applied. A large number of B.Ed candidates participating in this ensuing selection process. Apart from this writ petitioner, a large number can already participated. So B.Ed participated, and we have the both degree, B.Ed as well as DLED pursuing. But we have better marks in B.Ed, DLED pursuing as a DLED pursuing candidate. Because in the part one mark sheet already given. That's why. Part one mark sheet already given. So that's why, my lord, with a legitimate expectation that because board introduced this qualification, so we can proceed with this qualification. And after that, this time and again says the process is verged to completion. That is the, I asked this question to what is the last date of form fill-up? Kindly ask them, the board, what is the last date of form fill-up? What is the last date? According to the notification, the last date of application was, kindly turn page number 122. The last column. The last column. Part of the
Yes.
The last column, the application form for appointment will be available at online portal for the submission from such and such to such and such. 14 November 2022 was the last date, according to this notification. This says, after this notification, we are past to completion. May I hand it over a notification very recently, after the judgment of single bench, they passed this, they issued this, published this notification. And kindly see, so what is the last date? The last date, 11th May 2023, when the single bench passed this order in favor of us on 1st May. That is not that case. The board arbitrarily selected some of the candidates in their whims that no, for them, the gate is open. For us, gate is closed. This is arbitrary exclusion. Nothing else, my lord.
You may take your seat. Ashok. name/names as printed above with it. এটা দুটো appeal করতে হবে। Between 1 and 2. It's a common order. Question. Under challenge in both the appeals,
Before your lordship's not starts, not only
they're analogous in nature. Is the ওইটা নিয়ে নিতে হলো is the order of the Honorable Single Bench dated at 1st of May 2023. Casting WPA 10108 of 2023. By deciding to order the Honorable Single Bench
I'm taking a short leave, your lordships.
petitioners who are all E8 degree to appear for the selection process connected to recruitment of assistant teachers as initiated by the West Bengal Board of Primary Education on and from the 29th of November 2022. The Honorable Single Bench permitted the petitions to apply for the selection purely on the basis of their BA degrees. In challenging the aforesaid order in MAT 804 of 2023, the West Bengal Board of Primary Education, within bracket for short comma the board bracket close, is represented by Mr. Shanghal Kamalar and Senior Counsel, with Mr. Shoykot Banerjee and Mr. Biswas Kamalar at Counsel. Appearing for the appellants. In the para, in the next analogous appeal, the MAT 83020, the appellants are candidates who have already appeared for the selection on the basis of their degrees as advertised by the recruitment notification date 29 September 2022 and represented in their appeal by Mr. Chaturvedi, Kamalar and Senior Counsel, Mr. Parrot. The appellants point out that the writ petitioners before the Honorable Single Bench had earlier applied on the basis of their training qualification, being DLET. In terms of the permission to apply granted by the board to such candidates who were pursuing their DLET course, but were yet to receive their final training. who are yet to receive their final DELE certificate. Question. My a common judgment and order dated the 11th of April 2023 in a bunch of analogous appeals, comma, this honorable division bench, comma, inter alia, comma, held the candidates who had not yet completed their DLET courses or comma, had not obtained their final DLET training certificates on the date of the advertisement, on the date of the recruitment notification, comma, that is the 29th of September 2020, comma, to be ineligible to apply. Yes. Accordingly, the board had proceeded to redraw the recruitment exercise by excluding the candidates who had not completed the DLE as on the date of the recruitment notification, dated 29th of September 2020. Both Mr. Sharma and Mr. Chaturvedi, that is senior counsel with the practice, submit that the candidates excluded from applying on the basis of their DLET, on the basis of their failure, on the basis of their failure to possess a DLET certificate on the date of the recruitment notification, within bracket Subrata, bracket close, cannot be now permitted by the Honorable Civil Bench to apply for the same recruitment on the basis of their BA degrees. However, it is not disputed by the court that the BA degree is recognized as a standalone eligibility criteria for participating in the recruitment of four assistant teachers. Both these sets of applicants further submit then the petitioners had the option to edit, put italics and or modify their online to meet the DLE qualification and only include BEd qualification. However, such opportunity was not availed of by the petitioners. Most of that it is submitted by the board. At this stage, the recruitment process had reached an advanced stage. The Honorable Civil Bench urged in calling upon to revisit the entire recruitment process. On behalf of the respondents in these appeals, the writ petitions, Mr. Shami of Senior Counsel points out that it is not disputed that the board and the National Council for Teachers Education, within bracket NCT, recognized BEd as a standalone qualification for participating The recruitment process is balanced. It is pointed out that it was the board itself who permitted the lead petitioners to apply on the basis of their DAD training course, and and only such board of 29th of September 2020, being paragraph 3 in bracket small p thereof, allowing in-course DLED candidates to apply stood set aside by the order of the Honorable Division Bench dated 11th of April 2020. First of that, Mr. It is submitted that therefore the lead petitioners have the right to be considered on the basis of the standalone B.Ed qualification, which entitles the same to be treated as an eligibility criteria for applying for the recruitment of assistant teachers in terms of recruitment notification date 29 September 2020. It's Subrata, having heard the parties and having anxiously heard the parties and closely considering the materials based on this court finds that by the judgment and order review of the Honorable Division dated 11th of April 2020, part of the recruitment notification dated 29 September 2022, being paragraph 3 within bracket small b thereof. This creating eligibility for in-house DLE candidates who were yet to obtain their final DLE certificates stood struck down. First of that. In the opinion, the further view of this court, the striking down of the in-course qualification of DA with the facts as discussed, judgment and order date 11th April 2020 does not create a bar to consider the candidature of the affected individual only on the basis of their standalone B.Ed qualification, which it is not disputed is also an eligibility criteria to participate in the recruitment process. For the above reasons, there is no conflict. There is no conflict between the judgment and order date. Conflict for the above reasons. At this stage, this court finds no conflict between the judgment and order date 11th April 2023 of the Honorable and the direction of the Honorable dated 1st of May 2023 and the challenge who interference is one from the Honorable If to stand according to this one, stand according to this one. So can 1 of 2023 in MAT for it, can 1 of 2023 to be that's for yes, okay. No interference in the order of the city and disposed of.
Extremely grateful, my lord.
There is no conflict between the order of the division bench and that of the single bench. Why there is no conflict, we have discussed.
So far as not my application for leave.
Leave to appeal allowed, Matt disposed of. Rakud.
My lord, excuse me, may I return back my spiral?
It is a-
ফাইলটা বাড়ি দাও আমারটা তুমি আবার নিয়ে নিয়েছো আমার এই ফাইলটা বাড়ি
We have said this. We have said that there was a advertisement in brief, 29 September. That advertisement had paragraph 3B. That paragraph 3B allowed in-house DLED candidates to participate. That paragraph 3B came under consideration in the division bench, before the division. By order of 11th April 2023, we eliminated 3B. That in-house DLED candidates cannot participate who have not obtained their training certificates. That elimination did not mean that B.Ed, which is a standalone eligibility criteria for being eligible to participate in the recruits, should also eliminate. Therefore, the question of conflict between the two decisions does not arise.
My lord, we are not on the conflict. My lord,
I know,
we
I
are
know,
just at any time, my lord, any candidate can change the, my lord,
That part also we have discussed. Essentially, it was not a fault of the candidates. The board went one way and it had to be decided one way with the board, and then it has come back another way. The waves are being created by you. We are only sitting on the boat.
Grateful, extremely grateful, my lord. Much.
develop.
You see, the boat is moving and the waves are moving, the waves are you.
Not the board, my lord. I cannot tell you in the open court, my lord, not the board.
Let us see. But at
My lord,
least,
not the board, my lord.
at least we
My
are,
lord, board is, my lord, in a soup now, not the board. I cannot tell you the reason in the open court, but not the board, your lordship. That I can, that much I can tell your lordship.
the only thing we are swaying with the waves. We all are sitting on the boat and the waves are swaying.
My lord, we were forced to, my lord.
So this wave we have crossed. Now let us see what next wave comes.
My lord, I didn't certificate copy.
Yes.
Grateful, my lord.
আরেকটা জায়গায়
আমাদের 3 নম্বর
Item 3, দাঁড়া না।
এটা 10:30 আছে স্যার।
আরে দাঁড়াও না, 3টা হয়ে গেছে তো। Hearing concluded, only supplementary affidavit directed to be given by the state. It
Is
can
the
be,
other side there?
yes, yes. My learned friend is there.
Yes. Who's
That the parent teacher matter of the secondary and primary. Your
we have
lordship
not,
direct,
we
Yeah.
we have not completed the hearing.
no, the board was directed to,
Not board, state.
state, state was directed to file a supplementary affidavit
Already prepared.
and written notes of argument.
We'll give you a date. We will give you a date.
May I submit it?
No, not like this, not like this. We will give you a date. We could not take it up 2 PM even because
No,
we cannot even, I'm sitting through several benches and several
No,
things
that-
are coming up. It's not that we are sitting idle and not
No,
taking
no,
up
no,
the matter.
no.
We'll give you a date at 2 PM at a Bimal Theatre. Ask you, send your learned junior some date, if possible before vacation or if possible immediately after vacation. At 2 PM.
Vacation only, my lord, tomorrow is left.
That's right. So immediately after vacation, 2 PM, Bimal at a date though, 2 PM. All of you are here, we'll give you a date. Ekটু তাড়াতাড়ি দিও। 2 PM.
কদিনের এন্ট্রি মর্ডার ছিল?
ওদের বাদ দিয়ে করতে হবে। মানে there is the interim order, my lord, they are enjoying. Our board will be at
Up to the end of,
Possibly in the
19th.
9th.
Subject
No,
to
no,
correction.
19th, it has been extended. It has been extended.
19th অব্দি আছে, মে। মানে ছুটি অব্দি, ছুটির আগে অব্দি।
না, তারপরে extension করলো।
1 minute, madam, please take your seat. We have not called your matter yet. 3 নম্বরটা আছে সামনে।
এই তো না?
You are appearing in 3.
Item number 3 about the respondent matter.
ওই তো ওইটাই তো। না, ওই কম্পারিশনটা আছে না?
শুধু অর্ডার শিটটা দেখালে হবে। আমাকে ডেটটা দাও। Please enter your appearances. We are treating it as on.
না, অ্যাপিলেন্টের লেখাই আছে, আর দেওয়া দরকার আছে?
আসুন। এটা extend করে দিচ্ছি। May অব্দি আছে, এন্ট্রি কি করে date? Party matter is taken up on days list on urgent mentioning by Mr. Bari, Kamala and Senior Counsel. Full stop. Other parties are represented. Full stop. The matter could not be, the business of the court did not allow the matter to be taken up, could not allow the matter to be taken up on the 16th of May 2023 at 2 PM as fixed by the previous order of this court dated 8th of May 2023. Full stop. Accordingly, comma, let the matter appear next under the same heading. Key heading আছে? Under the same heading, fixed matter at 2 PM. কবে দেব? একটা date দাও, যেটা 2 PM. 2 PM on the 13th of June 2023. Full stop para. Parties, the interim order or comma already granted, comma stands extended till the end of June 2023 or comma until further orders, whichever is. 2 PM on 13th June.
Supplementary affidavit directed by Lordship Talukdar.
Supplementary,
Supplementary affidavit and written notes of argument directly.
have you
Yeah,
served?
we have received. Let the supplementary affidavit.
Supplementary affidavit is directed to be filed on behalf of the, on that to be filed by the state respondents is filed today and the same be taken on.
Grateful.
I am appearing on behalf of the appellant.
Now that, my lord, it has been
Urge
একটা কপি দাও ভাই।
দিয়ে দিয়েছি বাড়ি।
আর নেই, দুটো বাড়ি দাবি দিয়েছি। বাড়ি। এগারো।
I am appearing on behalf of the appellant.
Board has sanctioned
Board
the
has-
leave without pay.
Board has
sanctioned the leave. They
Board has already taken steps to approve the leave without pay in favor of this teacher.
My lord, now that it is ball is in DI's court, he will forward it. He will, my lord, forward the pension paper to the, my lord, concerned authority, director of pension.
Director of pensions.
Mr. Day, all that was directed to be completed and shown today.
No, it has. That was the order. That was the order.
We gave, kindly see the previous order.
My lord, by this weekend, it would be forwarded. Kindly record it from my side.
On our part, nothing.
No, that's. Yeah, we are.
No. And
It has been moved forward.
finally disbursed.
ওদের আগের orderটা দেখি। এবার DI ওটাকে করে, then from the DI it will go to, from the DI it will go to the,
My lord, it is called PGBT, Director of Pension, Provident Fund and Gratuity.
so when will he give us the PPO? Show us the PPO.
By Monday, it would be positively sent.
Monday we are closing, so let it be with him. We'll meet on the reopening date. So that the PPO can be shown to us. In the meantime, you complete by.
Yes.
এটা নোট করে দিন, রিওপেনিং ডেটে রেখে।
10:30. 10:30. 6. In the open.
Targeting water has been first.
এখন order.
Sanction করেছে ওটা উঠবে। এই তোমরা পাঠিয়ে দিয়েছো স্কুল?
স্কুল পাঠিয়ে দেওয়ার পরই তো এটা সেকশন হলো। Last statement কমে আছে। I have already submitted.
The council appearing on behalf of the आपको कोई आपको कौन आ रहा है?
Order to the
Submits that the school has performed its duty and has sent its duty. কবে পাঠিয়েছো? Phone has regards to calculation of your
20 April.
full stop. On behalf of the West Bengal Board of Secondary Education.
তাড়াতাড়ি।
I mean, issued by the Deputy Secretary General. আমার সঙ্গে দেওয়ার কথা হয় না leave without pay of late Pratap Chandra Sahu, ex-headmaster, has been approved by the board and by the full stop. Council appearing on the board, of the board submits the 3 days same has been group insurance TI secondary education Purva Mednipur. Full stop. Paragraph. As per the earlier order dated 27/4/2023, it was directed that the Director of Pension Provident Fund and Group Insurance shall take steps and finalize the pension payment order. Is under process as has been informed today. Let the matter appear on 7th of June as mentioned matter. As mentioned matter. On that date, report has to be furnished as regards to the steps taken by the Director of Pension Provident Fund
and group insurance. As regards to the finalization of the pension payment order of late Shri, the late Pratap Chandra Sahu. It is being fixed on 7th of June, 7th of June for the final report. As regards to the pension payment order.
Pension payment order.
To file report. Yes, report. On 7th of June. 7th of June.
Deeply obliged. Instead of 7, 9th, and kindly make it 9th.
9th.
I will be out of station 6, 7, 8. Kindly make it 9th.
Yes, 9. Mention matter by. Even Mr. Jana needs rest. So much of work, so much of work.
Lord, he has money, we don't have. What can be done?
Your lordship are very liberal for this reason. This order was passed. He's getting the benefits.
Her daughter
Oh,
just become MBBS.
doctor, that is an achievement. That is an achievement. Because
He's a
nothing
proud,
like having a doctor in the family. Mr. Jana, congratulations.
proud father.
You want a further date? We can give you a further date after hearing this. 9th June.
And he's treating us for that today.
Yes.
Hey, আমরা বাপকে
Yes, ডাকুন। আর তোর একটা বেঞ্চ আছে না?
My lord, may I be permitted to mention for inclusion one review application in this before this bench, my lord. My lord, the review application is lying pending for more than 1 year, my lord. And the all the files are here in this court for the last 6 months. But the matter has not been heard, my lord.
Review of this court.
Whatever you say, whatever you are saying in the mentioning, we have consulted our officer, we do not agree with whatever you are saying. But it does not matter. You have said what you have to say. We have a different opinion. You give it a review of our order.
Yes, my lord.
Please give it. It was there in the list last week also. So whatever it is, you can go on saying 1 year, 6 months, we do not agree with it. So what,
Yes, my
even if you do not agree with it, that will not stop you from
My
saying.
lord, the review application, the
let it
applicant
be
filed
here.
on 12th March 22. But the matter included in the list on the 12th May 23.
Because
But that
we do
matter
not-
had not been called on.
Subject to correction, we do not recall, at least I do not recall having seen you mentioning this matter in the last 3 months. Anyway, we are not disputing that proposition. Now it will appear when we sit next.
Obliged.
And when you use time periods, when you use big time periods, 6 months, 1 year, come back with some of the relevant material to support it. When you use large time periods, 1 year, 6 months, 4 months, please enlighten us which part of that 1 year, which part of that 6 months. Next time. Yes. Thakur.
My lord, item number 1 and 2, learned advocate Mr. Gaurav Das is appearing for the state. He is on his leg in court number 17, my lord. I am praying for a short passover, my lord, if it's possible.
What can be done? This bench is assembled for that reason. Good.
Just a short passover, my lord.
এইগুলোই content. Ask him to come. He is for the respondents.
He is for the council, my lord.
Council. Yes. Let him, we'll just check the records. Ask him to come. Let him finish that and come. Ask him not to run, but to walk fast. Yes. Yes, Mr. Gupta, what is the matter about?
My lord, this is regarding your lordship's violation of your lordship's judgment passed, my lord, in regard to recruitment matter for South 24 Organized District. DPSC, my lord, in the 2009 recruitment process. Your lordship's judgment is at page 161. 10th of November 2022 was your lordship's order, your judgment. And your lordship may peruse your lordship's order passed on the last date. The trial court record was asked for.
WPSC. WPI.
This we didn't get in the server. We didn't get it in the server.
No order.
Possibly not uploaded in the server.
Report koi. Report koi. But central.
Order report. নিয়েছে তো।
My lord,
Have-
have you placed the order passed by this court before the under single judge?
My lord.
Now, where is mentioning? The court has gone in the other way. The unsuccessful candidate filed a writ application challenging that the persons who are going to be appointed, they have got the less mark, and you wanted to create a superannuary post. But court has not been brought to the notice about the order passed by this court, which has been upheld by this court. The recruitment process has been upheld by this
My
court.
lord, the order of the Honorable Division Bench is annexed with the writ petition, and this
But that has not been reflected in
and
the order.
and also we have submitted before the Honorable Court that this is the order of the Division Bench. And my lord, one indulgence, my lord, I should brought it to the notice of the Honorable Court. My lord, Friday this matter was taken up by your lordships, my lord. In Monday, while I am moving a matter before the Honorable Single Bench, it was informed to me that there is no stay order in the, and if the stay order is there, the Honorable Court is already vacated. I don't know, my lord, but
Where is that order?
my lord, all the persons appearing on in this matter, my lord, taken note and in open court that there has stay has been granted. My lord, I submitted before your lordship. I don't know the order.
These are the orders. The file has come. These are the orders. We called for the file has come.
Sir, it is really very embarrassing situation for us, my lord.
let us proceed on the basis of whatever is there. What is embarrassing? We have to do a job and we have to do the job. You have to do your job. Now, the question is, as long as judicial discipline.
But after the order of stay, virtual stay.
Kindly have a look. Have a look at the order.
Last order.
একসাথে আছে তো।
Last order দিন। আরে order sheet, last
Order
order.
sheet.
Order sheet.
Only order sheet. My lord can find it from the record, my lord. We are already filing a report before the honorable single bench stating that all the writ petition is
Can you see the
below
first
cut off. Below
From
cut.
back. Mr. Gupta, last first order, last one, not first. From back, first order, from back.
Oh, from back.
Regarding the appointment of the expert. I told none of the panel has been given appointment up till now. No appointment can be given to you. Eighth order stays.
The last order, my lord, the last order on the front of this, 4th of May 2023, that order says, I am told that none from the panel has been given appointment up till now, and no appointment can be given till 30th June 2023 or until further order. And the orders before that from the bottom. না তো ডিভিশন বেঞ্চের অর্ডারটা কোর্টের কাছে অ্যাটেনশন আনা হয়েছিল কি?
আমি দিচ্ছি।
সেটা দেখো কবে সেটা করা হবে?
রিট পিটিশনে আছে, এখানে বলি রিট পিটিশন আমি সে বলা হয়েছে কোর্ট যদি না রেকর্ড করে দেন আমরা এই তো petition is a recruitment for 2009 result where of the declared today to the vacancy to 80 vacancy. But the panel has been prepared person slide time the petitioner demanded an observation and the unfilled post against the 2009. However, that
আমি নিচে হ্যান্ড ওভার করেছি কপি নিচে দেখিয়েছি অর্ডার ডিভিশন বেঞ্চের অর্ডারের পরেই তো আমাদের সমস্ত লেটারে ইন্ডিকেশন আছে পার্সুয়েন্ট টু দি অর্ডার অফ দ্য অনারেবল ডিভিশন বেঞ্চ
এই অর্ডারটা স্যার দেখুন 31st জানুয়ারি 30th জানুয়ারি
তাতে কি বলে
এখান থেকে হোললি এগেইনস্ট দ্য ক্রিয়েশন অফ মিক্রোফোন
আগের দিন আমি প্লেস করি
বলছি এখানে যদি আমরা বলেই থাকি যে এই পোস্টটা আমাদের কাছে আছে এই পোস্টটা তো আছে এই পোস্টটা তো আছে বলে ডিভিশন বেঞ্চ বলেছে তো এই পোস্টটা আমাদের কাছে পেলো নাহলে পোস্টটা আমরা পাবো কোথা থেকে ডিভিশন বেঞ্চ পাবলিশ করতে বলেছে না এই যে বলছি এখানে স্যার এই যে DPSC says the 120 number of vacancy are then vacancy যেটা এই 1824 number of vacancy were sent to because of change of rule আমরা যে বোর্ডকে পাঠিয়েছি আমাকে বলেছে তুমি দাও তাহলে তো জজ সাহেব
ডিভিশন বেঞ্চের অর্ডার আছে কিনা দেখো
না এইটা আমি দেখছি ডিভিশন বেঞ্চ অর্ডার আমরা বলেছি উনি নোট নাও করতে পারেন
এটা 30
ছাপিয়ে দেয়
টেস্ট করেছি অর্ডারটা পাস করা হয়েছে যেখানে জাহাজ অ্যাপিয়ার করেছিল লাস্টে জাহাজ অ্যাপিয়ার করেছিল ওখানে বলা আছে এত and the decided that as of vacancy but the panel was over petitioner
that is the difference
number of vacancy out of 1 না ওইটা বলেছি তো রেকর্ড করিনি
both has recruitment and under
it has not recorded not anything about the division bench order but I am told that it was part of the writ petition itself and
but my lord with the leave of my lord can find an observation of the honorable single bench in order dated 30th January 2023 where it is recorded that my lord we have not sufficient number of vacancy in our hand and we have asked for a sanctioning of an new created post my lord on that particular date we have placed before the honorable single bench this document where we have sent all, the chairman written to the Commissioner of School Education regarding sanction of a new created post. On that letter, it is specifically.
Mr. Gadas, we are not here to debate what the single bench thinks of our order, number one. Number two, we are here only to consider the contempt application. So number three, you give us an affidavit of compliance or challenge our order afterwards. That is, we are giving you a date, give us an affidavit of compliance.
They have used an affidavit pursuant to your lordship's last
We
order.
are putting a date. We have spoken to the registrar listing. For your benefit, we will see that these orders, we had called for the file from the single bench. The file has come along with the orders. We have shown you the orders. Now these orders, while they're not in the server, the registrar listing will look into it and will try to help out. That is the one process. You may have these orders, look into it. We want our order implemented. Tell us when can you give us our affidavit of compliance and what shall we do?
But our part, lordship, we are comply, lordship. Only for the lordship finance department, some lordship problem is there, lordship. Otherwise, I lordship publish the panel and lordship directed to the commissioner of education requested to the give much of new post. Lordship education department, lordship send the finance department. Some time has been given. I have lordship comply the lordship's order. Publish the panel.
You file an affidavit of compliance in one way or the other.
My lord, the plea taken here in the report is they have filed a report.
Where is that report?
State.
On the last occasion, my lord, your lordship directed to file a report in the form of affidavits.
Yes, what is the report?
And your lordship's order was that there should be one composite report in respect of all the.
Yes.
And this is affirmed by the additional secretary school education.
Yes.
Para 4 says about the that they want to comply. Para 4 has taken steps for compliance. Para 4 says so. Education department has sent it to the commissioner to the DPSC, DPSC again to the education department, then education department to finance, and they say ultimately cabinet approval will also be necessary.
So who represents the state? The finance is there.
My lord,
the finance department is there. So how long more will you take to comply?
my lord, that is the approval of the appointment committee of the cabinet, my lord. They are the appropriate authority to create the post.
Yeah.
My lord, so my lord, at this stage, my lord, I am not saying how many days it will take time. My lord, creation a new post, question of creation of new post. 1403.
There were total notified vacancy 1834. They cannot say that we have no vacancy today.
Panel also 1506.
They are making.
Why you have making a new case? What is the order passed by this court? The writ petitioners have challenged the recruitment process, and that recruitment process was stopped. Correct? That recruitment process was stopped, then this court has directed to complete the recruitment process. So where is the question of creating the post?
Lord, in compliance of his lordship, Justice Tabrul Chakraborty, my lord, we have already complied. And
We are not concerned with the other. We are concerned with our order. We have directed to publish the list and comply with the order. Give the appointment. Where is the question of creating the post?
well, pursuant to this earlier court's order, well, by all the single bench, well, we have already complied and all the appointment has been made.
But what we want to tell you is that these appointments were not made in this district.
Yes.
Therefore, the question of these posts were definitely lying with you. Where Lordship is asking, where is the question of creation then?
Because
they are not filled.
Earlier orders, well, so many orders, many times, my lord, Already appointment has been made by the South Chobbish Purgana, only 103 vacancies lying with them. Now the demand-
now you're making a new case. The matter was heard in your presence. You have filed your all the report. You have not taken a step. Only 103 post is lying vacant. On all the things have been filled up.
Yes, in the trial court, my lord, we have already raised this point.
Which trial court? We have held this. Which trial court you have taken this plea?
Well, Justice Gangapad,
This is not the case before the Justice Gangopadhyay.
Justice Tapabrata Chakraborty.
This is not, this order has been passed separately by this court and an independent writ petition.
But here, Lordship, I am saying, Justice Lordship passed the order on the basis of the trial court order, Justice Tapabrata Chakraborty.
Sorry,
Lordship, here kindly see the order, Lord.
not on the basis of the trial court. It can, we have not passed an order as an appellate court. We have passed an order in the writ petition.
Yes, but Lordship, here Lordship pass a writ petition and Lordship kindly see the Lordship's order.
Yeah, we have,
Once a moment, Lordship, no, Lordship pass the order.
we have relied upon the order passed by his lordship in the
Lord-
single pen.
That
But
Lordship,
we have not telling that,
no.
and that post and this post are total different of the two districts.
do district and Lordship,
Then-
that Lordship, I have Lordship, when the Lordship district, West Bengal Board of Primary Education come into the 2011, total district primary council merged with the Lordship board.
Yeah.
The document is here.
When it was merged,
Lordship 2011,
2000.
11.
And when the writ petition was taken up for hearing, when you have filed the affidavit in opposition in the writ application?
2019.
Sorry,
14.
2022.
22, Lordship, here, Lordship, Lordship, we have Lordship only for the difficulties, this Lordship. When as for the north, as for the Malda, when the Lordship Finance Department clear within the 2 weeks, within a 1 month, Lordship the fix without Lordship, if the Finance Department complete, we will also give the appointment. I have Lordship, the only problem is the Finance Department. If the state government only Finance Department clear the direction has been given to the Lordship, time has been.
Department has no option. What is the option before there is no if before the
Well, give
our
me the
court stand, our
May I-
order stands, he has to
the
go
time limit, Lordship.
do whatever it is.
Lord, may I make one submission? May I make one submission? They say that there is no vacancy, it requires creation of posts. Why do they say that? Because in 2009, they had declared so many vacancies. There were vacancies were there. The EPS had declared that. And appointments were supposed to have been made on the basis of such vacancies available. Now, in the process, since the matter was pending for long, they have eaten up these vacancies, filled up these vacancies through other processes.
Board vacancy declare করে না।
Board is March.
And
2011, so you come to
if
2014.
if they-
You don't know about the 2014. Justice
Milord,
when the Lordship was matter was hard on the division bench.
the system is this. Board asks the respective DPSCs.
Board DPSC থেকে ask তো করে না, স্যার। Board কিছু করে না। DPSC থেকে government
দাঁড়াও না। Therefore, Milord, board has nothing to do with regard to the vacancies where it is available or not. It comes from the DPSC to the state education department. Education department sends it to the board. Board accordingly, Milord, takes steps for filling up this. Now that way, Milord, initially in 2009, some vacancies were declared. And since the process came to a halt for so many years, Milord, what was done is, Milord, the DPSCs had sent, Milord, these declared vacancies, as if these vacancies are available for recruitment in the subsequent recruitment processes. On that erroneous basis, Milord, these posts have been eaten up. And therefore, Milord, if it is entirely the government's responsibility not to cheat the candidates in respect of declared vacancies.
But here, Lordship, clear Commissioner of Education, Lordship, here the letter dated, Lordship, in response of the director's memo number such and such, dated 16/5/2016, all chairperson had sent the vacancy to their respective district. It is also submitted that there were vacancies in the district of North 24 Pargana 2605, Malda 1320, and South 20 Pargana 183, which is stipulated to the recruitment process 2009, but were remain unfilled. at that material point of time in the year of 2016, so that said 5759 vacancy of the said 3 district along with the current vacancy were collectively reported to the West Bengal Board of Primary Education by such and such number, Lordship.
Therefore, my lord,
But here, Lordship, sign is not here, Lordship, Commissioner of Education is the mail.
Therefore, it doesn't, the creation aspect, the government has to create it, my lord, because of their own fault. This is not a creation of additional post. It is not creation of additional post really. It's creation of the posts which have been wrongfully written up.
লক্ষ্মীরা মানিক ভট্টাচার্য সব খেয়ে নিয়ে যাবে কেন?
কাউন্সিল তুলে দিয়েছিল হয়তো ওই জন্য খেয়ে নিয়েছে।
আমাদের কাছে ডকুমেন্ট আছে কে খেয়েছে আর কে না।
রাতুল সব খেয়ে নিয়েছে, রাতুল সব খেয়ে নিয়েছে তখন।
তাই না? তোমার খিদে আছে তাহলে আসো খাও।
ওটা লড়াই করে লাভ নেই তো, আমরা তো ভ্যাকেন্সি ফাইন্যান্স করলেই আমরা দিয়ে দেবো। আমাদের
আর ফাইন্যান্স
Yes.
my lord, we came up with prayer before your lordships.
No.
And your lordships are pleased to allow our prayers. Now it is not for us, my lord, to go and beg from the government that give us a point. Our right is crystallized by your lordship's order.
Yes, Mr. Chattopadhyay, Mr. Vaishya, Mr. Gaurav Das and the others. Our order stands. Our order, you have not shown us any order of a superior court or that this order has been modified, set aside. Therefore, what is our job? To see that our order is implemented. Now, we are not hearing, we are hearing so many explanations in between. This bench, this circular, that circular. That makes it impossible for us to execute our order. And at this stage, we are not called upon to do so also. Because what do we do as judges? We have passed a recent order, 3 districts followed a recruitment procedure. So the finance secretary, the education secretary, the commissioner of school education, and the chairman DPSC, they will appear before us on the next date. And if possible, they will file one single consolidated affidavit of compliance. And then we'll take steps. Whatever is your baby and the bathwater, you handle it. We will give you a comfortable date. These 4 gentlemen, we would like to meet them here in person, and we would like to see how much they can take our order forward. Or how much have they taken our order forward? Who are the alleged contemners?
Finance is not the party. My lord, if your lordship takes and 4 and plus finance secretary.
And secretary is to be
Well,
added.
subject to your lordship's kind approval.
Yes.
Well, lordship kindly make it adjourned for 2 weeks after vacation. Well, in the meantime, we're taking steps. Well, we'll travel. Because finance committee referred the matter. That has been the cabinet for supernumerary post creation of supernumerary.
Difficult task. No, everything is a difficult task. But we are.
Lordship kindly allow us. Otherwise,
Lordship, give me, Lordship, one chance, Lordship. Give me, just,
We are only hearing explanations
Lordship,
in the
give me
meantime.
1 week, Lordship, after vacation, give me a chance, Lordship. 1 week after, I am not.
We
paying
want an
for-
affidavit of compliance.
Lordship, give me 1 week, Lordship.
Because well,
Tell us
cabinet committee, well,
that you have to, that is your
That
department.
2 weeks time,
If
Lordship. in the
If
meantime,
suppose you
Lordship,
tell us that something has to be done by our High Court, we have to take steps. It's been done by you, you have to take steps. We have to see. Complete करेंगे.
Give me 2 weeks time, Lordship.
1 week.
1 week.
Because 2 weeks are, the question is, this bench
1 week
also
after
becomes
vacation.
contested. Very well. His lordship has a circuit bench in Andaman, so that is at Jalpaiguri. So you get 2 weeks actually. 19th June we meet.
yes, sir.
At what time? 12:30. Ashok. 12:30 কিছু আছে 19th? 19শে জুন 12:30।
Visit করতে বলো। ছেড়ে দেন না। Single bench stay দিতে
দুটো থেকে। আমার সাথে
আসতে বলো, আসতে বলো।
একের পর
2 o'clock, 1 নম্বর।
আরে আসো। সিঙ্গেল বেঞ্চ অর্ডার এখানে সেখানে আপিল করো যারা এফেক্টেড হয়েছে আমরা কি বলবো?
এটা first part.
কমপ্লেইন না করলে তখন পার্টি করছে।
Party list slash are represented. Party list slash are represented in the order of their names is printed above in the cost title. Although several strands of argument have been advanced by the respective parties, the fact remains that as on this date, the solemn judgment and order of the honorable division bench dated 12th May, 10th of November 2022. Yes. Is yet to be complied with by the alleged contemner / respondents. Full stop. This court is in requirement requirement of a positive instruction by way of an affidavit of compliance from the alleged contemners, from each of the alleged contemners, disclosing the compliance of the order dated 10 November 2022 within brackets. Let the Secretary, Ministry of Finance, Department of West, Department of Finance, Government of West Bengal be added as a as an alleged contemner number
নাম পার্টি করতে বলছি
5 to the contempt application. Leave is granted to the petitioners to amend the cost title in the course of this day. Full stop para. Let notice of this order be also served on the added contemner. You appear for the Secretary of Finance?
On behalf of the state,
Yes, so therefore he is there. Mr. Chattopadhyay, Learned State Council takes notice on behalf of the alleged added contemner number 5. Let additional copies of the contempt application be served on Mr. Chattopadhyay.
well, upon the finance, well,
Oh, no, you have to handle your own department. Be served on.
well, it would better, well, because next time you'll.
No, we are not. Then the service will be on the basis of service will be held up. We do not want that. Please take it. You call up the finance department and take the service. We serve on Mr. Chattopadhyay and also on the finance, also on the alleged contemner number 5. Mr. Gupta, please ask your clients to serve on Mr. Chattopadhyay for the election. Not now, you do it on the basis of a letter, everything. And also a direct copy to the finance secretary, both. Let the applicants file a consolidated affidavit of service on the next day. Also, let the matter appear under the key heading contempt application at 2 p.m. on the 19th of June 2023.
Well, subject to a courtesy line approval. Well, Manish Jain is not the secretary, he is the principal secretary.
Principal secretary add kore.
Well, that will be corrected in the cost title.
Who?
Contempt number 3.
Principal secretary. And let the alleged contempt number 3 be described as the principal secretary, leave granted. Finance secretary, principal secretary finance, or is it secretary finance?
Principal secretary.
So you correct 4, make the secretary principal secretary and add 5 principal secretary finance.
We have to get the name of the finance.
Okay, give the name.
Well, West Bengal Board of Primary Education may be a party, my lord. Made a party because
They had nothing. They had nothing to do.
Let them made a party, Lord. So
They were not.
then thereafter, Lord, comply the Lord. Lord, if the finance department made a party, finance department made a party, finance department not in the party, Lord. Let the board has made a party, Lord. Thereafter, I say, finance department then come. Lord, Ratul বিশ্বাস appearing for the DPSC. Now, Lord, say the board. Yes, what is the problem, Lord? If the Lord finance department made a party, our Lord, total post vacant to the Lord board. Let the board made a party, Lord. Our total post vacant to the Lord goes to the board. If the Lord finance department made a party, I am only submit before their Lord. Let the board has made a party, Lord. If the problem has been solved, Lord, you ought to have said in the proceedings.
My lord, the board was not in the picture at all in the 2009 recruitment process.
Then, Lord, total post, Lord,
Board came only in 2012.
Yes, but total vote, Lordship, total seat, total Lordship by vacancy goes to the board, Lordship.
Vacancy goes to the board.
3 districts people, Lordship.
No.
The board has made a party.
The vacancy.
Board
appointing as his board, Lordship. Board made a party, Lordship.
Vacancy.
That Lordship, Lordship,
Mr. Bush, we are not ruling out the idea. The last document which Mr. Chattopadhyay produced before us showed that it is pending approval before the finance department. Accordingly, we have asked for an affidavit of compliance looking into that document up to this stage. If any complications are pointed out on the 19th of June, our option is
my submission has been recorded, Lordship. I am only praying that, Lordship, my submission only board has made a party, my submission has been recorded, Lordship. Only my prayer, Lordship. Let the Lordship, my prayer, Lordship. My Lord, submission has been recorded, Lordship. I am not. If the Lordship
board was not in the picture at all.
There is no harm. My submission has been recorded.
Board is now in picture.
Lordship, kindly, sir, my submission has been recorded. Lordship.
2009 board is not.
Even now, the appointment will not be given by the board, but by the DPSC. Even today.
The only thing,
Lordship, my submission has been recorded. Otherwise, Lordship.
Compliance report.
If you wanted to board be made a party, okay, we'll make a board as a party and all the parties should present along with the compliance report.
What's the harm, Lordship? What the then, Lordship, if the Lordship,
then the board as a party and all
reward point, Lordship, given to me, Lordship, if I have compliance, Lordship, the member party, so what is the harm?
Also appear.
If Lordship, I will submit before his Lordship, if my submission will rejected.
Correct. You made your submission point taken. Now, if the board, we were not aware of the formal role of the board in implementing this order. If you give us an affidavit of compliance showing that this is where up to the point you've complied and here you're stuck because of the board. Within 2 days' time, we'll ask the board to be present.
Exactly.
That we can. You have to point out, we have one report of Mr. Chattopadhyay. Board has not been discussed. Up to the finance, it has been discussed. We have restricted ourselves on the basis of the report up to that point. There's no reason why we should not agree with you. We may agree with you. On the next stage, if you come up with your affidavit of compliance, say this is because of the board, these vacancies are stuck. We will take 2 more days. We'll meet on 21st and we'll ask the board chairman to be present here. Not an issue. That is, we are now addressing it one step at a time, the effort to comply. If the finance comes up and if the education comes up and says, no, because of the board, we are stuck. This order is not being implemented.
Yes.
You give us 48 hours, we shall have.
But that lordship submission is recorded there, otherwise the next date lordship that,
Very well. At a note, Reketin, I mean.
and that note has been lodged.
Hello.
Very
Only
well.
thing, Malab, record, Malab, I have submitted the compliance report that we kept in the record.
You have not submitted a compliance report. Report submitted by Mr. Chattopadhyay, we kept. That is not a.
Not compliance. But what steps we have taken, that has been.
Lordship,
Movement of file only.
We meet on 19th,
No.
2 p.m. with this.
On 19th
19th
at 12:30.
at 2 p.m.
the submission lordship.
Yes, we have taken a note. I shall correct the file. At a note the event, Mr. Vaishya submits that the board is now a necessary party to this contempt application and hence be implemented as a party. This point is reserved for consideration of the. Yes, you have submitted that this should be made a party respondent. This point is reserved for consideration on the next day.
I am submitted report,
You
lordship.
have submitted.
My lord, one indulgence, my lord. My lord has seen the last order of the last honorable single bench before your lordship. My lord, till taken up by your lordship, my lord, let the matter be tagged with this.
But otherwise, lordship,
Otherwise,
lordship, matter is fixed on 7th, lordship. Let the tag, lordship. I am not do not want to any lordship further proceed. Only for the report, otherwise
is-
matter has been famous as 7th.
We have
Lordship.
that, Mr. Vaishya, that is a wrong way of tagging. The
That's
question
that-
is, let it go back where it goes back. First of all, you get all your orders after the
Again,
registration.
7th, lordship, there, lordship.
7th, come back on 8th to be for us. We'll meet over virtual and then we will take a positive step. Right now, this wrong message is sent that we tag it just to let the court has a
Dear
freedom to
lordship,
hear
we are,
the.
we are the advocate lordship. Here come before their lordship. Again,
All
lordship,
the-
7th, I come before their lordship. I am facing a lot of trouble, Lord. Nothing, lordship. I know, lordship, what's the trouble I am facing on 7th, lordship. I know, lord.
That's right. If you're facing trouble on the 7th, come back on the 8th before us. If we are only interested in our order being compliant. His lordship may be, Jalpaiguri, we will meet over virtual mode and try to resolve.
Then, lordship.
And we are not keeping the file back, but we are giving you all the order copies for the registrar listed, so that they are on serve.
Like copy of the order speaker and everything.
My lord, one indulgence, my lord, under compelling circumstances, my lord, I'm praying for leave to file this appeal, my lord, without certified copy, my lord, and in the physical form, my lord. Issue is that, my lord, the petitioner, my lord, has filed a contempt application, my lord, and the file is lying there, my lord. So we couldn't collect.
Regular
certified-
bench.
Yes, my lord.
This is a regular bench matter.
Yes, my
Come back at 3 o'clock.
lord. Grateful, my lord.
My lord, before your lordship takes out this matter, my lord, at the outset,
Mr.
I must,
Mr. Kabir, Mr. Kumar, have you been paid your remuneration?
my lord, that will be, my lord,
No, my lord.
that has not, my lord, couldn't be
No,
furnished.
my lord.
In course of the day, it will be, my lord. That is what I wanted to mention. There was some, my lord, technical problems, my lord, it will be.
My lord, we also, we have, my lords, will process it on top priority. Actually, my lords, the order was uploaded only on Monday, my lords. That is why, my lords, I think they took some time, my lords. They'll process it, my lords. They'll do it, my lords. Goes without saying.
Tuesday.
Kumar, Mr. Kabir, have you heard?
My lord, my lord, my lord.
Please report to us on the next date that
My
you have.
lord.
Yes,
My
my
lord, my lord.
that was there, my lord. It was uploaded only on Tuesday. So anyway, my lord, that is not the issue, my lord. It will be, my lord. Now, my lord, two things, my lord.
Before court closes on the 19th for the summer break, Mr. Chakraborty, I hope the remuneration is completed by that time. We hope.
Yes.
Court closes on the 19th. The remuneration should reach the special officers by 19th.
My lords, we'll convey, I'll convey it to the concerned.
Otherwise, for each day's delay, we shall impose additional costs. Starting from 20th till we get it. Mr. Shanal,
My lord,
19th it
yes.
reaches. If there is any delay beyond 19th, from 20th onwards, we start imposing a particular
no
figure.
question of any
Then
delay.
they will have to be paid whatever is the
Absolutely, my lord. There is no question of
Yes.
any delay. I'll personally look into this. My lord,
My lords, I can only convey, and my lords, I would happily my lords, I would not oppose, my lords, if my lords decided to impose cost for every day of delay, my lords. That will be easier for me to do than to give an assurance of that kind, my lords, on behalf of the government. But my lords, I'll put it across.
Please do that.
My lord, before my lord, I place the report, my lord, I just want to, my lord, show certain things before your lordship. My lord, there are two things that have fallen. Now, my lord,
have these been provided to
no,
everybody?
my lord, no, my lord, I will. My lord, what happened, my lord, there was a lot of technical issues, my lord, internet and other issues, my lord, due to this. My lord, may I just place and I will submit it before the special officers, London special officers, as well as my now, my lord, kindly takes up, my lord, whatever documents that has been, my lord, gone through by me, I could, my lord, whatever has been gleaned, lordship kindly takes up the details as on 17.5 details of advances given to Manthana. There was, my lord, a submission that was recorded that Manthana was being given an, my lord, amount of 96 crores, 39 lakhs. Now, my lord, these are the what I have seen through the all the packages from all the records that was available.
Why are we beginning with Montana right now? Why don't we see the road condition and then we come to Montana?
You know,
Why
my
do
lord,
we
it
start
was-
with that now?
Oh, absolutely, my lord.
Let us see the road first. What have you done? What do you want to do? Then we'll come to Montana. Of course, we'll come.
Yes, yes.
But why do we start with it? Why do we have to start with this?
Because, my lord, it was
Yes,
lots
we
of
will.
pleasure.
This is part of our query. But first, tell us what is the road.
Because that was a monetary issue involved. That's why I thought, my lord, I will point it out before your lordships.
This report has been given to this.
We couldn't give it, my lord. We prepared it 10-15 minutes back. My lord, this much I can tell you, lordship, my lord, I assure, because there are certain papers which has been repeated also in this report. I will get it, my lord, since, my lord, I was under a duty to, my lord, file it before your lordship today, my lord. I am placing it for assisting your lordship, my lord. I will definitely, my lord, give the copy by tomorrow. It will be there.
It will just be a one-sided argument. You will present the report. Nobody will have anything to say.
No,
Go
my
on doing that. Do whatever you can to the
No,
best
no,
of
no.
your.
My lord,
It will
it
be
is
just
not
a one-sided monologue from your side.
Absolutely, my lord. Lordship will kindly appreciate it is only with regard to the queries that has been placed before the court by the learned special officers as well as the learned 3-member committee.
Read whichever portion you can read loudly. Otherwise, they get the report and then there is a meaningful discussion.
My lord,
only to show your law before your lordship, my lord, this one issue is still there. That is on instruction. I'm, my lord, again, my lord, submitting before your lordship that the forest clearance is a rudimentary part so far as my department is concerned. My lord, they have stated that, my lord, there is a road plan also that has been annexed. Lordship kindly takes up the plan of action that I have stated in page 4. As on date, 57 kilometers of road is in bad condition. My lord, the 3 members committee has recorded that 78 kilometers of NH4 is in bad condition and no roads. My lord, as on date, 57 kilometers is in bad shape. Out of which, my lord, we again submit, my lord, 34.774 kilometers, the forest permissions are required. Now, my lord, why I say so, it has also, my lord, been pointed out before your lordship that certain portions, they say that the drainage is required. Now, my lord, my technical expert has stated that it depends on the terrains and it depends on the topography of the area. For the entire stage, the drain may not be required. Now, in the forest area, until and unless the entirety of the land stretch is given, these embankments could not be, my lord, constructed. And, my lord, there are also evidences that where, my lord, without the forest clearance, when they proceeded, there has been, my lord, penalty levied. So, my lord, these stretch, there has been assurances, it is on instruction and it is also placed before your lordship. Assurances of clearance has been given, but, my lord, the clearance has actually not come forth. And second query, my lord, that has fallen from your lordships, pursuant to, my lord, the Lieutenant Colonel's query that we could have brought the stone quarries from outside the islands, my lord, that would have taken, my lord, the agreement beyond its scope. And the financial part would also have, my lord, raised. So, my lord, not going into that, we say that the balance length of 9 kilometers, lordship will kindly see that, my lord, in terms of the assurances that has been given, my lord, we have already taken steps. That 3 kilometer stretch, which, my lord, the learned special officers has pointed out before your lordship, initiation of fresh tender has already been started. And so far as the, my lord, the last inspection of the learned special officers, we stand by that assurance. That part of the road will be constructed by, my lord, 31st May. Dues from Vashish Mantana is, my lord, well covered by the bank guarantees that we are retaining. This is also, my lord, I have, my lord, prepared this chart for your lordships, my lord, where the, my lord, each and every bank guarantee details has been given, how much you have advanced to the contractor has been given, whatever is recoverable has been given. My lord, these will all be scanned and sent to my learned friend as well as my special officers, my lord, in course of.
Mr. Kumar, Mr. Chakraborty. No point carrying this matter forward today, because till you have the report and till you know what is happening, there's no point. It will be just hearing Mr. Shandal, and we will be hearing that, you know, there are assurances after assurances. So you please take the report, please consult it, report to us. We'll meet on the 7th at 2 p.m. 7th, that'll be better.
My lord, my lord, between the, my lords, I'm requesting, my lords, can it be after the 11th, my lords? Between the 4th and 11th, my lords, I'm traveling, my lords. I made that request in another matter also.
No, that's right, that's right. 4th and 11th. Vimal কোথায় আছে? খালি দিন দাও। Very well, it will be there on the 12th at 2 p.m.
My lord, my lord.
My lord. And please report payment of remuneration. Please note the date and tell us, both the special learned special officers.
My lord.
And please transmit these documents to them, and including whatever you're trying to show about Montana versus, give them
Chart
those
that has
documents.
prepared, my lord, I will include that also.
And
Yes.
give it to them. We'll meet on the,
Then,
you get some more time for your assurances to go.
My lord, what I am on, my lord, apart from this report, my lord, since now they get at least another 10 to 20 days.
Correct.
So on that day, what is the status? Let them file a report on that day also with regard to the status.
No, that maybe before we part with this case, maybe we will trouble you, learned special officers, for one more weekend, maybe. For the final, for our final assessment on the conditions. So they will give us a status report on 12th. And so far as concerned, the weather has been quite kind to Andaman. So they cannot complain that there has been any cyclonic disturbance.
No,
Which
it's not there, my lord. Yes.
is not there.
Not
So let us see. We were expecting them to report cyclone today.
My lords, I'm told that it's luckily not touched the Andamans and has instead gone to Burma and Bangladesh. Bangladesh, correct.
So let us see how lucky it is for NH4.
My lord,
We meet on the
one more
12th.
indulgence, my lord. Whatever we have submitted before your lordship, my lord, there has been certain documents which has been repeated, my lord. I find it
That's
right
why
now.
we'll
Now, my lord,
point it out.
if your lordship is kind enough to, my lord, can you take it back and, my lord, file it tomorrow, my lord?
Do that.
Because the
Give them
pagination, whatever we are going to submit to the London special officers may not tally.
You make the pagination, you
না ওই একই লেটার চারটে রিপিট করে গেছে তাই জন্য পেজিংয়েশন আলাদা হয়ে যাবে ওনারা একটা রিটার করবে বোঝা যাবে না
tally করে repaginate করবে।
তাহলে তো ফাইল
You do it. We'll sign the order when you do it. Ashok. কোথায় বলে দিই?
or my lord if your lordship so desires my lord let it be written with the record I will file a fresh one. Let it be, my lord. Your lordship, my lord, passes the necessary directions.
12 তারিখে meet সেটাই ভালো। In the meantime, remuneration pay by 90 May. Hon'ble. Both তাদেরকে remuneration দেওয়া হচ্ছে। এই তো স্যার by 19 May আমরা একটা fresh status report দেবে on 12 এর মধ্যে কাজ করেছে NHIDCL আজকে তো রিপোর্ট দিয়েছে তখন 12 তারিখে একটা ফ্রেশ রিপোর্ট দেবে কি আজকে থেকে 12 তারিখে কি কাজ হবে। আচ্ছা আরেকটা রিপোর্ট দেবে এটা তো আজকের অবধি না থেকে নেক্সট ডে কি কাজ হয়েছে সেটা তো একটা রিপোর্ট বলে দিলাম
The document at page 9 has been repeated again in documents, my lord, in page 12 and
parties / are represented in the order of their names as printed above in the cost title. Full stop. In terms of the previous order of this court dated the 10th of May 2022, the National Highways Infrastructure Development Corporation Limited within bracket NHIDCL files a report signed by its Deputy General Manager within bracket P. It is affirmed.
my lord, affirmation, my lord, we are awaiting that, my lord. He is
Sign,
present on my lord
report-
line.
Report by its Deputy General Manager within bracket P, Regional Office at Port Blair, 1 Koteshwara Reddy Mummadi. Spelling taken থেকে নিয়ে নেব। 1 Mr. Koteshwara Reddy Mummadi, full stop para. The report is filed today, filed today. Be taken on record. Full stop para. Let copies of the report be positively circulated to the learned special officer and to learned counsel appearing for the Andaman and Nicobar administration by the course of this week. Full stop para. This the NHIDCL is directed to file a further report disclosing progress of work on NH4 between today and the next date. Full stop para. Let the matter appear under the same heading. Ki heading ache? For orders on the 12th of June 2023 at 2 p.m. Full stop para. Both NHIDCL and the Andaman and Nicobar administration undertake to pay the remuneration of the learned special officers as directed to be paid by the previous order of this court dated 10th of May 2023 on and by the 19th of May 2023. Full stop para.
If your lordships permit, my lords, would your lordship consider making it a direction of the court, my lords, because my lords have said undertake if it commends to your lordship, my lords, if it can be made a direction of the court.
Direction was there.
Direction is there, my lord.
Direction was there on 10th May. Today is the undertaking to comply with the direction.
Yes, my lord, we'll comply.
Full stop. Para. Let the matter appear. It appears that you do not have a solid grip over your clients.
Lords, in monetary matters, it is quite true, my lords.
No, but then this is part of the order, part of the previous order.
My lords, I'll not say anything further, my lords.
Let
It's
them-
good, my lords, on my undertaking, my lords. I can be held to contempt, my lords.
Let the matter be 12th. All parties to act on it.
Obliged.
We meet on the 12th.
My lord, thank you.
My lord, grateful.
Between today and the next date, আর কিছু আছে?
Mal.
Oh, annexure, just a
Wait. Short committee. 9/7.
My lord, may I take your lordships kindly, my lord. I want to file this appeal, my lord, without certified copy, my lord, and in physical form. Grateful, my lord.
I was paying for the same leave of your lordship. I was paying for the same leave of your lordship to file without certified copy. Great.
Document.
Okay.
Yes, Mr.
I resume.
You have completed. Mr. Kaur was to complete. You've not yet
In
completed.
fact, none of us completed.
Very well. But we will, irrespective of the length of time it takes today, we will like to complete your submissions. And therefore, we want to deliver some orders before the court closes for the. So we will request you to give your assistance up to whatever time is necessary.
You know,
Yes.
I'll be very glad to do that.
No, because no point in, again
Yes, yes, keeping
going
it
on the
pending.
next step, because today this is the
We are very close to the vacation.
this is the fourth time I'm sitting on a bench, morning, rising, sitting there, because we are circulating matters among our brother judge. So therefore, yes.
My lord, I'll try to be brief. I made some submission, my lord, regarding the scope of the writ petition, the pleadings, the grounds, the prayers, etc., and the judgment I read out. Now, my lord, looking at the petition, my lord, one perhaps could not believe that this judgment is relating to this matter.
Relating to?
This writ petition. The judgment, my lord, goes totally different angle, totally different aspect.
Which judgment are we talking about?
My lord, the judgment by which, my lord, the jobs of 36,000 teachers was taken. My lord, this judgment proceeds on the basis, my lord, that aptitude test, etc., wrong here and there, etc. Now, my lord, the writ petition, I referred, my lord, to the grounds taken in the writ petition and the prayers. My lord, it is not the case of the writ petitioners that there was erroneous assessment in the aptitude test or interview or anything like that. That was not the case made out. The only and there was no prayer that the service of these teachers be terminated. The fresh recruitment process be initiated. Nothing like that. The writ petition was only on the basis that we have been discriminated against. We also fared well. Others have been employed. We have not been. That's the only basis of that's the entire writ petition. And if, as I said, my lord, if one reads the judgment, my lord, it will not be possible, my lord, to accept that this judgment is on this writ petition. Now, my lord, the carriage of the proceeding lies with a party to the lease, not with anybody else. That's the settled position in law. And on this basis, my lord, the courts have held, there are umpteen number of judgments on this, that the court will limit the relief to the pleadings. My lord, that has been totally forgotten. My lord, in support of that, this proposition, my lord, I cite only one judgment, 2010, volume 11, Amar boi, will be 2010, volume 11, Supreme Court cases, 557. আমার বই কোথায়?
আমার কাছে দিন।
2010 Lord, the judgment begins at page 557. Will not kindly take paragraphs 30 to 34. 30 to 34. The court will not make a third case for the party. That will not be principle. In paragraph 30 at page 569, in Trojan and Company versus Nagappa Chettiar, this court considered the issue as to whether relief not asked for by a party could be granted, and that too without having proper pleadings. The court held as under. It is well settled that the decision of a case cannot be based on grounds outside the pleadings of the parties, and it is the case pleaded that has to be found. Without an amendment of the plaint, the court was not entitled to grant the relief not asked for, and no prayer was ever made to amend the plaint so as to incorporate it in alternative case. Then 31. A similar view has been reiterated by this court in Krishna Priya, etc., observing that a party cannot be granted a relief which is not claimed. Dealing with the same issue, the court in Bharat Amrat Lal Kothari held as follows. Though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, grant a relief not even prayed for by the petition. In Fertilizer Corporation, this court held that the High Court ought not to have granted relief to the respondents who is there not even prayed for. In view of the above, law on the issue can be summarized that the court cannot grant a relief which has not been specifically prayed for by the parties. The instant case requires to be examined in the light of the aforesaid legal propositions. Then kindly take paragraph 39. The only other paragraph I'll read out. Paragraph 39. Page 570. More so, in the writ petition filed by Sri Ugroshen, relief sought was limited only to quash the allotment made in favor of Sri Manohar Lal. No relief was sought for making the allotment in favor of the writ petitioner Sri Ugroshen. However, the High Court vetoed the impugned judgment and order has issued direction to make the allotment in his favor. Thus, we are of the view that issuance of such a direction was not permissible in law, etc., even otherwise. A case made out by a party, relief is based on, the relief claimed is based on that. The court will not make out a third case and grant an additional relief. Now, I'll take the point of waiver and delay was taken by Mr. Bandyopadhyay yesterday. My lord, in support of this, my lord, I'll cite two judgments. 2014-4. 2014-4 Supreme Court cases 108. Delay waiver, particularly, my lord, in cases where third party right has accrued. My lord, the court doesn't entertain a delayed challenge. My lord, the 2014-4 Supreme Court cases 108, 108, paragraph 13 to 17. Paragraph 13 at page 115. First, we shall deal with the facet of delay. In Maharashtra SRTC, the court referred to the principle that has been stated by Sir Barnes Peacock in Lindsay Petroleum, which is as follows. Now, the doctrine of laches in courts of equity is not an arbitrary or a technical doctrine, where it would be practically unjust to give a remedy, either because the party has by his conduct done that which might fairly be regarded as equivalent to a waiver of it, or where by his conduct and neglect, he has, though perhaps not waiving that remedy, yet put the other party in a situation in which it would not be reasonable to place him if the remedy were afterwards to be asserted in either of these cases. Lapse of time and delay are most material. But in every case, if an argument against relief, which otherwise would be just, is founded upon mere delay, that delay, of course, not amounting to a bar by any statute of limitation, the validity of that defense must be tried upon the principle of substantially equitable. Two circumstances always important in such cases are the length of the delay and the nature of the acts done during the interval, which might affect either party and cause a balance of justice or injustice in taking the one course or the other, so far as relates to the remedy. In state of Maharashtra versus Digambar, while dealing with the exercise of power of the High Court under Article 226, the court observed power of the High Court to be exercised under Article 226 of the Constitution, if is discretionary, its exercise must be judicious and reasonable, admits of no controversy. It is for that reason a person's entitlement for relief from a High Court under 226 of the Constitution, be it against the state or anybody else, even if is founded on the allegation of infringement of his legal right, has to necessarily depend upon unblameworthy conduct of the person seeking relief, and the court refuses to grant the discretionary relief to such person in exercise of such power when he approaches it with unclean hands or blameworthy conduct. In state of Madhya Pradesh versus Nandlal Jaiswal, the court observed that, then the court, paragraph 24, it is well settled that the power of the High Court to issue an appropriate writ under 226 is discretionary, and the High Court in the exercise of its discretion does not ordinarily assist the tardy and the indolent or the acquiescent and the lethargic. It has been further stated therein that if there is inordinate delay on the part of the petitioner in filing a writ petition and such delay is not satisfactorily explained, the High Court may decline to intervene and grant relief in the exercise of its writ jurisdiction. Emphasis was laid on the principle of delay and laches, stating that resort to the extraordinary remedy under writ jurisdiction at a belated stage is likely to cause confusion and public inconvenience and bring injustice. Thus, the doctrine of delay and laches should not be lightly brushed aside. The writ court is required to weigh the explanation offered and the acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of the citizens, but simultaneously, it is to keep itself alive to the primary principle that when an aggrieved person, without adequate reason, approaches the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the lease at a belated stage should be entertained or not. Be it noted, delay comes in the way of equity. In certain circumstances, delay and laches may not be fatal, but in most circumstances, inordinate delay would only invite disaster for the litigant who knocks at the door of the court. Delay reflects inactivity and inaction on the part of a litigant. A litigant who has forgotten the basic norms, namely, procrastination is the greatest thief of time, and secondly, law does not permit one to sleep and rise like a phoenix. The delay does bring in hazard and causes injury to the lease. Then 17, in the case at hand, though there has been 4 years delay in approaching the court, yet the writ court chose not to address the same. It is the duty of the court to scrutinize whether such erroneous delay is to be ignored without any justification. That apart, in the present case, such belated approach gains more significance as the respondent employee, being absolutely careless to his duty and nurturing a lackadaisical attitude to the responsibility, had remained unauthorizedly absent on the pretext of some kind of ill health. We repeat, at the cost of repetition, that remaining innocuously oblivious to such delay does not foster the cause of justice. On the contrary, it brings in injustice, but it is likely to affect others. Such delay may have impact on others' ripened rights and may unnecessarily drag others into litigation, which in acceptable realm of probability may have been treated to have attained finality. A court is not expected to give indulgence to such indolent persons who compete with Kumbhakarna or, for that matter, Rip Van Winkle. In our considered opinion, such delay does not deserve any indulgence, and on the safe ground alone, the writ court should have thrown the petition overboard at the very threshold. My Lord, Mr. Bandyopadhyay yesterday had cited an order by which, my Lord, the court had dismissed a writ petition because the challenge was thrown to this particular recruitment process. after a period of 7 years. But here, my lord, the the dispensation of justice, my lord, is done in a totally different manner. My lord, on this point, my lord, I beg to cite another judgment, 1986, volume 4. Volume 4, page 566. I'll read out only one paragraph. At page 594, paragraph 24. Now it is well settled that the power of the High Court to issue an appropriate writ under 226 of the Constitution is discretionary, and the High Court, in the exercise of its discretion does not ordinarily assist the tardy and the indolent, or the accusant and the lethargic. If there is inordinate delay on the part of the petitioner in filing a writ petition, and such delay is not satisfactorily explained, the High Court may decline to intervene and grant relief in the exercise of its jurisdiction. The evolution of this rule, latches and delay, is premised upon a number of factors. The High Court does not ordinarily permit a belated resort to the extraordinary remedy under the writ jurisdiction, because it is likely to cause confusion and public inconvenience and bring in its train new injustices. The rights of third parties may intervene, and if the writ petition is if the writ jurisdiction is exercised on a writ petition filed after unreasonable delay, it may have the effect of inflicting not only hardship and inconvenience, but also injustice on third parties. When the writ jurisdiction of High Court is involved, unexplained delay coupled with the creation of third party rights in the meanwhile is an important factor which always weighs with the High Court in deciding whether or not to exercise such jurisdiction. We do not think it necessary to burden this judgment with reference to various decisions of this court, where it has been emphasized time and again that where there is inordinate and unexplained delay and third party rights are created in the intervening period, the High Court is 1.25 lakhs in making arrangements for putting up the restaurant and the snack bar. Of course, this rule of latches or delay is not a rigid rule which can be cast in a straitjacket formula, for there may be cases where, despite delay and creation of third-party right, the High Court may still, in the exercise of its discretion, interfere and grant relief to the petitioner. But in such cases, where the demand of justice is so compelling that the High Court would be inclined to interfere in spite of delay or creation of third-party rights, would by their very nature be few and far between. Ultimately, it would be a matter within the discretion of the court. Ex hypothesi, every discretion must be exercised fairly and justly so as to promote justice and not to defeat it. Here, obviously, there was considerable delay on the part of the petitioner in filing, etc. The principle is in paragraph 24. Lord, here third-party right has been is affected. I did not emphasize on that. Lord, my first point was making a third case. Second is the second is the delay waiver, etc. And the third point that I beg to take is that now regarding the non-impletement, not a single appointed person has been implemented in the writ petition. Possibly not, no DPSC was also implemented. The writ petition has been filed by persons hailing from different districts. It's a jumbled up petition. But none of the DPSCs is implemented. Now, and the relief granted by the learned court means, my lord, affectation of the settled rights of 36,000 teachers. This is in violation of natural justice.
Yes.
My lord, on this I will cite a judgment 2014 to 2014, volume 16, page 187. Page 187, Ranjan Kumar and others versus State of Bihar and others. My lord, paragraphs 4 to 13. Paragraphs 4 to 13. On a perusal of the orders impugned, we find that only 40 persons who had made respondents before the High Court and hardly a few appointees filed applications for intervention. It is well settled in law that no adverse order can be passed against persons who were not made parties to the litigation. In this context, we may refer with profit to the authority in Prabodh Bharma for the state of UP, wherein a 3-judge bench was dealing with the constitutional validity of 2 Uttar Pradesh ordinances, which had been struck down by the division bench of the Allahabad High Court on the ground that the provisions therein were violative of Articles 14 and 16(1) of the Constitution of India. In that context, a question arose whether the termination of the services of the appellants and the petitioners therein as secondary school teachers and intermediate college lecturers following upon the High Court judgment was valid without making the said appointees as parties. The learned judges observed that the writ petition filed by the Sangh suffered from 2 serious, though not incurable defects. The core defect was that the non-joinder of necessary parties for respondents to the Sangh's petition were the state of Uttar Pradesh and its officers concerned, and those who were vitally concerned, namely the reserve pool teachers, were not made parties, not even by joining some of them in a representative capacity, considering that their number was too large for all of them to be joined individually as respondents. Thereafter, the court ruled thus. The matter, therefore, I quote, the matter therefore came to be decided in their absence. A High Court ought not to decide a writ petition under Article 226 of the Constitution without the persons who would be vitally affected by its judgment being before it as respondents, or at least by some of them being before it as respondents in a representative capacity, if their number is too large. And therefore, the Allahabad High Court ought not to have proceeded to hear and dispose of the Sangh's writ petition without insisting upon the reserve pool teachers being made respondents to that writ petition, or at least some of them being made respondents in a representative capacity. And had the petitioners refused to do so, ought to have dismissed that petition for non-joinder of necessary parties. Then paragraph 5. In the case at hand, neither was any rule nor any regulation challenged. In fact, we have been apprised that at the time of selection and appointment, there was no rule or regulation. A procedure used to be adopted by the administrative instructions. That appointee was not a large body of appointees, but only 182 appointees. Quite apart from that, the persons who were implemented were not treated to be in representative capacity. In this regard, it is profitable to refer to some authorities. In Indushekar Singh, it has been held thus. Paragraph 56 of the judgment is quoted. There is another aspect of the matter. The appellants herein were not joined as parties in the writ petition filed by the respondents. In their absence, the High Court could not have determined the question of interstate seniority. Then paragraph 7. In Rashmi Mishra, after referring to Prabodh Verma and Indushekar Singh, the court took note of the fact that when no steps have been taken in terms of Order 1, Rule 8 of the Code of Civil Procedure, or the principles analogous thereto, all the 17 selected candidates were necessary parties in the writ petition. It was further observed Therefore, my lord, only if order 1 rule 8 principle procedure is followed, then you can choose some of the parties to be made respondents, leaving aside others. But if you do not go by that procedure of order 1 rule 8, then you have to impede them all. It was further observed that the number of selected candidates was not many, and there was no difficulty on the appellant to impede them as parties in the proceeding. Ultimately, the court held that when all the selected candidates were not implemented as parties to the petition, no relief could be granted to the appellant therein. In Trideep Kumar Dingal was the state of West Bengal, this court approved the view expressed by the tribunal, which had opined that for absence of selected and appointed candidates, and without affording an opportunity of hearing to them, the selection could not be set aside. In Public Service Commission,
Yes, we
Yes.
refer to the paragraphs, yes.
Yes, up
We'll
to,
read them.
my lord, up to 4 to 13.
Yes, that's right.
Yes. Now, my lord, kindly take paragraph 22 of the judge. Impugned. In the stay petition, my lord, it starts at the relevant portion. Paragraph 22 and 23. At page 302 and 303. The board shall immediately arrange for a recruitment exercise for candidates who are untrained at the time of recruitment, including candidates who have obtained training qualification in the meantime within a period of 3 months from date, only for the candidates who participated in 2016 recruitment process. Now, my lord, pausing here for a moment. Now, the court says, my lord, that untrained, as if being untrained was something erroneous. Untrained was permissible at the relevant time. Within a period of 3 months for the candidates who participated in 2016 recruitment process, where both interview and aptitude test of all examinees shall be taken, and the whole interview process has to be videographed carefully and preserved. It will be a recruitment process under the same rule and legal procedure under 2016. No new candidate. Then 23. The primary teachers who are employed now in primary schools, against the recommendation of the board in respect to 2016 selection process, shall be allowed to work in the respective primary schools where they are working now for a period of 4 months from date. The judgment becomes operative from the date it is pronounced, and from that date, what will be the fate of the existing appointees at the remuneration equal to a para teacher of a primary school. Therefore, all the 36,000 appointees.
Which means these examinees referred to at paragraph 22 means the whole original lot of examinees, including those who are serving presently as teachers.
Yes.
It is not restricted to this 36,000 at all. What is the meaning of paragraph 22? For a recruitment exercise for candidates who were untrained, which means those who were unsuccessful even at that period of time, they will also be included in this examination.
Exactly.
Not the
not
contrary to what was discussed, not these 36,000 or 32,000. No. In addition to that, all those who are from outside.
As Mr. Tiwari Miller pointed out, your Lordship, 36,000 inside the room.
That's right.
1 lakh outside.
That's right. So therefore, all examinees.
Yes, all examinees.
Who will go through the
But
interview.
no new applicant.
No new applicant who was not an applicant in the 2016. That is the whole point.
But all others who had never had participated.
Not restricted to these 36 or 32,000. Yes, followed.
And then, my lord, what will happen to these 36,000 that is mentioned in paragraph 23, that from today, the date of the judgment.
That is understood.
They will be treated as para teachers.
Correct, understood.
para teachers, they will not get the remuneration of the teacher.
Followed, that is understood.
And after the exercise, new exercise is undertaken, if they do not succeed, their service will be terminated.
Correct.
Therefore, my lord, a settled position is being unsettled by this judgment with regard to 36,000 appointed.
Correct.
Now, I am told, my lord, that later on 36,000 has been amended to
On the
32,000.
microphone, we are your.
To 32,000.
Yes.
I don't have that. I don't have a copy of that order.
We'll ask them. We'll ask them how to, when
Yes.
their turn comes.
আর কি কথা বলছিলে?
Yes.
297.
297. তুমি বলো না। বলো তো। বলো না। বলো না।
Yes.
No, point বলতে চাইছি আমি সেটা জানি না। Now, paragraph 13 at page 297, my lord, this impugned judgment.
Of the
My learned
judgment.
junior, the impugned judgment at page 297 of the stay application, paragraph 13. For a, this is again, my lord, making out a third case on that. For example, paragraph 13 at page 297. For example, some particulars as has been given in the said 121 pages booklet spiral binding, which has been prepared from the particulars published in the web portal of the board by the board. Some candidates' marks are reproduced here in below, which shows that the marks awarded to such candidates whose results are very poor in secondary and higher secondary and also in TET are wholly absurd assessment in interview, and unless some extraneous factors which includes corruption, as has been alleged by the petitioners and now has come to light from the investigation by CBI and ED, nothing to do with the present case, which ED, such absurd marking could not have been made by the interview boards in different districts. While looking for the following particulars, it has been noted by me that in academic assessment and TET, the maximum marks that could be given against secondary examination score of a candidate was 5, and 2, the maximum marks that could be given to a candidate against higher secondary, some of the scores was 10. The maximum marks that could be given to a candidate against TET was 5. Therefore, the maximum marks that a candidate can get against the above 3 heads is 5 plus 10 plus 5 equal to 20. Then kindly turn over. Kindly turn over. Page 299. A list is given of some 20 odd persons. There will not first column, the second column, that gives the academic marks. And that last column, this is the column regarding interview and aptitude test. What the learned judge wants to say here is that those who have not got high marks in the academics have been awarded better marks in aptitude and interview. And this has been coined as absurd, which includes corruption and extraneous factors. Now, Mr. Bandyopadhyay, my lord, yesterday had shown to your lordship from out of his pleadings. He has prepared a chart, which is part of the stay application, which shows, my lord, those who have got higher marks in academics have got 2.5, 3.5 marks in aptitude test and interview together, that out of 10, they got 2.5 to 5 like that. Therefore, this is just picking up a few cases and saying that this is the result of corruption or extraneous reason. That possibly, is not the correct way to assess. And a recruitment process where thousands of persons have been employed and where lakhs of persons had been considered.
Para for 17.
My lord, in this connection, my lord.
How many appeared for the interview and aptitude test?
My lord, 1 lakh plus. My lord, 1 lakh plus candidates, my lord, had passed the state examination. 1,12,000 or 1,25,000. 1,25,000, I am told. The 1 lakh candidates had passed the state examination. Therefore, all of them. My lord, কি বলেছে এখানে? My lord, my learned junior my lord wants me to refer to a judgment on this.
Yes.
The 2009 volume 4. 2009 volume 4 Supreme Court cases, page 516. My lord, I will read out, my lord, paragraph 17 to 21. Paragraph 17 to 21. Having examined the records, the High Court recorded its reasons for striking down the select list as follows. In this regard, we have considered the marks awarded to the candidates who had undergone the selection, and on such consideration, we find that each of the selected candidates has been given very high marks in the interview segment, and it is only on account of such high marks in the interview that the said candidates have been selected. While it is correct that the selected candidates have also secured equally high marks in the written test, we have also noticed that other candidates who have secured equally high and even higher marks in the written test, the selected candidates have fared very poorly in the interview. The scrutiny of the marks awarded to the successful and unsuccessful candidates reveal a distinct pattern. That is, those who have been selected have secured very high marks in the interview, whereas those unselected have secured very low marks in the interview held. Such a uniform pattern, in our considered view, is unnatural, and in spite of our best efforts, we have not been able to persuade ourselves to accept the final result of selection. We therefore set aside the select list, etc. Now, my lord, this is, my lord, after considering all candidates. That was the High Court view in respect of after, my lord, considering all. But here, my lord, in our impugned judgment, before your lordship, the High Court only picked up some 20 odd, and on that basis, my lord, it was there. Now, my lord, kindly count to 18. Even in spite of, my lord, the High Court considering in paragraph 17 the entire records and coming to this conclusion, the Supreme Court observation, kindly note this, paragraph 18. We are unable to appreciate or even follow the reason assigned by the High Court for condemning the select list. In case in Bhaibavosi, very high marks were given to candidates who secured low or very low marks in the written test, that might be a ground for suspicion. But if the candidates securing high marks in the written test were able to secure equally high marks in Bhaibavosi, we are unable to find any anomaly. After all, there has to be some differences between the selected and the unselected candidates. Unfortunately, the High Court has not made clear the distinct pattern it was able to discern from a scrutiny of the marks awarded to the candidates. The selection records are not before us, and we do not have the benefit of its perusal, but we are clearly of the view that the approach of the High Court was quite contrary to law laid down by this court. In Sadanand Halo was Mumtaz Ali Sheikh, in paragraph 49 of that judgment is quoted. Learned single judge in his judgment has observed that as per the report of the amicus curiae, the selected candidates got higher marks in Bhaibavosi, ranging between 30 to 41 marks. In our opinion, this has hardly any effect, and merely because the selected candidates got the higher marks ranging from 30 to 41 marks, that by itself could not be reason to reject the selection. We have extensively referred to the comments made by the learned single judge in the earlier part of the judgment, where the learned judge has in fact recorded his satisfaction for the printed charts and more particularly about their authenticity. The learned judge has also expressed his satisfaction with the procedure adopted. There is hardly any reason given by the learned single judge, excepting that the benchmark of 250 candidates had already been crossed. Then para 58 and 65. of the judgment are also relevant. End quote. Paragraph 58. It is settled law that in such writ petitions, a roving inquiry on the factual aspect is not permissible. Kindly note this sentence, my lord. A roving inquiry is not permissible. The High Court not only engaged itself into a non-permitted fact-finding exercise, but also went on to rely on the findings of the amicus curiae, or as the case may be, the scrutiny team, which in our opinion was inappropriate. While testing the fairness of the selection process, wherein thousands of candidates were involved, the High Court should have been slow in relying upon such microscopic findings. It was not for the High Court to place itself into a position of a fact-finding commission, that too more particularly at the instance of those petitioners who were unsuccessful candidates. The High Court should therefore have restricted itself for the selection committee and also in the process assumed the role of respondents. Unfortunately, the High Court took it upon itself the task of substituting itself, for our opinion, not proper. Thus, the High Court converted this writ petition into a public interest litigation without any justification. Then 65 quoted. We also do not approve the approach adopted by the learned single judge of the High Court as going all the way into the facts and the microscopic details, not via the pleadings of the parties, but on the basis of an unnecessary investigation, not on the basis of pleadings of the parties, but on the basis of unnecessary investigation. We also disapprove of the logic of relying on the findings arrived at only on the basis of sample survey. This is what has been done here, sample survey of 20 candidates out of 1 lakh. Such selection of a large number of candidates would not have been set aside on the basis of sample survey. No evidence was available before us as to the proportion of this so-called sample survey. To the same effect are two earlier decisions of this court in such and such.
Page 150.
Yes.
Just give me 1 second.
This is the definition of aptitude testing. This has not.
We do not think we need more decisions on these points.
No, not on this point.
Aptitude testing. Hold on. Preposition nature, no aptitude test, paragraph 9 and 5. Now, aptitude testing, this is overlapping. Interview, aptitude test, action knowledge. Interview, এমন কিছু question
আপনি বলবে would your lordship kindly permit Mr. Channa to, because he wants to take a point on the very aspect of aptitude test.
On the microphone, yes.
On the very aspect of aptitude test.
Yes.
My learned brilliant lord has found out one judgment.
Yes.
I have not gone through it, therefore, my lord,
Now, your lordships kindly, the aptitude test has been defined in the rules itself. Your lordships kindly take consideration of the rule itself, 2C at page 154. Well, rule 2C at the top at page 154, your lordships will find the expression has been defined. This is the statutory rules. Now, kindly see, aptitude test means a test to assess natural teaching ability of a candidate. Well, the expression interview has not been defined. Well, the aptitude test and the interview was taken by a selection committee by the members of the selection committee. If your lordships kindly take note of the judgment at paragraph 9, your lordships at page 292 of the judgment under appeal. Internal page 5, paragraph 9. Now, your lordships, kindly consider this. In respect of in holding of an aptitude test, the chairman of the board in his report has says the aptitude tests were taken. But from the evidence adduced by the interviewers, Malad, kindly take note of here. Malad, the interviewers means, Malad, though took the interview, Malad, they were chosen by the learned single judge and the deposition was taken by the learned single judge in respect of an interview which took place 7 years before. The candidates, it has been proved before this court that no aptitude test was taken. Malad, apart from its Malad perversity, with all respect to the learned single judge, of this sort of finding by taking the deposition of 7 to 8 Malad interviewers in the process, Malad, this very concept of the learned single judge, Malad, he has not taken into consideration the definition of the aptitude test. All I'm trying to submit before your lordships, by process of an interview, Malad, a question can be put to a candidate by the members of the selection committee, who are called Malad interviewers, which can cover both interview and the aptitude test. Malad, suppose an interviewer, a committee of the selection committee, ask a Malad examinee, please, on a particular topic, explain us how do you teach the students, considering the members as the students. Now, look, this is a natural ability, Malad, is being tested by the interviewers. Now, Malad, these cannot be Malad, considered by the learned single judge in respect of a process of recruitment throughout the state of West Bengal only on the basis of Malad, deposition of 8 to 9 persons and on the basis of the deposition of the petitioners. Malad, petitioners certainly they have come up to Malad undo the entire process. Was done. The persons who were selected, their depositions were not taken. All that I'm trying to say, your lordships, that interview sometimes covers the aptitude test as defined under the rules. The Supreme Court has none of the cases, your lordship says, what is the aptitude test? This is the definition given by the rules. Now, I will be showing one judgment, your lordships, that interview covers the aptitude test also. This is the judgment. If your lordships kindly consider this judgment reported in 1981 4 SCC 158. I'm giving your lordships the legible photocopy of it. 158. The paragraphs are 6 to 9, if I'm not wrong, your lordships. 159. Now, your lordships, paragraph 6. Now, this is commonly known to us, Leeladhar's judgment. It's a celebrated judgment, my lord. Kindly consider this paragraph 6. Thus, the written examination assess the man's intellect, and the interview test the man himself, and the twain shall meet for a proper selection. If both written examination and interview test are to be essential features of proper selection, the question may arise as to the weight to be attached respectively to them. In case of admission to a college, for instance, but the candidate's personality is yet to develop, and it is too early to identify the personal qualities for which greater importance may have to be attached in later life, greater weight has perforce to be given to performance in the written examination. The importance to be attached to the interview test must be minimal. That was the case decided by this court in Pariyakappan versus State of Tamil Nadu and Ajay Hasi and others. On the other hand, this is very vital. In the case of services to which recruitment has necessarily to be made from the persons of mature personality, interview test may be the only way, subject to basic and essential academic and professional requirements being satisfied. To subject such persons to a written examination may yield unfruitful or negative result, apart from its being an act of cruelty to those persons. There are, of course, many services to which recruitment is made from younger candidates whose personalities are on the threshold of development and who show signs of great promise, and the discerning may, in an interview test, catch a glimpse of future personality. In the case of such services where sound selection must combine academic ability with personality promise, some weight has to be given, not no much to great weight to the interview test. There cannot be any rule of thumb regarding the precise ways to be given. it must vary from service to service according to the requirements of the service, the minimum qualification prescribed, the age group for which the selection is to be made, the body to which the task of holding the interview test is proposed to be entrusted, a host of other factors. It is a matter for determination by experts. It is a matter for research. It is not for courts to pronounce upon it unless exaggerated weight has been given with proven or obvious oblique motives. The Kothari committee also suggested that in view of the obvious importance of the subject, it may be examined in detail by the research unit of the Indian Public Service Committee. In this background, let us now examine the situation presented by the Rajasthan rules. The Rajasthan Judicial Service rules have been made by the Governor of Rajasthan in consultation with the High Court of Rajasthan and Rajasthan Public Service Commission. The High Court may be expected to know the precise requirements of the judicial service of the state and the caliber of the available source material, while the Public Service Commission is an expert body thoroughly conversant with the recruitment policies and selection methods. Both the High Court and the Public Service Commission are independent bodies outside executive control, occupying special positions, enjoying special status under the Constitution. Neither is an outstanding agency. Both are well acquainted with the particular needs of their state and the people. If the governor, in consultation with the High Court and the Public Service Commission of the state, makes rules stipulating 75% of the marks for the written examination and 25% for the interview test, on what basis can a court say that the 25% for the interview test is on the high side? It must not also be forgetting that the interview test is generally conducted, and was in the present case conducted, by a body consisting of the judge of the High Court, chairman, and a member of the Public Service Commission, a special invitee expert. There can surely be no legitimate grievance or hint of arbitrariness against this body. Yet another factor worth of consideration is that candidates expected to offer themselves for selection are not raw graduates freshly out of college, but are persons who have already received. Then your lordships kindly consider the paragraph, my lord, the 9, your lordships. This second ground of attack, paragraph 8, my lord. The second ground of attack must fail for the reasons as the first ground of attack. The rules themselves do not provide for allocation of marks under different heads at the interview test. The criteria of the interview test has been laid down by the rules. It is for the interviewing body to take general decision whether to allocate marks under different body. Well, this is also not here so relevant, your lordships. Kindly come to the paragraph 9 itself. Both cases cited before us, Periyakappan and Ajay Hasia, were cases of admission to colleges. We have already pointed out that the provisions for marks for interview test need not and cannot be the same for admission to the colleges. Now, in fact, the Periyakkan case, even in the case of college admission, the court observed, while we do feel that the marks allotted for interview are on the high side, it may be appropriate for the government to re-examine the question. We are unable to uphold the contention that it was not within the power of the government to provide such high marks for interview, or that there was an arbitrary exercise of powers. Now your lordships will find.
So what is the point you're trying to make?
And the point to trying to make out, your lordships, that just giving you. Now, so for the interview test,
the facts of this case, with the what is the point you're trying?
The interview and aptitude test was taken by the same interviewers, by a selection body. Interview also, my lord, considers a person may be theoretically sound, but evaluated on the basis of written test. Whereas interview assess the candidates on other facts: his alertness, his resourcefulness, his dependableness, his cooperativeness, clear and logical presentation, and capability to interact and discuss. My lord, what are the points before the learned single judge that aptitude tests were not taken? By examining 7 or 8 interviewers and some of the petitioners. My lord, there were 700 selecting committees were there throughout the state. My lord, suppose in the case of a particular interviewer, a question was put up which was combined, both can serve the purpose of interview and the aptitude test. My lord, it was for the court to decide that the aptitude test was not at all taken. My lord, therefore, these judgments shows, my lord, what is the purpose of the written test and what is the purpose of interview, which covers, my lord, both the aptitude test
Yes,
and
that'll be. Yes, anybody else on?
Submission from our side is okay.
Yes. Yes, Mr. Bandapata, anything more after yesterday or?
My lord,
You have anything more
yes,
after?
yes, I didn't complete yesterday.
Well,
My lord, the list of. My lord, I have placed the facts to your lordship's, my lord. The list of that. My lord,
Which is
yes,
your appeal number?
my lord, appeal number is 890 of 2023. 890 of 2023.
Yes. এটা একটা কাজ করো, ওটা এখানে রাখো। এটা ক্ল্যাম্প দাও। এটা রেখে দাও।
এখানে সব বই।
এই নাও।
যা কিছু এখানে
ওই ক্ল্যাম্পটার সাথে এগুলো একসাথে রাখো, এখানে সাজিয়ে দাও।
My lord, 890 of 2023. Each. My lord, I have brought today a short list of dates, my lord,
Yes.
so that I am not required to go to the pleadings, etc. My lord, kindly take this list of dates will be very clear. 1, 2, leave aside serial number 1, 2.
Please give a copy to Mr. Tiwari.
After that.
Yes.
Third, 26 September 2016 advertisement was published. And that is the most, my lord, the important aspect in this matter, which I have pointed out to your lordships, my lord. Kindly recall, my lord, page 230, lordships, kindly come to page 230. That's a very important, which, my lord, the learned single judge has missed it. (230) 3 note 1. The persons qualified test and having qualification of a higher secondary pass under the West Bengal Council of Higher Secondary Education or its equivalent with at least 50% marks of graduates irrespective of marks obtained without 2-year diploma in elementary education by whatsoever name known in accordance with the National Council for Teachers recognized so and so shall also be eligible to apply for appointment of primary school teachers in the states, subject to condition that those who will be appointed without professional course shall acquire the professional and qualification within a period of 2 years. Now, this now has become very important by reason of the paragraph 22 of the judgment. I will show to your lords. Therefore, this is not the case that only the trained teacher will be appointed. Untrained teacher also can make the application and their applications can be considered. If they are appointed, they have to acquire the qualification within a period of 2 years. My lord, I have shown to your lordships this notification that is at page, last notification, that's at page 238. 238 to 221. My lord, kindly remember these dates when I will make my submission. So for paragraph 22, I will, my lord, kindly remember this date so that 238, kindly see 3rd August 2017. This is regarding training of untrained in service elementary teachers in the government unaided private school. It is apprised that the amendment to the section 23 subsection 30 to extend the period such training to 31st March 2019 has been passed by the parliament. Now, my lord, the 230-41, another important aspect, kindly see, 3rd October 2017, 241, 3rd October 2017, start of the course, first term 3rd October 2017 on 18 June 2018, second term 25th June 2017 to 31st March 2019. Therefore, these semesters, the persons, why I am praising, my lord, I am giving an emphasis here. 31st March 2019 is the last date. Thereafter, no untrained teacher can be and can be given any chance to appear in any examination. Kindly see.
cannot be given any chance.
কাজ হচ্ছে বন্ধ করতে বল।
But this is, after this, no one can be granted. By this time, we have acquired our respective qualification. Now, my lord, kindly consider, my lord, the very important aspect, what the learned judge has done. The learned judge, by paragraph 22, allowed everyone who made application untrained to appear again. Therefore, untrained, just I am giving, untrained. Why this paragraph 22 is absolutely bad? Untrained cannot appear after 2019. Statutory. Therefore, the learned single judge, in an indirect method, making the candidates as competent one to appear against the statute. Yes. If no one has acquired the qualification, then they cannot. And yes, admittedly, the writ petitioners have not acquired the qualification up to 2019. There were those who are ineligible by virtue of this judgment will become eligible and continue to the statute.
কি হচ্ছে এটা কি বিমল? একে ডাকো, বিপ্লবকে ডাকো, এক্ষুনি ডাকো। Yes, please continue.
My lord, kindly, I just give 3 dates. My lord, 2016 selection process is challenged. Right, my lord?
Yes.
Thereafter, 2020, my lord, selection has been undertaken. 2020 selection process, my lord, no untrained teacher was allowed to appear. The writ petitioner could not become successful even 2020. Leave aside 2016.
Yes.
2021, 2022, 2020 result was published in 2022, 21, and 16,000 have been appointed after us. These players have not been appointed. 2022, another selection process has been undertaken. That result has not yet been published. Therefore, those who have become ineligible on 31st March 2019, they who could not make their application in 2021 and 2020 and 2022 by reason of the default clause, they have been made eligible by the learned single judge.
Yes.
Apart from my other arguments, I will argue.
Yes.
Then what is the benefit these writ petitioners will get? If it is held to be bad, first of all, the learned single judge, by the judgment impugned, not directed to the board to give them appointment.
Yes.
Therefore, appointment has not been given. If they have been given the appointment by the court, I don't mind. What I am having, the board will take care about that. Not given the order appointment. Secondly, ineligible candidates in today has been made eligible for consideration. They are completely bad. What is the writ petitioner's gain? I will come to my right. What is gaining?
Yes.
It's a gaining, nothing. Apart from the arguments what Mr. Gupta has made it beyond the prayer, etc., leave aside that. Now, kindly come to list of this now.
Yes.
Now, 19th October 2016, applicants were called for scrutiny, verification, and interview aptitude test. I have shown 31 to 37. I have given the pages. I am not repeating today. 11th February, two applicants were given appointment as assistant teacher on probation for 2 years from the date of joining by the respective district primary school council. So mentioned in Senapon, later happened that the service will be regulated by ratio 52 to 58. But I am not pressing today itself again. Shall I press it, Mullah?
That's all right.
Not all right. Mullah, then 3rd August 2017 circular already happened. 22nd May 2019, applicant received the final marks sheets and certificates for duly completing diploma in electrical insurance or DLED 59 to 72. I have given the certificate, I have acquired. Then, Mullah, 22nd November 2019, applicants upon completion of the DLED course was granted the training benefit by the respective district primary school. 22 to 229. 3rd December 2019, after satisfactory completion of 2 years of service, the service of the applicants were confirmed by the respective district primary school council with effect on 2 years after the respective dates of joining.
Yes.
Then, 10 December, Justice, Honorable Justice Origins Banerjee, yesterday I have placed it before the Lordships to dismiss the writ petition on the ground that parties have not been, necessary parties have not been made. It's a nullity. It would be a nullity.
Followed, yes.
And 2019 judgment. Then 12 September 22, this writ petition has been filed. Prayers have been already been made, placed by Mr. Gupta. I am not repeating. Then 23rd March 2022, Honorable Justice Hiranmay Bhattacharya dismissed a number of petitions. And Justice, my Lord Mr. Justice Origins Banerjee also dismissed a number of writ petitions. Then, this allowed by the learned judge, 12 May 2023. Now, I come one after another. I will not repeat this much, but I have to touch it. First of all, the grounds of delay which has been taken by the Mr. Gupta, I will give a one constitutional bench judgment. 1975, volume 4, SCC, page 285, paragraph 1. Paragraph 1, paragraph 11. Paragraph 11, दाओ जोसेफ पे दाओ.
1975.
सुने ने भाई, बार-बार एवं जिज्ञेस क्वेश्चन, please have your mind concentrate, and then please don't disturb. Otherwise, later on you will take the. Concentrate yourself, you will get it. 75, 4 SCC 285. See 5 judges bench judgment, constitutional bench judgment. Come to paragraph 11. Now, do you think that the petitioners in the writ petition should be allowed to raise this plea in view of their conduct in not challenging the validity of the notification even after the publication of the declaration under section 6 of in 1966? Of the 2 writ petition, one is filed by one of the appellants. There are apparently no reason why specified. A valid notification so I'm initiating a proceeding for recognition to have set on the fence and allow the government to complete the acquisition proceeding on the basis of the notification and so and so is valid, and then to attack the notification on grounds which are available to them at the time when the notification was published to be putting a premium on dilatory tactics, the petitions are liable to be dismissed. We are sitting on the fence right from 2016 to 2022. You have not given any reason in the writ petition why there is a delay.
Yes, followed.
But I tell you, Lords, I very honestly, I am submitting to your Lords, very candid I am so disheartened that the West Bengal Primary Board should have on the very first day raised the point before the learned single judge. I am a victim of everyone. Board will not take steps. Court will go against me. I will not be party.
I do not know. Board will not tell before the court, argue. I have become victim. Tick, 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 tick. You know that tick, tick? It is tick, tick. Therefore, I have become victim. I would have been happy to see that the board was serious. Now, this is the judgment. I will not. There are other judgments I have brought today, but I will not cite on this point because Mr. Gupta has cited this judgment. I do not want to repeat. But constitutional bench judgment, I have placed two words.
Yes.
Next, Milord, the point I am coming, that's all. But very interestingly, I will show to you lots of the judgment. This is, Milord, ILA 2003, Karnataka 3806. Milord, the judges who are there, yes, yes. See, my lord, Justice Ravindra and Justice Najir, ultimately who became, who, copy dao.
Minimal SJ, Viplov SJ.
This is mixed up with the things. Kindly just. Milord, kindly share it, Milord. Milord, kindly come to the propositions of law. Let's come. Let's see what is the law. Paragraph 16. Milord, here the case was, of course, a promotion. Allegation was that fraud, etc., malpractice, all that allegations were there. Similar. The principles relating to promotion based on examination can therefore be summarized thus. The examination result of a candidate published and given effect cannot be altered, while the candidate is not guilty of malpractice or misrepresentation or any blameworthy conduct. Am I? Anywhere? No. B. Where there is no fraud or irregularity in the conduct of examination or evaluation of tabulations. C. Where the rules do not provide for change of results on the basis of review or evaluation of the answer scripts. But kindly come to Roman 3. But where there is a fraud or irregularities in the conduct of evaluation, tabulation, or malpractice, or when the conduct on the part of the candidate himself, the result of an examination can be altered. These are principles. Where is the findings of the learned single judge that because of our fraud, because of our conduct, because of our blameworthy conduct, the result is violated. Somewhere Pacho Chatterjee is arrested, Manik Bhatta is arrested, others have arrested, corruption in the heads of the learned single judge from, I will show to your lordships, my lord, from the judgment, every step, every breath he is talking about the corruption. Where is this finding that this corruption has been made by us? Where is this evidence before the learned single judge? Where? My lord, this is a basic principle. This is the basic principle to disturb any result of a selection process, my lord. And not a single anywhere the learned single judge has come to the finding that because of us, because of the candidates have committed fraud, candidate has committed illegalities, candidates have indulged malpractice. No finding against her.
Yes.
Therefore, if this finding is not there, the result cannot be changed.
Yes.
Cannot be, court should not have interfered with. These are the basic principles. Now, my lord, come, my lord, this, ওটা দে তোমাকে এই judgment 2000, my lord, 2011 1 SSC 150 selection process. Judge Sahib Khatam. My lord, kindly take, my lord, 2011 1 SCC page 150.
Yes.
My lord, kindly come to, my lord, paragraph 24 and 25. Right or no? Paragraph 24 and 25. Kindly come, my lord. When the list of successful candidates in the written examination was published in such notification itself, it was also made clear that the knowledge of the candidates with regard to basic knowledge of computer operation would be tested at the time of interview, for which knowledge of microscopic system with office operation would be essential. In the call letters also, which was sent to the applicant at the time of calling him for interview, the aforesaid criteria was reiterated and spelled out. Therefore, no minimum benchmark or new procedure was ever introduced during the midstream of the selection process. All the candidates, all the candidates knew the requirements of the selection process and were also fully aware that they must possess the basic knowledge of computer operation, meaning so and so, so and so. Knowing the said criteria, the appellant also appears in the interview, face the questions from the expert of the computer so and so, and has taken a chance and opportunity therein without any protest at any stage, and now cannot turn back to state that the aforesaid procedure adopted was wrong and without jurisdiction. In this connection, we may refer to the decision of the Supreme Court, wherein also a similar stand was taken by a candidate that the Supreme Court had declared that the candidates who have participated in the selection process cannot challenge the validity of said selection process after appearing in the section and taking opportunity of doing so and so. Well, this is well settled. This is well settled.
Yes.
Now they have participated, declared, they know they did not become unsuccessful, they know what are the rules, they faced the interview, they did not come, they have come after 6 and 4. I am not using any other word and expression.
They went up to the aptitude test.
Malad?
They participated up to the aptitude test.
Only one test, aptitude test,
Yes, and
interview and aptitude test.
And then they were unsuccessful.
They were unsuccessful. Waited. My lord, kindly excuse me, my lord.
Yes.
My lord, there is an expression, legal expression is, no litigant can be forum suffers.
Other forum কোথায়?
16 to 2022, only one, no one. Huh? After 2022, quorum has been available. Huh?
Next judgment.
Yes. But on this point, another judgment is 2014, volume 4 SCC. No, this is not required. Just leave it. Now, I am coming, very interesting. Justice Orijit Banerjee has held it. It's a violation of a natural justice.
Yes.
Look, will be doing 2016 and 2022. Justice Orijit Banerjee dismissed. I have not come. It will be dismissal. No. 2019, 2020. Justice go. Now.
Next decision.
Next judgment. I will show to you lordship one.
Next.
On the point of delay, all settled law, principles of natural justice, all settled law. I was referring to yesterday, Lord Justice Ayat. Question is whether any maybe something may come in the meantime. The Mr. Theory was saying this. Yes. Now, Krishna. Malad, Joseph Kedao. Justice Ayar has held. And that too, it is also a constitutional bench. 1980, volume 3 SCC, page 719. My lord, come to page 722. 722, lots of come.
Yes.
Read from him, Lord, first, second, third, fourth, fifth, sixth, seventh, eighth line from the bottom.
Yes.
Ninth, 10th line from the bottom. The decision binds on the simple score of state diseases and the constitutional ground of Article 141.
Yes.
Every new discovery or argumentative novelty, can market.
Yes.
Argumentative novelty cannot undo or compel reconsideration of a binding precedent. In this view, other subdivisions sparkling with creative ingenuity and presented with hyper pressure advocacy cannot persuade us to reopen what has been laid down in the guidance to answer. What is the proposition? Proposition is well settled principles of law cannot be reopened because of some new facts or novelty or arguments pressure. Mr. Theory's pressure, learned counsel's argument pressure. Although I don't find from the judgment that Mr. Theory has argued these points or others. I don't find.
Yes.
No, judgment bolchi. That is not a part of the judgment. Judgment in the judgment I don't find. Therefore, nobility to find out a fact by the learned trial judge, learned single judge, cannot change the binding precedent.
Yes.
Possibly, my lord, I am clear to your lordship on this point.
Yes.
My lord, one judgment on natural justice, that's one of my favorite judgment right from my childhood in the profession. Kindly similar. 1986 4th Supreme Court cases 537. Institute of Chartered Accountant and L.K. Ratna. Kothay Kishore kothay? My junior Mr. Doctor knows how many occasions I have cited this judgment. And whoever comes to my chamber, as a junior, I tell them to read few judgments, and one of that judgment is this one. Milord, kindly come to Milord. Paragraph. But kindly read this court portion. Before that, some of those cases, as mentioned in Sir William Wade's erudite and classic work on the administrative law on 5th edition. But as the learned author observes, in principle, there ought to be an observance of natural justice equally at both stages. And kindly read this. If natural justice is violated at the first stage, the right of appeal is not so much a true right of appeal as a corrected initial hearing. Instead of fair trial followed by appeal, the procedure is reduced to unfair trial followed by a fair trial. Then, Milord, if one accepts the contents of the same, Milord, I will not, Megari in Leary versus National University and so. If one accepts that the contents and that the defect of natural justice in the trial body can be cured by the presence of a natural justice in the appellate body, this has the result if depriving the member of his right of appeal from the expelling body. If the rules and the law combine to give the member the right to fair trial and the right to appeal, why should we be told that he ought to be satisfied with an unfair trial and a fair appeal? Because, my lord, if an unfair trial is there, is it an unfair trial? We give whether the opportunity of hearing has not been given, is it a fair proceedings? If there are unfair proceedings, unfair trial was before the learned single judge. No. Let me deliver my judgment if you are agreed.
then you can't go for the appeal.
Yes.
Well, I have not been allowed to cross-examine any of the petitions. What more? Although I submit under section 165 of the Evidence Act, 65 doesn't apply in the proceedings then. But remember one thing, no one has raised the questions to the witnesses. Learned judge has raised the questions, took the role of the prosecutor, and well-settled principles, where prosecutor cannot be the judge of his own cause. Everywhere there is a breach. Now, kindly come, next judgment is precedented now. 2010-SCC 5. 2010-SCC. Take this one. 2010, volume 13, SCC, page 771. Oh, sorry. 336, sorry. 336. Kindly come 336, 2013, 33 paragraph, 16, 17, and 19. It and na lagche. Kindly come to paragraph 17. A coordinate bench cannot comment upon the discretion exercise or judgment rendered by another court of the same court. The rule of precedent is binding for the reason that there is a desire to secure uniformity and certainly in law. Thus, in judicial administration, precedents which enunciates the rule of law from the foundation of the administration of justice under our system. Therefore, it has always been insisted that the decision of coordinate bench must be followed.
Yes.
Rather, so and so coordinate takes the same view as so and so. This is the principle.
Yes.
Now, here you will find, although Mr. Dotto placed the judgment before the learned judge, showing that Justice Orijit Banerjee's judgment and Justice Hirama's judgment, how the comment has been passed by the learned single judge. No, these are the niceties, the questions of the niceties. Are there law? High Court is being for that, for deciding the niceties, questions of law. High Court is not for that, for making a mockery of all the backing. I can't run with your lordship now.
Neither can I. Yes.
No, that's no. I am saying that what more speed? Vande Bharat is not going with my speed. Same principles. 2007 10 SCC page 201.
Yes.
Same principles. Same principles. Kindly come to me, Lord. Paragraph 14. Lord, paragraph 14. The High Court and only a occasion consider the very issue relating to so and so. The High Court negative the said contrary. The High Court, apart from the above, there is no inconsistency. This is given. Then we have followed this. Kind of see here is very interesting. What the High Court has done, your lordship, Bombay High Court, there was a judgment of the Bombay High Court, and there was another judgment of the Kerala High Court. The later bench said, no, I will not follow my Bombay High Court's earlier judgment. I will follow the Kerala High Court judge. Supreme Court has said, no,
you have to follow your own High Court judgment first. Kindly see. Kindly come to 210, 12, last line. Both the two contentions were considered rejected merely because the Kerala High Court had accepted the clarification of the Bombay High Court could not have ignored a binding precedent of the coordinate bench. If it wanted to take a different view, judicial propriety required that the matter be referred to a larger bench. That we find it difficult to sustain the reasoning of the High Court in judgment. There were no, you have to follow your own High Court judgment. You can't follow the another High Court judgment. Here, this idea is not coming here. Two judgments are there, you are not follow. Because I am an innovative character.
Got the point.
That's it. But kindly see the judgment first. Kindly come to paragraph. Shall I give from my reference or your losses are looking from there? Marked it. But I have in my copy, it is page from 81. What was passing on of your losses? Kindly see. Sorry, just before the judgment, one add-on, very important. Sorry, Millard, kindly excuse me. Kindly come to paragraph 20, page 43, which I cited.
Of the judgment.
No, sorry, Millard, kindly stay petition, kindly. Then I will make my legal arguments on that based on the reading. Page, kindly see, Millard, page 43. Page 43. Page 43, kindly come to page 44. See, my lord. 1, 2, 3, 4, 5, 6, 7. I have given. The learned judge was proceeding on the basis that you see those who are not having an educational qualification, good qualification, those who have got lesser marks, but you have given the higher marks in an interview, picking up 20 cases. See, I have given. Similar, 1, 3.6 for total marks, academical 15.722. How much I have got in the interview and appraisal? 2.5, 2.55. Then we have 3.7 to 10.12, 4.33. Total marks 10.12, 4.33, 4.6, 5.99. I have given a chart C. Total marks last 6, similar 6. 16.202. Academical.
Yes.
Put it down. 1 mark. Wow, 16.202. And interview mark 5. Where from the learned guy has got it by testing few cases as given by the representatives. Those who have got less marks, higher educational qualification, they have been given much marks in the interview. No court should proceed on the basis of any presumption.
Yes.
See, I have given it. I will. 912 appeal 910 Milord MAT 910 take to work memo dorkan stated in
yes,
my lord, I will show from my another appeal very interestingly just for the purpose of the number. My lord, I want to show. See 910 page 50. Is it proper? Is it proper for the learned single judge to do such an injustice to us? क्या बोले जो पिटिशनर ताते ही जी मतलब kindly come to page 50. See, similar serial number page and edition. Must come to serial number 7, page 50. Total marks 12.119 on higher educational qualification. Interview 1, aptitude 1, 2. Then I got 14.119. It's not that case, my lord. that in every cases the interview marks have been given higher. Kindly come to me, Lord, serial number 20. Interview marks 2.24. Kindly come to me, Lord, serial number 21. 1.1, 1.12. Kindly see 222, 1.5, 1.53. Then Lord, 24 and come to serial number 30. About these presumptions of the learned single judge, my lord, with great respect.
Yes. That will be all, Mr. Bandyopadhyay.
I am just, I will come back to the original one. I'll be finished very quickly. My lord, come to this judgment, my lord. See why I am placing it. My lord, everywhere, if you read your lordship's this judgment, kindly come to take my brief, this petition, page 89, serial number, page 9, judgment. Something suspicious. ওইটা দিয়ে দাও আগেরটা
89, the other one we have.
Yes. Otherwise, all are similar to only for similar. Everywhere there was suspicion in the mind of the learned single judge. Can a suspicion is the basis of a judgment?
Yes.
Kindly come to 89, paragraph 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal and the false exercise to hoodwink all concerned, including the court. What is this? Now, Lord, kindly come to paragraph 12. In support of their allegations as to corruption in awarding marks in interview, that has not been pleaded. That is not the case. What the corruption has been established in this case, my lord? Where? Every sentence, every word to prejudice to every person, the learned single judge in every paragraph have used the expression corruption, selling, just to prejudice to the person, not based on any legal reason or not based on any legal evidence. Now, see, page 90, kindly come. Paragraph 13, read. Foreign staff party as well as 14 against 120, so and so. But the candidates whose results are very poor in secondary, in higher secondary examination, and also in state are wholly absurd assessment. Testing 22 cases, 21 cases. You are commenting on selection of a 36,000. And I have given this. See, although I have acquired higher education qualification marks, I have got only one in the interview. Now, my lord, kindly come. My lord, page 91, paragraph 14, the so far examination is concerned. Mr. Kaur will argue, I will not touch the point, section 165. Now, my lord, see, my lord, come to paragraph 17. What is this? At least this petitioner, at least, my lord, this petitioner, these parties are required to appear in the test examination or not, that your lordships will decide. But after reading of this judgment, at least I have come to, if it is correct, my lord, I have come to my opinion that I have to take again admission in the law class. Page 93, paragraph 17. From the gross illegality in the selection procedure in the recruitment conducted by the board, is clear that the board and its officials, including its former president, who is now in custody, is it relevant? In custody, after arrest by enforcement department for transaction of huge money, in the recruitment procedure conducted the whole appeal like affairs of local club, and now it is gradually coming to light by investigation of enforcement directorate, the jobs for primary school teachers were actually sold to some candidates who had the money to purchase the employment. A corruption of this magnitude was never known in the state of West Bengal. Is it relevant anywhere? Any report, any evidence, anything? Learned judge may have decided any matter in another proceeding. That decision, observation, everything should restrict it to that matter. who can't bring it, a judge cannot bring evidence of one matter, fact of one matter, his opinion in one matter to another matter which is hearing, which has no connection at all. I can understand, my lord, there was a legal evidence was there before the learned single judge. Learned single judge could have come. Therefore, this findings is, with great respect, is perverse, based on no evidence. And what I was telling you, Lord, everywhere and everything, shop, everything, scam. Learn, money looking, Bhattacharya arrested, money Bhattacharya arrested. Therefore, everyone has to be gone. This is not the law of the land. This may be one individual perception. This cannot be said in the court of law. My lord, yesterday when this matter was going on, very unfortunately, see, my lord, see this. Does it hurt us or not? See, this is the, see, this is the Justice Gangopadhyay was making this comment. Come to me, Lord. Come to me, Lord. Last page.
Mr. Bandyopadhyay, let us stick to the facts of this.
That's it. Let's see. That the corruption. What I am on, a judge has to decide the case on the basis of the facts and evidence produced before him. He cannot go on. He cannot say anything.
No, we will confine ourselves to the facts of this.
These findings are totally illegal. Sorry, this is incorrect. Not illegal. I'm sorry. They are totally incorrect. Not based on facts. So far, now consider, not just, I'm finished. The two aspects I will tell you lots of benefit. See, right from 2016 to 2022, 23, 7 years, have I acquired a right? Have I acquired a right? Can my right under Article 21 can be taken away by any court in this process? One of the paragraphs I have written here, 2016, 2016 after their appointment, after appointments of ours, my lord, we have also settled in our family life. Someone is having one child, someone is having 2 children. Justice is not one-way traffic, my lord. Justice is 2-way traffic. You are this 36 into 5. How many persons will be the affected? They will not be able to. Why?
Yes.
Concept. Yes. They will livelihood. They will have to be strict. Not considered. And these persons have not acquired the right. I have a right. Now, my lord, very interestingly, I will show you this one thing. I know, my lord, just one to two, 2009, 5 years. Is it a civil proceeding? Whether writ proceeding is a civil proceeding or not. The civil in character is not a criminal court. If this writ proceeding, writ court is not a criminal court. 2009, 5 years. 5 years, so 5 to 8. 1 line. Yes. Basic law, my lord. Again, I repeat, this is the High Court which decides the niceties questions of law. The High Court doesn't decide on facts who is having tears on the street. Kindly come to me, lord. Paragraph. That cano gulmal kochis tu yam ko bolte 5 to 8 kochis tu. 5 to 8 will not kindly come to paragraph 24. Kindly come to paragraph 24. So why I am showing to you lots of very basic foundation. Leave aside everything. If primacy is to be given to a criminal proceeding indisputably, the civil suit must be determined on its own merit, keeping in view the evidence brought before it, and not in terms of the evidence brought in the criminal proceeding. The question came up for concern. Therefore, evidence, even leave aside everything, report, etc.
Yes.
Therefore, even an evidence produced in the criminal proceeding, proof facts cannot be brought into a civil proceedings. It has to be proved there.
Follow.
Therefore, the learned judge was something in the mind that the CBI ED want more finished. 2020, very fundamental principles, my lord. 2022. This, my lord, knows all this bunch of law. I know, but my job is to just to remind nothing more than that. Nothing more than that. A lawyer's role is that. 2022, volume 12 SCC, to judge ke dena. 2022, volume 12 SCC, 200 paragraph 27. Kindly come. Kindly come. This will be my last judgment.
Yes.
Let's understand. Eta to no? 27. No? Time 27. Take extreme case. Here no report, nothing is there. Take an extreme case. Report under section 173 subsection 8 has been filed. Read, Milord. Section 173 to CRPC calls upon the investigator to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer on the materials collected by him. He takes note of the offense and thereafter conduct an investigation to identify the offender, the truth of which can only be decided by the court. The aforesaid conclusion lead to the position that the evidence of the investigating officer is not indispensable. The evidence is required to be corroborated in the contradiction of the other material witness, as he is the one who links and presents them before the court, even assuming that the investigator has not deposed before the court or has not cooperated and accused not its answer. Therefore, like a report. Let's assume any report, CBI report, ED report, whatever the report. This report cannot be taken as a consideration, not as an accepted evidence. It is an opinion. It has to be proved. Whether Partho Chatterjee arrested, Manik Bhattacharya arrested on the ground of this CBI report, that will be tested in the CBI, in the criminal court. Unless it is proved, it cannot be said that the report is sacrosanct, and on the basis of the report, 36,000 teachers' appointment cannot be annulled.
Followed. That will be all.
I'm so grateful to you.
Thank you. Yes, Mr. Kaur.
With your lordship's leave, may I come up after 5 or 10 minutes?
Yes.
Let
Any additional points?
yes,
Any
but
additional
only I'll touch on the only additional point. Not repeat anything which my learned friends have already addressed to your lordship. My first point that I wish to take, apart from the points which are already there, that this writ petition ought not to have been entertained by the learned judge.
Your appeal number is MAT?
Kindly, Lord, 874, MAT 874. If your lordship's kind enough, Lord, to take the
It clamp it off.
Lord, if your lordships kindly take the stay petition and come to page 148, which is the writ petition.
Lord, kindly take the writ petition. It starts at page 148. I'll just Lord quickly run through some of the paragraphs. Please come to para 7 at page 149. Lord, paragraph 7, your petitioner states that on 11th of October 2015, date 2014 examination held in West Bengal, where huge number of students appeared. It is needless to say, on the date of examination, the notification issued by MHRD, Government of India, was in force, and all the students who passed or qualified in TET 2014 should get benefit of the notification dated 9th April 2015. Then, Lord, please come to paragraph 8. Your petitioner states that on 2nd March 2016, West Bengal Primary School Teachers Recruitment Rules 2016 was notified, and Rule 6 of the said notification speaks about qualification of the person who are seeking and are eligible for appointment. Clause 6, subclause 3, some specific guidelines are there for non-trained teachers. It is needless to say that all TET 2014 candidates are entitled to get benefit of this instant rules and notification issued by MHRD, Government of India. Then copy of the West Bengal Primary School Teachers Recruitment Rules. Then Lord, please come to paragraph 9. Your petitioner states that on 14th September 2016, the result of TET 2014 was published, but on merit list and scorecard was given, no merit list scorecard was given. On 26 September 2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. It is needless to mention that MHRD gave relaxation only till March 2016, and in spite of that, the board notified that the candidates who do not have trained will be considered too. The notification proves that the board decided to give benefit to the relaxation to all TET 2014 candidates, qualified candidates. Now, Lord, just pausing here for a moment. Up to TET examination, therefore, there is no difficulty. The difficulty is that who will get a chance to appear, because, Lord, according to the notification, it says that qualified persons, that means trained, will be admitted first, and then, Lord, untrained will be considered. Now, this is not paragraph 9. Now, Lord, I just want your lordships to straight away come to page 151. That is part of paragraph 10. Please come to page 151. Kindly, Lord, take about 9 lines from the top. The sentence starting with the word on 4th February 2017. Has your lordship found that? List of non-trained candidates other than Bengali medium was published. And on 8th February 27, list of non-trained candidates and candidates from Bengali medium were published. From the dates and the list, it is clear that all trained candidates of TET 2014 were appointed through the first list, and after completion of the same, as per notification dated 2nd March 2016, the board appointed non-trained candidates. The board stated that they shall publish more lists, but those lists were not published. The problem starts here, according to the writ petitioners. Then, Lord, please come to the last 3 paragraphs, 19, 20, and 21. These are the 3 paragraphs on which, Lord, I heavily rely. In the whole of writ petition, your lordships will not find any grievance with regard to the appointment which has process which has been completed. They are complaining about the fact that after completion of the appointment procedure, no further candidates have been called, untrained candidates. Then, Lord, please come to paragraph 19, 20, and 21. These are the 3 paragraphs, Lord, I would request your lordships to kindly consider.
Yes.
Says, your petitioner states that your petitioners are hailing from poor families, and if they were recruited in time by giving them opportunity of being trained, then this complex situation could have been avoided. The West Bengal Board of Primary Education put the petitioners from a bad situation to worse situation. The relaxation which was given to the candidates who were appointed in 2017 from TET 2014 could have been given to the present petitioners. Lord, kindly mark this.
Part 2, but the same was not done by the department for the reasons best known to them. The board recruited only trained candidates from TET 2014 qualified candidates post 2019 and completely ignored the petitioner. Now, Lord, please mark this. From 2019, there was a recruitment and only the trained candidates were recruited.
Yes.
However, the board flouted the NCTA guidelines on repeated occasion, and from the very first recruitment, the same was flouted, etc. Then 20. Your petitioner states that your petitioners are praying for equality before law and equal protection of law. Huge number of non-trained candidates were appointed by the board, and when the petitioners are seeking the same benefit, the board is saying that NCTA guidelines is against them. NCTA guidelines was there since 2016. And if TET 2014 qualified non-trained candidates can be appointed in 2017, then there should be no bar in appointing the present petitioner. Then 21, your petitioner states that the complications arose for the illegality and delay committed by the board, and for the fault of the board, the petitioners cannot be held liable. On the day of the petitioners gave TET 2014 examination, there was no specification about compulsory training, and the same cannot be applied prospectively by the board on these petitioners. The qualification or appointment on the basis of TET 2014 should be considered by taking into consideration about the qualification on the date of applying for the examination of any particular student. But here the board has done complete injustice to the present. So, Lord, they want that, Lord, they should be considered as an untrained candidate post 2019. They were not considered in 2019. They have no grievance with regard to 2017. They have the grievance that in 2019, where the board recruited, they have only considered the trained candidate. And they say that we should be treated as untrained as on the date of TET examination, and we should be conferred the benefit. This is what the writ petition is. And Lord, now, Lord, kindly see why, Lord, this writ petition could not be entertained. Because, Lord, your Lordships may kindly first, Lord, take the page 209. Please come to page 209. There is a notification issued by Ministry of Human Resources Development. Your Lordships may kindly, my Lord, have a look at it. It's dated 1st April 2015. Has your Lordship got that? Now, Lord, please come to paragraph 3. And whereas in exercise of power under subsection 1 of section 35 of the RTE Act, this is, Lord, Right of Children to Free and Compulsory Education Act 2009. The central government laid down the guidelines on 8 November 2010 for state governments for submitting proposal to the central government for grant of relaxation under subsection 2 of section 23 of the RTA Act. And whereas the central government in exercise of power under 23(2) Act granted relaxation to the state government for a period of to 31st March 2014 by notification, etc. Then Lord, please come to paragraph 7. Now, therefore, in exercise of power conferred by subsection 2 of section 23 of the RTA Act, the central government hereby extends the relaxation to the state of West Bengal in respect of the minimum teacher qualification norms notified by NCTE as published in the Gazette Vide August such and such as they relate to class 1 to 8 as under. Then Lord, please turn the page. It says that aforesaid relaxation will be valid up to such and such. And then Lord, please take 6. State government and other school management shall ensure that teachers who are appointed under the relaxed qualification norms acquire the minimum qualifications specified in NCTE notification within a period of 2 years from the year of appointment. Has your Lordship found that? Please, my Lord, kindly take the Right of Children to Free Compulsory Education Act 2009. Lord, there is a statutory bar under section 23. Lord, the NCTE has provided a qualification, and Lord, the recruitment has to be in terms of the qualification. The relaxation was granted for a limited period of time. And this relaxation was granted in view of the fact that the state had inadequate, there was the teacher-student ratio was inadequate. Kindly see section 23(2). Your lordships will find this is clearly mentioned there. Every school management committee, sorry, 2, the school 23(2), sorry. Where a state does not have adequate institution offering course or training in teacher education, or teacher possessing minimum qualification as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary, by notification relax the minimum qualification required for appointment as a teacher for such period not exceeding 5 years as may be specified in the notification. So, my lord, here this limitation 5 years was initially for 2 years, which was extended. As Mr. Bandyopadhyay has already submitted, I don't want to trouble your lordship. But Lord, the question today is that what they wanted in the writ petition is not an order which runs contrary to the provisions of the statute. So, Lord, minimum maximum period, Lord, which was there for acquisition of the training was over. By the time, Lord, they came to court in 2022. And Lord, your lordships will find from their averment that they were asking for relaxation as a untrained teacher. So, Lord, they did not fit into the question of qualified teachers as Lord is required under this act. This is a central legislation. They had to comply with it. But Lord, they were trying to bypass this legislation. Therefore, Lord, they came to court. My first contention is that the writ court ought not to have entertained a writ petition when, Lord, the petitioners were not qualified for being considered for the post. This was one of the points which was completely overlooked by the learned single judge. And it was obviously this point was not taken by either of the parties. Now, Lord, this is the first point which I wish to take. The second point which I want to develop is this, that Lord, we are an absolute necessary party. In the writ petition, we were not impleaded because obviously the petitioner did not ask for, Lord, cancellation of these appointments. Their whole petition is that they expected that after the recruitment is over, there would be further recruitment. And consequently, in 2019, when the recruitment was made, state government has only admitted trained candidates. State government, Lord, the board had no other option but to, Lord, take trained candidates, because as on that date, Lord, the act stood its ground. So therefore, Lord, they had only admitted trained candidates. The untrained candidates could be retrained within the next period of 2 years. We have been trained. We have been trained, and Lord, your lordships will find, Lord, from our averments, I don't want to trouble your lordship, that we have been trained. So, Lord, the first, the second point which I wish to take is that they did not implead us, knowing fully well that they are not going to ask for any relief as against us. But Lord, having said that, I say that the learned judge, Lord, halfway through went off course, off the course, and Lord, learned judge, Lord, has now directed, Lord, cancellation of our job. Now, Lord, the first preliminary point which I wish to take, your lordships are overburdened with the judgment, but Lord, as a first principle, that Lord, I not being a party to the proceedings, this order has no binding effect on me. Absolutely not. And I of course, Lord, I have got judgments, but I don't want to waste your lordship's time. This is, Lord, the first, Lord, point that I wish to take, that I not being a party, this order itself is not binding on me. But Lord, since there is a direction by the court by a writ of mandamus, I say that no writ of mandamus could be issued to me without giving me a notice, without, Lord, giving me an opportunity to defend. If my rights were getting affected, and this is a fundamental right. So, Lord, for the purpose of getting my right affected, I had to be given a notice. I had to be, Lord, given an opportunity to defend. Now, Lord, in a similar situation, identical situation, 200 and odd, Lord, persons, 273. Now, in a similar situation, Lord, about 273 people's service was terminated.
on an earlier occasion. My lord, your lordships may kindly, my lord, come to pay paragraph 2. Lord, paragraph 2, my lord, kindly turn the page, page 3. Supreme Court. No, kindly, Lord, kindly look at the Supreme Court. I think wrong judgment has been handed over. The Supreme Court judgment, Lord, I just wanted to rely.
Yes.
Lord, I think it is already in your lordship's record. একটু দেখবেন কালকে দিয়েছেন অ্যাডভোকেট যদি থাকে তো দিয়ে
Give us the reference, we'll take.
Lord, it is, Lord, a non-reported judgment yet. So therefore, Lord,
What is the citation?
Citation, Lord, it is
Yes.
Lord, kindly to come to page 3 of this judgment. Part of paragraph 2. আছে judgment আছে আমি দিয়ে দেবো কপি না আমি দিয়ে দেবো Lord, please come to about the third line from top, page 3. The petitioners in this proceeding sought cancellation of appointment of private respondent impleaded therein, inter alia on the ground that the appointments was made through corrupt process and not on the basis of merit and performance of the successful candidates. In the other writ petition filed by so-and-so, registered at so-and-so, complaint was non-disclosure of certain information with regard to 68 candidates pertaining to their answer script. These were OMR sheets. We do not find particulars of the information he has asked for. Then, Lord, please come to paragraph 4, which, Lord, sets out, Lord, the order of the learned single judge. Kindly turn to page 5, Roman II. Kindly see, it says invalidation of appointment of 269 candidates. Has your lordship found that? Then what it says, single judge has also by order passed on 13 June invalidated appointment given to 269 candidates. These candidates were not parties in either of the two writ petition. 58 of these candidates have approached with SLP. The background in which this order was passed is that after publication of regular panel, successful candidates, second or additional panel was also published. In this panel, 269 candidates were found to be unsuccessful. Then Lord, successful, and then Lord, it goes on. I need not trouble your lordships, Lord, with the whole judgment. Please come to paragraph 13. Or rather paragraph, Lord, yes, paragraph 12. Now we shall turn to that part of the order by which cancellation of appointment of 269 candidates have been effected. Such cancellation has not been interfered with by the division bench. The division bench has referred to the prima facie materials which point to a fraudulent exercise connected with their appointment. On behalf of the respondents, however, no material has been shown to us through their which the candidates' direct complicity in the process of appointment has been shown. This is the judgment that Mr. Bandupata has relied upon. What weight with the single judge in directing the termination in a case where they were not even the parties appears to be material that was revealed in response to orders of the court. Such orders reflect some kind of investigative role that was being undertaken by the court itself in obtaining documents from the recruiting bodies. It was also not a case of the respective appointments were of very recent origin. Then the duty of the judiciary to follow the principles of natural justice. I will not skip this.
So what is the point you're trying?
Point is that, Lord, the paragraph 14 is the point. The Supreme Court said, set aside the judgment, they should be impleaded and they should be given an opportunity of hearing. And your lordships will find the ratio at paragraph 14. Here, the issue is, Lord, when the employment of a person is set at naught, they are not made a party. Article 21 is violated. Lord, that can't be the situation. The situation is that, Lord, they should be added as a party, they should be heard. And if they are not added as a party and they are not heard, then, Lord, this judgment is not binding on them.
Any
This
other
is-
point, Mr.
No,
Kaur?
yes. Now, my lord, your lordship has been taken through the order. I only, my lord, like to invite your lordships to paragraph 9. Paragraph 9 of the impugned judgment, your lordship can look at it from the point, my lord, from any of the judgments that your lordships were looking at. Court judgment of the 165 evidence sector. Wait a minute. Lord, I just want to rely on first, Lord, paragraph 9. Your lordships will kindly come to paragraph 9. Lord, aptitude test was not an issue in the writ petition. Lord, what the learned judge does, he exercises power under 165 of the Evidence Act to take the evidence of the some of the writ petitioners and Lord, the evidence of some of the Lord examiners. Now, Lord, there is no pleading. Obviously, Lord, there nobody knows, and these are evidences taken by the learned judge in exercise of power under 165. Now, Lord, 165, I had argued this on the last occasion. Your lordship's Lord judgment is there. I'll rely on it. In course of trial, a judge is given power to ask question to a witness, but it is as a judge, not as a prosecutor.
Just refer to our judgment.
Absolutely.
You have argued this matter before. right?
Absolutely. And Lord, your lordships have held.
Which paragraph it is?
Yes.
Just tell us those paragraphs. That will be quite enough for 165.
Kindly give me 1 minute. কোথায় গেল আমার ব্রিফটাই গেল? Yes. Lord, paragraph 50 to 52, page 32. If your lordships kindly take note of. And I also say, Lord, page 46 to 48.
Of Emmett of?
Lord, page numbers are at the top. Your lordships will find it is said SCC online, and then Lord, page numbers are there at the top left-hand corner.
SCC online.
And then Lord, page number. Your lordships.
3991.
Lord, at the top, Lord, your lordships will find SCC online, page 1.
What is the reference?
Reference, Lord, it is 2022 SCC online, Cal 3991.
Correct.
And at the top, your lordships will find page 1.
Yes.
So, Lord, I request your lordships to first come to page 10.
Yes.
Page 10. Or rather, Lord, sorry, page 32, kindly come to page 32. I need not trouble your lordship. Straight away come to page 32.
Yes. We are kindly come to paragraph 10 of the judgment.
Yes, paragraph 10, Lord, before that, Lord, your lordships have noted the contention. Yes, page 46, your lordships can straight away take paragraph 10, 11.
Yes. And those principles will apply here.
Those principles will apply. This is well settled. This is well settled. And your lordship had, on the earlier occasion, had struck down, Lord, the disparaging comments, Lord, based on this. Because your lordships held that the settled law is, if your lordships kindly, Lord, take page 47 once. Kindly take paragraph 3, which is quoted. It says, with such wide powers, the court must actively participate in the trial to elicit the truth and to protect the weak and the innocent. It must, of course, not assume the role of a prosecutor in putting questions. The functions of the counsel, particularly those of public prosecutors, are not to be usurped by the judge by descending into the arena as it were. Any questions put by the judge must be so as not to frighten, coerce, confuse, etc. So, my lord, what has happened, paragraph 9 onwards, your lordships will find, these are all, my lord, product of 156. Now, 165. Now, my lord, 165 is in course of a trial when a judge is given power to ask question. Lord, in a writ jurisdiction, taking evidence, and Lord, that too, not Lord, giving any right of cross-examination. We had no right of cross-examination. All this evidence in chief is held against us as conclusive. This could not be, because Lord, even under the Evidence Act, if once there is an evidence in chief, there has to be a cross-examination. Without the cross-examination, these findings could not have been held against us. And your lordships have been asking that where is the material. Now, my lord, paragraph 9 onwards of the judgment, your lordships will find the materials are whatever these witnesses said are held to be sacrosanct. Now, my lord, can this be a piece of evidence which is admissible in law? Lord, our contention is this is not a piece of evidence which is admissible in.
Followed.
Lord, I also have a point of bias. Lord, I say that, Lord, just one page, if your lordships kindly look to in our stay petition. Of course, Lord, I have asked for the transcript. I haven't got it as yet. Please come to page 111. Of course, Lord, this is just a prima facie glimpse of my point. Lord, of course, I'm going to develop, Lord, in course of hearing of the appeal. We are at the stage of interim order. Kindly see page 111. Lord, right hand top says 6 December 2022, Dhaki Shomet Bisorjon diye debo. Has your lordship found that?
Yes.
Now, Lord, this is the mindset, Lord, on 6th of December 2022. Now your lordships will find page 239. Please come to page 239. Kindly see the second paragraph. As a large number of petitioners were present in courtroom, I decided to exercise my power under section 165 of the Indian Evidence Act. I asked some questions after administering oath to 7 of such candidates, being petitioner number such and such, such and such. From their evidence, I am satisfied there was no aptitude test for the said petition.
Yes.
Now, this is one. Come to Lord, page 245.
Yes.
Lord, we belong to Howrah district. We were recruited in Howrah district. We work in Howrah district. We are about 263 persons, Lord, who have come up by way of appeal. Now, Lord, please come to page 245. This is an order dated 6th of February 2023.
Yes.
Kindly come to paragraph 3. Another sealed envelope containing list of persons who took interview of different districts, namely South 24 Parganas, North 24 Parganas, Bankura, Purulia, Malda, Paschim Mendipur, etc. Then kindly come down. Out of these interviewers, the envelopes in respect of district of Hooghly, Howrah, Uttar Dinajpur, Coach Bihar and Murshidabad have been opened and kept in a separate file. Then, out of the interviewers of the following district, namely Hooghly, Howrah, Uttar Dinajpur, Coach Bihar and Murshidabad, I need to know some facts about the interview and the aptitude test and whom I call for appearing before this court on 21st February 2023 at 2 p.m. and the expenses for their journey would be paid by the board, as I do not want to saddle the petitioners. Now, Lord, this is not a role of the prosecutor. This is a clear role of the prosecutor. This can't be, Lord, a better evidence of a role of a prosecutor. Now, Lord, apart from that, please also look at, please look at the order. Now, Lord, what happens is, envelope containing Howrah is there. Lord, what he takes into consideration, he discards Howrah. He discards Howrah. Kindly, my Lord, see the order. Kindly, my Lord, come to the order. Impugn judgment. Inner page 6. Kindly see, Lord, quoted, Lord, in under paragraph 9. Says, pursuant to the order passed on 6th February, evidence of the following named teachers who took interview of some candidates in 2016 recruitment process of teachers of primary school, West Bengal Board of Primary Teachers of different districts, namely Hooghly, Uttar Dinajpur, Coach Bihar and Murshidabad. Howrah is, Lord, not taken into consideration. Where taken up, the real question was, etc.
So, my lord, these selective, my lord, prosecution, if I may use the expression, does it have any basis? My lord, I ask this question to myself. This is after all a writ petition. First of all, the petitioner had no right to seek relief because they continued to be untrained candidates. Because of the act, my lord, they had no chance of being considered. Was it at all material after 6 years? Now, my lord, my learned friend says that we came to know about something which came up in 2022. Lord, what were they doing? Right to Information Act was definitely there. If they were not fence sitters, then who are they? They are clear fence sitters. They just sat tight of the matter, sat tight because, Lord, as Mr. Bandopadhyay said, that this was a clear case of forum shopping. They were looking for the forum, they got the forum, they have come.
That will be all.
Lord, these are my submissions, Lord. I've been short because, Lord, your lordship, lot of time has been taken.
Yes, Mr. Tiwari. Which appeal you would like to argue?
Well, I would like to argue, my lord, appeal that is, my lord, 873 of 2023, my lord, the board's appeal.
এটা স্টেট ক্ল্যাম্প করে দাও। Eight seven three. ওটা ক্ল্যাম্প করে এসো তো। Yes. Yes.
My lord, your lordship, my lord, kindly to come to, my lord, page 164.
Yes.
My lord, this is the, my lord, affidavit in opposition filed by the, my lord, vote. Well, I'm just placing, my lord, certain paragraphs of the affidavit in opposition of.
Yes.
My lord, your lordship, my lord, kindly turn, my lord, page 175, paragraph 9. May I place it, my lord?
Yes.
With reference to the statement made in paragraph 10 of the said petition, I say that the applicable recruitment rules of 2016 made in exercise of the delegated legislative power by the School Education Department, Government of West Bengal, never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup marks, marks of the candidates as contained in the writ petition. The recruitment rules of 2016 has not been challenged in the said petition, and such being the position, the answering respondent cannot be faulted not to be caused the publications of the above in the public domain. However, in terms of the direction passed by this Hon'ble Court, the answering respondents on 28/11/2022 did publish the breakup marks for the candidates who were recommended from 2016 recruitment process. So, my lord, this was first light, has seen the light of the day, my lord, on 28/11/2022. Now, my lord, keeping in background, my lord, on 28/11/2022, now, my lord, your lordship, my lord, kindly takes the, my lord, supplementary affidavit, my lord, affirmed by the petitioner, my lord, on page, my lord, 189.
Yes.
Now, in the course of hearing, my lord, the point was taken whether these petitioners were TET qualified candidates or not. My lord, in response to that, my lord, in order to satisfy that,
yes.
In response to that, my lord, in order to satisfy that, my lord, whether these petitioners were TET qualified candidates or not, now, my lord, a supplementary affidavit was affirmed and it was stated that these petitioners were TET qualified candidates. Now, my lord, this has been stated in the supplementary affidavit, my lord, appearing at page 189, my lord, annexures were not there. Now, my lord, kindly turns, my lord, page 191. This is the, my lord, exception filed to the report of the board. Now, may I place, my lord, certain paragraphs of the exception? Now, my lord, kindly turn, my lord, page 192. Well, paragraph 2. That on 20th of December 2022, this Hon'ble Court was pleased to direct the learned advocate for the board to supply the backup marks of the petitioners, and he was also directed to come up with the particulars of the last employed candidate of different categories and different medium of all districts. In terms of the order passed by this Hon'ble Court, a report under memo number such and such was supplied to the petitioners. Now, will not kindly see, will not, what was the breakup mark given so far as petitioners are concerned. Kindly turn, will not, page 197.
Yes.
Now, will not, in page 197, will not, your lordship would find the breakup marks, will not, so far as petitioners are concerned, that is, will not, district code 03. First one is Deepak Chaudhary, undeserved OBCB. Blood, that is, he got blood 12.687.
Yes.
Now, these marks were given, Lord. I am not traveling to your lordship, Lord. That's backup marks. Your lordship would find the sum of the petitioners, Lord, got more than 14 marks, 15 marks, 19 marks. This as well as, Lord, 20 marks. These are there. Now, Lord, again, Lord, your lordship, Lord, kindly turn, Lord, page 192 once. Now, paragraph 3. That the petitioners have gone through the report and found that the report is absolutely bogus. On detailed scrutiny, it was found the petitioners who were from SC, ST, OBCA, OBCB categories were treated as undeserved. 4 petitioners, namely such and such, were shown as rejected at the time of scrutiny verification. All these petitioners have given interview, and if they were rejected in the scrutiny verifications, then the question of giving interview could not arise. Another petitioner, namely Amit Kumar Ghosh, was shown as rejected, but reason of such rejection was never informed. For the first time, Amit Kumar Ghosh is getting the information of such rejection. Next, paragraph 4. That in the order dated 20th of December 2022, the board was directed to come up with the particulars in tabular form of the marks obtained by the last employed candidate of different categories and different mediums of all districts, but the board has come up with the alleged backup of 16 districts, and the same is absolutely bogus. As from the list, it can be found that the list of impaneled category who are para-teacher, servicemen are given, but the list of general SC, ST, OBCA, OBCB was not given. In terms of the backup of the board, 16 districts of the lower number of impaneled candidates, it is absolutely false that the proper steps should have been taken against the deputy secretary throughout the 824 candidates who are appointed below 13, including the viva and aptitude marks. The copy of the report of the 824 candidates are annexed here. So now, your lordship, can it on page 202. Now, this is the this is the thing supplied by the board. The list of breakup of the total score of the last empaneled candidate in the respective districts and in respect of medium, category, and district. Now, your lordship, kindly takes for test case, kindly takes first one, that is in the 03 district, that is not name is medium is Bengali. Now, your lordship find Tapos Sutrodhar, undeserved, that is OBCB. He got 16.602, 607. Now, next is your lordship find, that is Tomalika Kundu, OBCB, para teacher, that is 13.796. Other categories are not given. So far as this Kamalika Kundu is concerned, that is OBCB 13.796. So throughout the state of West Bengal, last empaneled candidate got 13.796. Kindly keep it in mind. Now, I will proceed. Your lordship, kindly turn page 204. My pleading is regarding 204. Your lordship, paragraph 4, your lordship would find in paragraph 4, page 193, I have stated, my lord, in terms of the breakup given by the board, 16 candidates of the lowest number of such and such. It is absolutely false and proper step should be taken. Such and such throughout West Bengal, 824 candidates were appointed who scored below 30. Now, my lord, who scored below 30, my lord, kindly text, my lord, page 204. My lord, these candidates, my lord,
So what is the point you're trying to make?
trying to say, board is saying the last impanel candidate, my lord, secured 13.796 marks. Lowest marking throughout the West Bengal. I just demonstrate before your lordship, the person who got, my lord, less than 13, 10, 11, 12, less than 13, they were given appointment, and these documents, my lord, these documents is available from the my lord, documents uploaded by the board itself. Now, my lord, if your lordship, my lord, kindly takes, my lord, page 4, your lordship would find that these are the roll numbers and these are the marks. There are, my lord, as many as 824 candidates. My lord, this starts at, my lord, page 204, ends at page 202.
You mean to say, Mr. Tiwari, sorry for the interruption.
Yes.
The lowest candidate got 13.76. And even candidates below that 13 were granted.
Were given appointment. Lord, I say, my lord, your lordship is absolutely correct. I say, my lord, board says last impanel candidate got 13 point something. I am showing to your lordships that these are the persons got 10, 11, 12, they were given appointment. So the board is lying. And my lord, if your lordship, my lord, kindly takes, my lord, page 202, sorry, 220, your lordship would find that these six persons, my lord, they were given appointment, they got, my lord, 12 point something, 12.996.
Yes.
This 204 to 220, all these pages, my lord, here your lordship would get, my lord, the total appointment is 824. These persons were, my lord, appointed, my lord, having secured, my lord, less than 13 marks. Now, my lord, if your lordship, my lord, kindly takes, my lord, the recruitment rules once. My lord, kindly takes, my lord, kindly turn to, my lord, page 156. Kindly turn, my lord, I'm sorry to say, kindly turn, my lord, page 154.
Yes.
Now, my lord, this was placed by Mr. Sanlan, my lord. What does it mean by aptitude test? Aptitude test, they are saying, my lord, the aptitude test means the test to assess the natural teaching ability of a candidate. Now, my lord, kindly takes, my lord, I shall be defining, my lord, few rules just to demonstrate, my lord, the entire selection is contrary to the rules. My lord, kindly takes, my lord, page 155. That is, my lord, rule 4, the information regarding vacancies. Kindly take, my lord, rule 4, sub-rule 5.
Yes.
May I please, my lord? With the prior approval of the state government, the board shall have the following power to lay down the modalities and procedures and guidelines as the case may be. A. For selection of candidates for preparation of the panels for appointments, coordinate the entire procedural formalities relating to the recruitment and engage any specialized agency for the purpose. Now, there is a clear finding given by the learned trial judge. I'll show to you, lordship, Lord, that there is no provision for engaging any third person, Lord, in the recruitment process. Lord, the board has engaged a third party for doing all these things.
Yes.
And third party, it can be engaged, my lord, for the purpose of, my lord, assessing the vacancy list. But that cannot be a part of the selection committee, or selection committee cannot be controlled by a third party, my lord, which is total alien to the selection committee. Now, my lord, kindly see, my lord, next, my lord, page, rule, my lord, I just showed to your lordship, my lord. Next rule is, my lord, rule 8, page 157. Now, kindly see, my lord, rule 7, sorry, my lord, rule 7, my lord, page 156.
Yes.
The selection committee, the board shall constitute the selection committee within the jurisdiction of the council with the following members, namely the chairman of the council, the secretary of the council, the special officer of the scheduled caste, scheduled tribes of the district, the representative of the district magistrate ex officio, and 7 members
Mr. Tiwari, all this should have been pointed out before you participated.
No.
After you participated.
Now, my lord, kindly see, my lord.
And you waited for 6 years.
6 years.
Answer
Now, my lord, all these documents, my lord, today what I am showing to your lordships, all these documents were not in the public domain.
How did they come in the public domain?
As per the direction of the court, the court directed on 20, my lord, that is the case, my lord. My limitation point stands from on and from 28/11/2022. 28/11/2022, when these documents were made available to the public domain. But it was done by a third party that has also come to the knowledge of the students subsequently. When the investigation, kindly see, I am just visualized to. The investigation is going on. So far as this recruitment scam is concerned.
How did it come to the public domain? What was the provocation for coming into the public domain?
Once I moved the repetition before this Hon'ble court, now, my lord, this Hon'ble court had passed an order directing the board to disclose.
Where is the disclosure? Huh? Where is the disclosure?
That was admitted. Kindly text 175 once page. That is the admitted position. That is the admitted position, my lord.
This is the affidavit filed by the board.
By the board. Board said, my lord, that board had disclosed it, my lord, on 28/11/2022. It is the stand of the board. Now, my lord, kindly see, my lord, two documents, my lord. My lord, kindly see, my lord, the first one is order dated, my lord, 17/1/2023. My lord, that is at page 263.
Yes.
Now, my lord, this is the order on 17/1/2023, passed by the Lord single judge. Now, my lord, may I place this order? In the course of hearing, a serious allegations was made by the petitioners that in the selection process 2016, when the stage of interview and aptitude test come, only interview was taken and there was no aptitude test. Though in the aptitude test there are 5 marks, 5 marks are also there for interview. As a large number of petitioners were present in court, I decided to exercise my power under section 165 of the Evidence Act and asked some questions after administering oath to 7 of such candidates, being petitioner number such and such. From their evidence, I am satisfied that there was no aptitude test for the said petitioners. Learned advocate for the board has submitted that he does not have any idea whether such aptitude test was taken or not. But this is the counsel for the board is saying so. The board stand is, Lord, learned advocate for the board has submitted that he does not have any idea whether the aptitude test was taken or not. In such circumstances, I direct the president of the West Bengal Board of Primary Education to file one affidavit by 7 days from the date of disclosing whether there was any aptitude test in 2016 selection process and what is the method of the board in following this to take such aptitude test of the candidates.
That is at page 266.
Now we'll kindly see page 265.
Yes.
265, your lordship, kindly turn page 266.
Yeah. Instead of turning pages, you also tell us what problem you are finding with this.
Problem is, Lord, number 1.
Let us see page 266 first.
Yes.
And then as you turn to a page, tell us what is the problem you face with.
266, Lord, paragraph 4 clear. Paragraph 4 says, from the available records in my office, it is evident that in 2016, recruitment process marks were given by the selector both in the interview as well as aptitude test to the candidates. This is the stand of the president of the board.
Correct.
Now, Lord, kindly see, Lord, how it was affirmed. Lord, page 267, paragraph 4, are based on information derived from records. Now, Lord, kindly have a look, Lord, the orders.
Kindly read paragraph 6 of page 266.
Yes, Lord. In 2022 recruitment process, which comments after I assumed the office, the board has taken the various steps on the first.
That is the 22
recruitment process. That is not relevant. Now, my lord, your lordship, my lord, kindly see, my lord, the orders. My lord, kindly see the orders passed by the learned trial judge in these proceedings from time to time. And next one, sir. Petitioner. Now, kindly see, my lord, the first order that is on 6/12/2022. Well, kindly take page 3 of the order.
Yes.
But by this order, my lord, I was directed to disclose the applications filed by the petitioner and the call letter for interview of the petitioners by filing supplementary evidence. Well, this is not so relevant, my lord. Kindly text, my lord. Next order. That is, my lord, order dated, my lord, 24 January 2023. Now, my lord, may I place the order? 24th January 2023. I directed the petitioner that at least 2 candidates from each district are to be present before the court, as the court wants to know them about the interview and the aptitude test taken by the West Bengal Board of Secondary Education in 2016 selection process. I am told by the learned advocate for the petitioners that the candidates are present. Now I start exercising my power under section 165 of the Evidence Act, as I want to take the evidence of the candidates from each district. Some of the candidates from each district have been intimated to me by the learned advocate for the petitioners who were the candidates in the 2016 recruitment process and appear before the interview, but all of them are unsuccessful. Through the name of the, though the name of one such and such was mentioned in the list handed over to me by the petitioners, Mr. Thapa is not present. I have undertaken the evidence of 19 candidates exercising my power under section 165 of the Indian Evidence Act. I have received the affidavit as was directed by the court on 17/1/2023, affirmed by the president of the West Bengal Board of Secondary Education. Now, now, will kindly text, my lord. Kindly, my lord, kindly turn, my lord, page 3. Last, my lord, it was directed. The president of the board is also directed to produce one list in a sealed cover, which will be given to the petitioner, which will not be given to the petitioner, which will contain a list of interviewers and their resignations in respect of the interviews of the candidates whose evidence has been taken by this court. A list of shall remain a secret list in this court. The directions given by the president of the West Bengal Board of Secondary Education is to be complied with by such and such, such and such. Now, my lord, kindly text, my lord, next order. So that is, my lord, order number, my lord, 6th of February, my lord, 2022.
Tiwari, tell us, then why are these orders? Why do you support these orders? Tell us that.
My lord, I support this order, my lord. My lord, I relied on your lordship's judgment. My lord, judgment, my lord, which my learned senior friend, my lord, shown to your lordship, my lord, kindly takes that judgment, my lord, I will show you, my lord, one paragraph. My lord, your lordship, my lord, kindly excuse me, my lord, that one copy is only. Kindly excuse me, my lord. Yes, yes.
This is that.
This is the, my lord, division bench judgment delivered by your lordship, sitting with Justice Lopita Banerjee, my lord.
Not the spiral book. We were referring to a spiral book. Where is that? Where is that spiral?
Spiral book is also there. I'll show to you, lordship.
Well, show us the spiral book first. This is also spiral. That is.
Now it is not for spiral.
Now it is not spiral. It can be made spiral. Yes. Now, what is the spiral book about?
The spiral book is, my lord.
We'll come to our judgment, of course, Mr. Tiwari, but tell us our curiosity. What is the spiral? This spiral
The
book?
spiral book is, my lord, if your lordship, my lord, kindly takes first one. My lord, your lordship, can you see? This is a list.
Yes.
List of some impanel candidates
Yes.
who got less than 11 out of 20 in TET, Madhyamik and HS,
Yes.
but got 7 out of 10 in Bhaibausi and aptitude. Now, my lord, this list, my lord, contains the, my lord, those who got, my lord, 11, my lord, up less than 11 out of 20, and my lord got, my lord, 7 to 10 in out of 10 in aptitude and in Bhaibausi.
Yes.
Now, my lord, in this list, my lord, only it contains near about, my lord, 5,000 name of 5,216 candidates.
Yes.
My lord, out of, my lord, total 42 something candidates. These are 32, my lord, unten candidates. Here, my lord, your lordship would find Lord, most of the candidates, Lord, were given 9.5, 10, 9, Lord, in interview and aptitude test.
Yes.
And so far as Lord, their academic qualification is concerned, that is Lord, much below, but they got Lord, maximum marks.
And where is your chart? Did you show a chart before the single bench?
Yes, that
What
was
your
Lord,
performance?
that was Lord, supplied by the board. That was supplied by the board, Lord. Your Lordship will kindly get it, kindly take Lord. This chart is Lord, page Lord, 197. Page 197, Lord, this is the chart of the petitioners. Lord, this chart, Lord, supplied by the board.
Yes. Yes.
Now, Lord, may I go to the order, Lord, on dated 6th of February, Lord, 2023. Lord, may I? Huh? Well, pursuant to the order dated 6th of February 2023, evidence of the following named teachers who took interview of some of the candidates in 2016 recruitment process for the teacher of the primary school conducted by the West Bengal Board of Primary Education of different districts, namely such and such, were taken up. The real questions were whether the aptitude test of the candidates were taken or not. From the table below and reply, the real questions would be found. First one said, no aptitude test. Second one said, aptitude test was taken. Third one said, no aptitude test. Maximum said, no aptitude test. Some said, London judge asked, what does it mean by aptitude test? Some said, aptitude test, that I don't know what is the meaning of aptitude test. And only one thing, Lord. Now, Lord, after these questions, the London judge recorded that no question was asked by the appearing parties to the above interviewers. The evidence recorded are kept on record. Now, Lord, mere shouting will not do. Lord, it has been shouted, Lord, throughout the argument that in the course, despite London judge took the evidence, Lord, no opportunity was given to the parties to cross-examine the interviewers. Lord, that was given. London judge recorded that. And these orders are fine. These orders are Lord, binding on the parties. Lord, now Lord, somebody had come and say in the appeal court, I was not given the opportunity of hearing. No. The opportunity of hearing was provided to you. You did not avail that. Lord, effect of non-cross-examination, Lord, your Lordship knows, Lord, that when...
But Mr. Tiwari, they were not parties.
Lord, kindly consider, I'll cite judgments, Lord. Lord, somebody is coming and saying, I was not parties, Lord. There is, Lord, natural justice, Lord, is not an unruly horse. Is not an unruly horse. Lord, kindly consider one situation once. Today, somebody, Lord, suppose Mr. Bandhavadai's client, Lord, got 13 marks or 13 marks. Lord, I got 17 marks. I was on the street. Mr. Bandhavadai's client is in school. What is the use of giving any right of hearing to Mr. Bandhavadai's client? I'm asking the question to you. Can he improve his mark? From 13 to 17, can he improve his mark? Lord,
you got 17 in the academic test.
Well, I got, Lord, I'm just giving one example. I got, Lord, 17 marks in total academic plus interview. No aptitude test. Without aptitude test, Lord, I got 17. Now, Lord, Mr. Bandhavadai's client, Lord, got 16 marks. Lord, 16 marks, Lord, after getting 16 marks, Lord, he was appointed. Now,
after 16 and after 17, both of you appeared in the aptitude test.
Yeah, no. So far as I am concerned, no aptitude test.
Anyway, we'll come to that point. Therefore, you got, and we are just having a thing. It's late in the evening, not late in the day, early in the evening, no issues. The issue that you got 16, somebody else got 17. Now, both of you appeared for the aptitude test. Now you can say he got 9. No, we correct us if you're wrong. Yes. Now you can say he got 9.5 or 10 in the aptitude test. You got 3 or 4. Is that the position, or you were not in the aptitude test at all?
No, so far as I am concerned, no aptitude test at all, number one. Second point is, I'm just, perhaps I am not clear. I say, suppose today I got 16 marks. Without aptitude test or even aptitude test, whatever it may be, I got 16 marks. Now, my lord, on records, after scrutiny of records, it is found that somebody, my lord, who got, my lord, 15 marks, he is in service. And I got, my lord, 16 marks, is on state. So, my lord, I am asking the question to myself that what is the use of giving, my lord, right or opportunity of hearing to the person, my lord, who got, my lord, 16 marks and is in service?
Got that point. Now, in this list of candidates which the board has given, your names are not there.
So far as this
list
no.
is this list is concerned.
So it was done from the documents.
You were left out of the. Then you are not a participant in the selection process. How are you then, without being through the aptitude test? How do you become a participant in the selection process?
We are the participant.
Then
we are the
up to
participant.
what stage did you participate?
We are the participant. We participated in the interview, but our case is that no aptitude test was conducted, and the marking was given randomly. That is the case, short to be made out in the trial court. That is one of the points. Other points are also there. This board, what board is saying today? Today, board is saying, last employment candidate got 13 marks. I shown to your lordship, that there are candidates who got below 13 marks who are still in service. There are issues. Now, your lordship will not kindly consider, today, so far as exercise of power under section 165 of the Evidence Act is concerned. Now, that's why, I refer to your lordship's judgment. Your lordship, at the end of the day, your lordship held that when justice not only to be done, but seems to be done. That is the observation. That is the finding of your lordship to discard the argument of 165.
So even assuming that 165 was employed by the Honorable Single Bench, the reasoning of the Honorable Single Bench is not that you did not participate in the aptitude test. The Single Bench says the entire thing was conducted in a sham manner, the aptitude test, not your lack of participation, but the conduct of the aptitude.
No, it was pointed out.
That is the thrust of the Single Bench.
No, it was in the course of hearing, your lordship will not kindly see.
It was not a question of no evidence or no aptitude. It was a question of a sham aptitude test.
In the orders, your lordship would find, your lordship will not kindly just placing the order.
Yes.
I decided to. Your lordship will kindly take the order dated 20th of December 2022.
Yes.
May I place the order?
Yes.
The case of the petitioner, in short, is that though the petitioner got higher marks before addition of the marks against the interview and aptitude test, comparing to some candidates who have been given the appointments against the 2016 recruitment process, even after adding their marks for personality test and aptitude test, they have not been given appointment. They have come before this Hon'ble Court as has been submitted after taking inspection of the records, persuaded before the Honorable Chief Justice Court in a public interest litigation before the got imposed. May I just point out one thing? The crux of the matter is this, a writ petition was filed before this Hon'ble Court. In that writ petition, the person challenged, he was appointed as a assistant teacher, in a primary school. Subsequently, his appointment letter was withdrawn by the District Primary School Council. Now, he challenged before this Hon'ble Court, saying that I was appointed rightly and my appointment was illegally withdrawn. Now, in that petition, the board has filed one affidavit and saying that he did not have any requisite qualifications, and he did not have all the documents. So wrongly we have given appointment. Now, when this report was before the learned single judge, the petitioner filed an exception, saying, look here, not only I, 12 other persons were appointed in the same fashions. Now, what they have done, the learned single judge treat the writ petition as a public interest litigation and place the matter before the Honorable Chief Justice. Now, before the Honorable Chief Justice, it was treated as public interest litigation, and in the public interest litigation, the matter was going on. The Honorable Division Bench, presided by Honorable Chief Justice, hearing the matter. In the meantime, board has filed an appeal challenging the order passed by the learned single judge, by which the writ petition was treated as public interest litigation. Then in the appeal court, board has taken an U-turn, saying, the look here, he had all the documents. He had all the documents. So he let him submit a representation before the secretary. Secretary will consider it and secretary will pass appropriate order. In terms of the submission made by the board, the Honorable Division Bench will not dispose of the matter, will not directing that petitioner should be treated as an assistant teacher, and will not order of the learned trial judge was set aside. Not only that, public interest litigation, which was hearing by Division Bench, will not first court, that was treated on base list, and it was also disposed of. Now, public interest litigation was disposed of. Order of the learned trial judge was also set aside. Now, another public interest litigation was filed before the Honorable Chief Justice. That order, your lordship was quoted in last occasion. In that order, it was a preliminary objection was taken that maintainability point that this public interest litigation is not maintainable, as because the point was the order under appeal was set aside by Division Bench of this Honorable Court. So I argued, that order is absolutely nullity, as because the court did not have the jurisdiction to treat the petition, as because the public interest litigation has to be heard by the Division Bench number 1. Now, that maintainability point raised by the state that has been rejected by the Honorable Division Bench, the state went to the Supreme Court. Supreme Court upheld the order passed by the Honorable Division Bench. The public interest litigation is pending before the Honorable Chief Justice. Now, in that public interest litigation, I seek, there was a direction. Board was directed to file all the envelopes of 42,000 showing they have given appointment. Now, I mentioned the matter before the Honorable Chief Justice, saying that I should be given an opportunity to inspect the file. I took the inspections. After taking inspection, I gather so many things are there. Untrained candidates were given appointment, they have given absolutely privilege. Other persons were also left out. Less meritorious candidates were given appointments. Meritorious candidates were left out. All these things had come up. Now, subsequently, that facts were also had taken into consideration by the learned trial judge. Now, in the course of hearing, learned trial judge found, your lordship if your lordship sees the evidence given by the interviewer.
We have gone through the
Evidence that is not there. Well, learned judge just quoted something. Can you see the evidence given by the interviewer? The interviewer there?
Anyway,
can you see these are the entire set of evidence given by the interviewer. Your lordship would get the gist of the statement in the order of appeal. But here your lordship would file how the learned judge had taken the pen of interview of all the interviewers. All the interviewers more or less in the same tone saying that there is no, they doesn't know what is the meaning of aptitude test. They don't have any knowledge what is the meaning of the aptitude test. They sometimes say one paragraph of the learned trial judge I am just referring. And learned trial judge
now look at one interview just suddenly came to our notice. Recorded on the 21st of February 2023.
Yes, Mr. 21st of February 2023.
Names Mohammad Maruf Alam, father's name so and so, age 55 years, service high school teacher. Now, high school teacher, he has the antecedents to be part of the interview board. We cannot dispute that possibly. Now the question, are you a teacher of school? Yes. Second, were you authorized by the Board of Primary Education? This is just one of the random pages we opened to see.
Yes.
Who's the first thing? Yes, over telephone. Who gave you authorization? The DPSC chairman. Total marks for interview, 10 marks. Now, was there any separate sheet for interview aptitude test? Yes. Did you ask any questions to any of the candidates? Yes. Questions for teaching skills. Was there any guideline how to assess the mark for aptitude? Guidelines were given by DPSC that candidates have to be assessed on the basis of subject knowledge as well on the basis of teaching skills. Can you show any document? No document was given at that time, only verbally. How did you assess the replies? All the candidates were on live performance. Live performance means, did you tell them to use blackboard and chalk to demonstrate their skills? Yes, I did. I think you were wholly incorrect evidence. Now, this is the single bench saying you're giving incorrect. No, my lord, I'm very responsible to the board. How many questions did you ask in the aptitude test? 3 or 4 questions. What do you understand by the aptitude test? Those who are confident enough by their body language, that is there. What is really fundamentally wrong with this interview?
It might
Just
be,
asking the question to
it might be a case of one. So, for example,
one random what is fundamentally wrong in this kind of an aptitude test?
Question is, the aptitude test has to be certain guidelines.
Correct.
Now, it has to be conducted in a manner as suggested by the board from time to time. There is no such
Question is, we are just asking you a question.
Yes, please.
This was a random page opened. He was
Yes,
a
yes.
teacher, part of the aptitude test. It is almost like a walk-in aptitude test.
Well, one of the
What is
interviewers said,
fundamentally wrong?
yes, one of the interviewers said, one interviewer, that is Mohammad Maruf Alam,
Yes.
that was quoted by the learned trial judge,
Yes.
said, he took aptitude test, but when asked, asked what was an aptitude test, his reply was, aptitude test means confidence and body language of a candidate.
Correct. So that is, he has given a blackboard and a chalk, the way he walked up with the chalk to the blackboard. We understand. The question is,
The process of teaching, how he will teach the student, how he will assess the student, these are the things to be. Now, teaching ability of a candidate. This, as per the board, as per the rule 2C of the 2016 recruitment rules. Now, so far as if you have lots of so my response submission is this.
of course, we are just sharing our
Yes,
mind.
yes, yes. My response submission is this, that all documents are available before the learned trial judge. And the board had the opportunity, to cross-examine these interviewers. Board had the opportunity to cross-examine the petitioners. Board did not avail that opportunity. And so far as board affidavit is concerned and report is concerned, board is saying, not in concrete form, the aptitude test was conducted. He said that everything is available on record, number one. On that relevant point of time, I was not the president. Somebody was the president. So I can give answer to that. Now, looking into the background of this case, I just shown to your lordship, few pages. Kindly turn page 224.
Yes.
Now, this chart was prepared. You also would find the list of the breakup of total score of the last impanel 10 candidates in their respective category, district code wise, as per breakup marks published by the board in their website. What we have taken in every district last 10 lowest marks were taken as per their roll number around this. Now, if you lordship would find first one, that is general candidate. First, that is Gopal Chakraborty. Your lordship would find he got the lowest mark 11.805. And last, highest amongst the lowest, that is he got 13.040. Now, kindly take next one. Next lot. That is OBCA. In the OBCA, your lordship would find first OBCA candidate, lowest is 12.831. Now, kindly turn next, just 9 after 9, highest among the lowest, that is 14.245. Now, a candidate, OBCA, OBCB, whatever it may be, if he got 14 point something more than general candidate, he should be treated as general candidate. This is the my lord, common law of reservation.
Yes.
My lord, this is the rule, my lord. If your lordship, my lord, kindly takes my lord 158 once. But kindly, my lord, read my lord 228, 224 with page, my lord, 158. Now, my lord, 158, my lord, this is my lord, continuation of my lord, rule 8, sub rule, my lord, 6, proviso. May I place it, my lord? Rule, page 158, bottom. My lord, the addition.
Yes.
An additional panel of 5% of general, scheduled caste, scheduled tribe, OBC category and OBC category, exempted category, ex-servicemen, physically handicapped candidates shall be prepared in the same manner as is referred to 5B1 of Rule 8. Next, provided that additional panel of general category shall not be include any candidate belonging to scheduled caste, scheduled tribes and other backward classes. However, in case of appointment to the post of general category from the additional panel, if any reserved candidates score higher marks, then the candidates belonging in the general category in the left out merit list, then the reserved candidate shall be selected for appointment. This is the my lord meritorious reserved candidate. So, my lord, if a person, my lord, secure, my lord, being a my lord, scheduled caste category, my lord, if I secure more than my lord general category, marks obtained by a general candidate, now I should be treated as general candidate. This is the my lord, normal rule. Now, my lord,
Yes.
now, my lord, if your lordship, my lord, kindly say, my lord, 158 once, page 85. My lord, rule 8, sub rule 5, page 158. My lord, may I place, my lord? The selection committee shall prepare the separate council-wise panel as per procedure below. First, selection committee shall segregate all eligible candidates applying for earmark vacancies as mentioned in note 7 to rule 6 from the successful candidates. Secondly, the selection committee shall prepare the following panels for the successful candidate who have applied for non-earmark vacancies. The panel of all selected candidates in the district, namely unreserved category, comprising of the name candidate belonging to the general category, reserved category or the scheduled caste category, scheduled tribe category, OBC category, OBC A category, PH category, serially according to the descending order of the merit as per the existing vacancies, medium wise. A panel of
According to you, sorry to interrupt. Yes. According to you, this was not.
My lord, I can show to your lordship, my lord, the meritorious SC candidate treated as SC candidate, not general candidate.
Now let us ask you a final question before. Now then, how do you support paragraph 22 of the impugned judgment?
Now, so far as paragraph.
And what happens according to you after with paragraph 22? What is your reading of paragraph 22 of the impugned order?
Paragraph
that
22,
is the operative part.
Paragraph 22, my lord, Laneja says.
What is the wisdom behind paragraph 22? Or in other words,
My lord, paragraph 22, my lord, it says, my lord, the board shall immediately arrange for a recruitment exercise for candidates who are untrained at the time of recruitment, including the candidates who have obtained the training qualifications in the meantime within the period of 3 months from the date, only for the candidate who participated in 2016 recruitment process. My lord, learned judge, my lord, treated, my lord, trained, untrained. My lord, the person who subsequently become trained candidate, they are also treated as untrained candidate. As because, my lord, the cut-off date was considered by the learned judge that on that particular date, everyone was equal. On that particular date, my lord, kindly considered if somebody, my lord, by applying the rule of somebody, if somebody gets, my lord, become 10 as on date, and I had not, so far as I am concerned, my lord, that rule was not applied to me, my lord, I become untrained as on date, so my lord, I will be wiped out. But this cannot be the law, my lord. Responsible submission, my lord.
Because Mr. Tiwari, one of the arguments which was advanced is after 2019, there is no scope for untrained candidates.
Well, after 2019,
this is the argument
yes,
you have
yes.
to meet.
Lord,
So how can the honorable single bench create a playing field for you. That was their argument, even if this was admitted.
But so far as 2019 is concerned, Lord, there are cases.
Yes.
I don't want to say all these things. There are cases. Persons who are been appointed, my lord, even after my lord, 1st of April 2019. There are cases. Now, my lord, if your lordship, my lord, kindly consider, my lord, I just cite, my lord, 2-3 judgments on this aspect. Before that, my lord, if your lordship, my lord, kindly takes my notes of argument, my lord, which was filed before the trial judge. But I have said, my lord, everything. But as Mr. Dotto was pointed out, my lord, that so far as, my lord, notes of argument is concerned, my lord, it was.
Yes.
All the points, my lord, I said, my lord, kindly have a look, my lord. There's few judgments, my lord, which I'll cite to you, lord.
Yes.
There, first. (1994) for a Subrata. But 1994, 4 SCC page 165.
Yes.
Now, if you lordship will not kindly text, will not paragraph 16 to 20. May I place, will not paragraph 16. Page 174, my lord, paragraph 16.
Yes.
Having regard to all the above, irresistible conclusion is a fraud has reached crescendo. Deeds as foul has been misconstrued and such. Now, my lord, kindly text, my lord, paragraph 17.
Yes.
It may not be too much to draw an inference that all these were motivated by extraneous consideration. Otherwise, how does one account for selection without interview? Fake and ghost interviewers tampering with the final records, fabricating documents forgery. Each of these would attract the penal provision of the Indian Penal Code, and they have been done impunity. The story does not end here. From the selection list, secret communications has been sent to the candidates. Selections were made without medical test verifications of antecedents. It is highly regrettable that the holders of the public office with big and shall have forgotten that the offices entrusted to them are sacred trust. Such offices are meant for use, not abuse. From the minister to menial offices are meant. From the ministers to menial offices, everyone has been dishonest to gain undue advantage. The whole examinations and interview have been turned to a farcical exhibitions based character of those who have been irresponsible for this sordid episode. It shocks our conscience to come across such a synthetic fraud. It is systematic fraud. It is somewhat surprising the High Court should have taken the path at least resisting, stating that in view of the destruction of record, it was helpless and it should have been helped itself. The law is not that powerless. In
And
what
the
now?
elections were passed. Yes, paragraph 21.
Now, paragraph 20.
Yes.
Paragraph 20 said, in above circumstances, what are we to do? The proper course open to us is to set aside the entire selection. The plea was made that the innocent candidates should not be penalized for the misdeeds of others. We are unable to accept this argument when the entire selection is sinking, conceived in fraud, delivered in deceit. The individual innocence has no place. The fraud unveils everything. To put it another way, the entire selection is arbitrary and it is which is faulted, not the individual candidate. Accordingly, we set aside the entire selection of taxation inspectors.
Got the point. Got the point.
Now, my lord. Now, Kyle. Now, my lord, in so far as Tripura High Court is concerned, my lord, the similar situation arose. In the Tripura, my lord, 10,000 appointments so far as assistant teachers is concerned, all were set aside. Now, my lord, this is a judgment of the Tripura High Court. It was also affirmed by the Supreme Court. I'll show to your lordship, my lord. In the Tripura High Court judgment, my lord, now, my lord, I'll be just placing, my lord, few paragraphs. The entire judgment, my lord. My lord, kindly text, my lord, paragraph 16. Yes, it's reported. This is reported. Yes. 2014 SCC Online Tripura 291. 2014 SCC Online Tripura 291.
Yes.
Now, my lord, if your lordship will not kindly transfer, my lord, paragraph 16.
Yes.
Now, my lord, may I just place, as held by the Honorable Apex Court in the case of such and such, the most important factor in imparting education in the role of a teacher can perform his role as a guide, philosopher, mentor, teacher, and guide to the students only if himself is well qualified. If a teacher is honest and believe in high moral values, his students will imbibe the same values from him.
We understand that.
Understand. Now, Lord, here what happened, Lord? Here teachers were appointed by the hands of somebody. Now, Lord, if the teachers were appointed by the hands of somebody, now, Lord, these illegal appointments should go. And now, Lord, kindly seek, Lord, I just show to you, Lordship, Lord, another few paragraphs of this judgment. Lord, kindly state where, Lord, comes. Lord, kindly text, Lord, paragraph 117. Lord, prior to that, Lord, 116 and 117. Lord, may I place, Lord, paragraph 116.
Yes.
Lord, we live in a country which is governed by the rule of law. The action of each and every official of the government functionaries has to be in accordance with the constitution. The rule of law is a grundle thread which runs our constitution. The most important facets of the rule of law are fairness and equality. Every citizen has a right to equal opportunity of employment and equal treatment at the time of selection. Nobody can deny this right to any citizen of the country, and if such right is denied, then the court shall step in to ensure that justice is done. Now, my lord, kindly take, Lord, paragraph 117, last 3 lines. Last line, my lord. The entire selection process was a cruel joke on the youth of Tripura. When I say, my lord, entire selection process is a cruel joke on the youth of West Bengal. The entire selection process, my lord, is absolutely a farce. My lord, that could be, my lord, Mr. Bandyopadhyay was saying everything after, my lord, if there is a Bengali proverb, the chutney is there, my lord, after a scam, the chutney. Now, my lord, your lordship would find, my lord, what is going on in West Bengal. But the entire selection is based on, my lord, extraneous consideration.
So now you just summarize.
Lord, only one judgment will I show to your lordship.
True.
So far as, my lord, natural justice is concerned, my lord, I'll just give citation, my lord.
I have one question for
Yes.
you. You show the judgment and close your argument, but one question. So summarize how the fraud took place. 1, 2, 3, 4. This is how you see the fraud took place.
First of all, my lord, number one.
Number one, how did the fraud take place? How do you just give us in a bullet form? Your understanding.
Can you take my, my lord, notes of argument once,
Yes.
which is filed before the trial court. Page number 3, my lord.
Yes.
In terms of the rule 7 and 8 of the West Bengal Such and Such rule, it was the duty of the selection committee to prepare the panel. The mode of preparation of the panel was declared in rule such and such. Strangely, the panel was prepared by a third party, which showed the rule was not followed. First one. The entire panel was prepared by.
What do you mean by a third party? An agency?
Third party was interested. A particular company was interested to prepare the panel.
That was contemplated by the rule itself.
That is not that rule is for ascertaining the vacancy, not entire selection committee to be headed by a third party. Now, rule 8, Rule 8 of the West Bengal Primary School Teachers Recruitment Rules 2006.
But you have not given details of the third party. Any details of the third party are not here.
That is not in the order, learned judge recorded that.
Yes.
My lord, if I place the orders, my lord, your lordship would got it, my lord, the learned judge also recorded that.
No, yes, but in this rules, there's some reference to what, there are 3 points which, three aspects which can be taken care of. Yes, kindly come to page 155. Subclause 5.
Yes.
3 things which can be done. It's suddenly, you had placed it. With the prior approval of the state government,
The board shall have the following powers to lay down the modalities, procedure of guideline as a case may be.
Correct.
Now, my lord, let's engage any specialized agency for the purpose.
Correct.
The purpose, for the purpose, my lord, kindly, it comes.
Is that a third party or because this is provided by the rule?
Yes.
Then
Purpose is, my lord, information regarding vacancies. That is, my lord, rule 4 starts, information regarding vacancies. My lord, kindly see, my lord, rule 4 has to be read with rule 7. Rule 7 says, my lord, selection committee. If the selection committee, my lord, kindly text, my lord, page 156 once. The selection committee consists of these things. Rule 7 speaks about the selection committee. Had it been the case, my lord, the third party would be involved in the selection committee, then it would have been there, my lord, in section rule 9, rule 7 itself. Rule 7, rule 8, rule 7, rule 8, all these things are there. Now, my lord, kindly consider these things. Today, my lord, what is the main thing? My lord, 5,000 as per, my lord, information provided by the board, my lord, rough estimation was given, 5,000 persons were given more than, my lord, 9.5 out of 10. My lord, considering their, my lord, education, qualification and all these things, my lord, if your lordship would not kindly tally this. My lord, I got, my lord, my lord, there are instances, my lord, if your lordship, my lord, kindly ask the board to produce all these things. My lord, there are instances, the person who got less than 50% marks, my lord, in high secondary, they are given appointment. There are instances, my lord, I can show to your lordship, my lord, when the public interest litigation is pending, my lord, person who did not qualify the TET, they were given appointment. So, and my lord, so far as, my lord, these things, my lord, fraud, my lord, so far as, my lord, right of hearing is concerned, my lord, board is the person, my lord, who has managed this, all these things. My lord, board is the recruiting agency. The board has to do, my lord, perform in a fair manner. So that, my lord, article 14, 15, 16, my lord, have not been violated. Provisions of article 14, 15, 16 have not been violated. The board has done, my lord, in such a way, my lord, I am just, my lord, repeating it, my lord, the rule of somebody is, my lord, applicable, rule of somebody has not been applicable so far as, my lord, this case is concerned.
Yes, your last judgment on national.
Now, my lord, so far as, my lord, last judgment is concerned, my lord, now, my lord, just one page I will show to your receipt. My lord, this has been, my lord, this data was collected from the petitions of Mr. Bandyopadhyay. Now, my lord, kindly have a look, my lord, these 2 documents, this one document. Now, my lord, 890 though. Now, my lord, in 890, my lord, you will also find in one district, Malda. Roll number, you will also find, name is, my lord, Wanitro Acharjo, general category. Now, my lord, he got, my lord, 16.204.
Yes.
Now, my lord, Malda, one of the petitioners, Sujoy Sharnokar, 16.410. Now, my lord, who is better candidate? I am asking the question to myself.
Yes.
Now, my lord, this is one instance. Now, my lord, you will also take another instance. This is the, my lord, in from the petition of Mr. Kaur, my lord. Sir, these sheets were prepared, my lord, from the.
Give Mr. Bandyopadhyay's paper to Mr. Bandyopadhyay. Give Mr. Kaur's paper to Mr. Kaur.
Now, my lord, you will also see. Matt, my lord, 874. Matt 874, my lord, 4 persons, my lord. Abdul Wahab Ansari, Soed Ali, Pankaj Shao, Neha Rajak, Darka Prasad. My lord, their marks is, my lord, 13.423, 12.643, 13.793. Now, my lord, you lordship can see backup marks of the petitioners. My lord, 15.986, 13.786. Same district. Same district.
Very well.
Now, my lord, kindly have a now, my lord,
Now we have to
No.
Come to
No.
a conclusion.
Conclusion, let
Give us the natural.
2007 4 SCC.
Yes.
My lord, 2007 for the 2007 4 SCC.
Reference to
2007 4 SCC, page 54. My lord, your lordship, my lord, take a note, my lord, few paragraphs, that is paragraph 26. I will just give paragraph 26, 27, 28, 29, 32, 33 and 35. Only below one line I am showing.
Yes.
The court of law does not insist on compliance of useless formality. The natural justice, my lord, is not an unruly horse. My lord, so far as natural justice is concerned, my lord, I'll just cite, my lord, another two judgments. Kindly take a note. 2018-15 SCC, page 463.
Yes.
2018-15 SCC, page 463, paragraph 24 and 25. And 2010-13 SCC 255. My lord, paragraph 25 to 31. Now, my lord, so far as my lord 165 is concerned, my lord, I'll just cite one judgment. 2018 আর হচ্ছে 18-15 আর 10-13. হ্যাঁ, my lord, so far এটা year 2010 Supreme Court 3823. 1815. 1815. Page 383. No, 3823. AIR 2010 Supreme Court 3823.
Yes.
Lord, Lord, I will be relying, Lord, paragraph 20. Paragraph 21. And my lord, paragraph 30.
Yes. That will be all.
Only one thing. Lord, so far as Lord, so much have been said, my lord, regarding the pleading. Lord, your lordship, my lord, kindly takes, my lord, these rules. Calcutta High Court, my lord, rules, my lord. Kindly, my lord, straightway comes, my lord. My lord, kindly take, my lord, page, kindly comes, my lord, page 84 of this book. Well, it starts from, my lord, kindly take, my lord, page 83. That is rule 53.
New bearer.
New bearer.
Don't forget to ask for the return of the book.
Now, my lord, rule 53, my lord, I just place.
Yes.
Save and accept as provided by these rules and subject thereto. The provisions of the Code of Civil Procedure Code in regard to the suit shall be followed, so far as it can be made applicable in all proceedings under Article 226, and nothing in these rules shall be deemed to limit or otherwise affect the inherent power of this court to make such order as may be necessary for the ends of justice and to prevent the abuse of process of the courts.
Yes. So what do you mean?
And-
Why do you say
Well,
that?
I say, my lord, so far as, my lord, technicalities of these, well, technicalities are handmaids of justice. Now, my lord, your lordship will not have the occasion, my lord, to consider all these things, my lord, in the previous occasion, my lord. And my lord, your lordship will not discarded the argument of Mr. Jagdeep Kaur, my lord, senior advocate. My lord, so far as, my lord, 165 is concerned, your lordship was of the view that justice, last line, my lord, it requires an emphasis, justice not only be done, but seems to be done. Well, this is the thing, Lord, your lordship, Lord, today your lordship has to visualize the situation. Today somebody is saying, Lord, I am 36,000, my 32,000, whatever it may be. My service has been taken away. Well, those who are on the street for the last 6, 7 years, 8 years, well, those who are having, Lord, better marks, they are on the street. Well, you cannot deny their right.
Now really we will. Now only two questions.
And my lord, so far as this judgment is concerned, my lord, learned judge, my lord, did not say that these persons cannot participate in the process. Learned judge proceeded on the basis that everybody can participate in the selection process.
Now there are only two questions. After that, we close. One for you, one for the board. First one to you. How did 36,000 be corrected to 32,000? What happened? We understand the figure of 36,000 was corrected to 32,000.
Now, my lord, kindly permit my junior my lord to say.
Yes, Mr. Tiwari, the junior Tiwari, Mr. Tiwari, what happened? Why the correction from
My lord,
36?
correction was that, my lord, 32,000. Initially, it was recorded at 36,000. But now, after I have mentioned the matter because number of non-trained candidates are not 32,000. Actually, exact number should be 30,185. As there was in my written notes on argument, it was written as 32,000. So it was ultimately it was corrected as 32,000 more or less, but exact number should have been 30,185.
And Mr. Gupta, what is this reference to the third? What is the reference to the third party? Only you can know Mr. Tiwari was referring to in induction of a third party. What is this third party?
He is entirely wrong on fact. Entirely wrong on fact. The third party selection procedure entirely was followed by the authority named in the rule. Only the computerization aspect was given to a third party. Tabulation and computerization, nothing else.
That will be enough. Anything that will be enough.
But if
Now-
Lord
now-
permits one, I'm sorry. Sorry. So, my lord, only one thing.
Yes.
But so far as my lord, Tripura High Court judgment is concerned, my lord, it was affirmed by the Supreme Court. My lord, I'm just giving the citation. That is, my lord, 2020, volume 8 SCC, my lord, page 67. That is Ajoy Debbarma and others versus State of 2020, volume 8 SCC, page 67.
Yes, thank you. Yes, Mr. Gupta. Anything
My lord,
more?
in an appeal where a judgment is assailed, my lord, the only duty for the person, my lord, who has supports the judgment is to place his case on the basis of the considerations which weighed with the mind of the judge. My lord, all new things are being brought in here, my lord, which were not considered at all by the court.
So this third party is only for tabulation purpose.
Only for computerization and which tabulation and computerization.
Lord, on this third party, I just wanted to add one sentence.
Yes.
Lord,
Ashu.
Mr. Tiwari has handed up, Lord, a copy of the deposition today to your lordships. These are depositions, Lord, of the selectors, the persons who had taken the interview. Your lordships will find they have all said that they were appointed by the board. So, Lord, question of third party is an invention which may have come, Lord, in course of art.
My lord, just for clarification, the seat which has been handed over by Mr. Tiwari, this is district wise, not centralized. One district different. But the learned judge has committed an error in law in the table given whole of West Bengal, not district wise. District wise marks, district wise is different.
District wise
And
list not
second,
published in.
second, so reservation, etc., all have been decided by Justice Hiranmaya Bhattacharya. All have been decided. In Justice Hiranmaya Bhattacharya, Justice Origin
Parties. Thank you for the assistance. Taking up to
just one sentence, ballot. Just one sentence. So just one sentence. Let me finish. Two sentences. One is, Milord, leave. Our leave applications are there. Second is, Milord, your lordships will be considered since stay applications with balance of convenience.
Will. Yes, Mr. Shamim.
Today morning, my lord, it was granted.
Yes.
I want to add two things, sir, nothing else.
Possibly he has no appeal.
Yes.
Already had the government. One thing is that, my lord, I always quote the.
Who is he? Who is he? He is not a party now here. Who is he? But who is he? He has lost before Justice Banerjee, Justice Hiranmaya Bhattacharya. Now he is there.
Yes.
Right to education would position.
But he's
Section 23.
He has not. No proceeding.
This practice was available in book 67.
It is
This
one.
notification, my lord, as per
Kumar.
this notification, no untrained teacher can't be appointed after 31st March 2016. The notification
Good.
posted in the month of September. Section 20, can you take the section 23 first, my lord, of Right to Education Act?
But we have not placed the orders. Justice Kannan has passed judgment.
Yes, so afraid of. I am
Not afraid.
Tell us about the notification.
You are a busybody.
Tell us
It's not that you are a busybody.
what,
the provision of that.
what is the provision of law? Tell us and finish.
Yes, ma'am. Kindly section 23.
Evening has started.
Final again says, in 2019, there was a relaxation.
Yes.
No. Up to 31st March 2016, with state of West Bengal got relaxation. What's the amendment says? Kindly take section 20 subsection. The second proviso.
Mr. Shamim, make your point and we will see the amendment.
Yes, my lord. My point is that
Don't read the amendment, make your point and we will read the amendment.
2019, the teacher whosoever appointed before 31st March 2016.
No.
But there only there was
No.
relaxation.
No.
After
Yes.
31st March
Before-
2016, there are no such relaxation.
Very
That's my point. And my lord, the state of
Just a minute.
paper is able to show there is piece of paper after 31st March 2016, there is no such relaxation.
কত বললেন নাম্বারটা?
হ্যাঁ, this is Justice Kannan order. না, বলে দিই।
Reserved for orders on 19th at 1 PM.
ওগুলো কি হবে গো?
এগুলো সব